way should be starting up in about 3 seconds now, and then I look forward to saying hello to some of the towel friends over on the YouTube. And of course, it's easier to read the comments and read the chat and engage with your questions over on that platform, just due to the way in which the back end works. The comments don't fall off the screen as quickly, etc., etc. My name's GrantSmithEllis. We're on day 4 of jury impanelment of the Kierney and Reed trial. As far as I understand, we are somewhere around 8 jurors out of 16 that will be selected sometime by next week, maybe the week after. Maybe more than 16 jurors, 12 jurors, plus however many alternates the court ends up choosing to select. And let me just make sure. Oh, the YouTube is indeed going. Hello, Maui Swift. Hello, Karen. Hello, Bina. Hello, D. Nice. Hello, Julia T. It's so wonderful to see you all. We are going to read Karen's ill-fated appeal to the Supreme Court of the United States. We're going to learn a little bit about why this document, thank God, is limited to 25 pages compared to some of the longer documents we've had to read in the past. And then while we're reviewing it, we're going to talk about why this petition for certiorari, 1, will not stall or do anything to the state court trial. And then 2, this petition for certiorari is not an automatic right of appeal for Karen. And remember, Karen's reviewing her first mistrial at this point. And not only that, Karen lost at the federal district court in Boston. Karen pursuant to a ruling by Judge Dennis V. Saylor IV. That was in March. Karen lost at the U.S. First Circuit Court of Appeals, also in March. Karen lost a request to stay her federal state trial at the federal district court. Karen lost a stay request at the First Circuit Court of Appeals. And if you've watched these streams before, you know we have read both opinions from Judge Saylor and then the First Circuit. Both extensive opinions. I think Judge Saylor's opinion is what I would call a 29-page learned historical treatise on the enumeration of precedent related to the inviolability of jury deliberations and why Karen cannot challenge her mistrial or get any of the counts dropped therefrom due to a number of cases that go back to 1824, but in Massachusetts they go back to 1831 via Lawrence v. Stearns, which requires that a jury verdict be read in open court and affirmed by all jurors, and the jury agreements among jurors are not verdicts. And then that, of course, gets interpolated via a case called Tanner v. U.S. in 85 or so, which then talks about how even allegations of jurors using drugs is not enough to pierce the inviolability of jury deliberations. Then you got Bluford v. Arkansas from 2011, which talks about how even a jury four-person standing up in open court and explaining that the jury had provisional discussions about acquittal on some counts is not enough if those jurors go back to deliberate, because any of such agreement was not final. Now, of course, Chief Justice Roberts wrote the majority in Bluford, and that's going to end from 2011, and that's going to end up becoming really important, folks, because you need 4 judges to get permission to go to the Supreme Court of the United States under a petition for a writ of certiorari, and based on the current breakdown of the court, so Chief Justice Roberts, Justice Coney Barrett, Justice Kavanaugh, Justice Gorsuch, Justice Alito, Justice Thomas, none of those 2 are going to appeal to vote with the 3 liberals, which means none of those, no one of them are going to appeal to vote with the 3 liberals. The only chance to get the case heard, you need 4 votes, and then to actually win, you need 5. But I don't even think Karen will be able to get the 4 votes necessary to get this heard by the Supreme Court. No chance, actually, because the dissents in Bluford, which was basically Karen's argument for this appeal, there were only 3 of them. They were all liberals. There's only 3 liberals now. Justice Ketanji Brown Jackson, Justice Ketanji Jackson Brown, Justice Kagan, and Justice Sotomayor. Now, yes, it was Justice Sotomayor's dissent in Bluford that is going to catch, like, this could catch Justice Sotomayor's eye, but there's no way that Justice Sotomayor is going to peel off the Chief Justice who wrote the majority opinion in Bluford that really sunk Karen's hope at the Federal District Court and then the First Circuit Court of Appeals. And then there's no chance, if you can't peel off the Chief Justice, you're not going to peel off Justice Coney Barrett, who definitely ebbs and flows with the Chief Justice. And then you're not going to peel off Gorsuch or Kavanaugh in an opinion that the Chief Justice just wrote in 2011, and all the conservatives will stick on that. So, all of that's to say, Grant, why are we reading this? Well, because we have read both of the lower court decisions, and since Karen has filed a petition for a writ of certiorari, which does not entitle Karen to review by the Supreme Court, and which will not delay her state court trial, we should, at least for the full historical record, read Marty Weinberg's attempt to have Judge Saylor's from the District Court's opinion reviewed, and then the First Circuit Court of Appeals opinion reviewed. This is never going to be taken up, but it is important to understand what Karen has filed, why you will see a headline saying Kierney and Reed appeals to the Supreme Court, but why, unlike other lower courts, this doesn't mean anything in terms of Karen getting any hearings or being heard or anything like that. It is just a pro forma petition for writ of certiorari. There's 8,000 or so filed a year, less than 1%, 80 or so are ever heard by that vote of 4 justices. So that's the context here, and then we're going to actually read the opinion. Now, I hope that explication of the federal appellate process was helpful to all you wonderful Towel friends who have been so kind to join over on the X and then also on the YouTube. If you are over on the YouTube, I do my best to try to read and engage with all of your comments, and I'm going to do that today as well. If you'd like to be so kind to leave a like or subscribe to the stream, apparently it's exceptionally helpful if you do that while watching the video. I see murder by my maestro out of the corner of my little eye. I spy with my little eye. But yes, it's apparently extremely helpful to do that. So if you would be so kind, Towel would appreciate it. And Towel doesn't really understand why engaging with the YouTube video while it's playing helps the channel, but apparently it does. And so as Towel learns these things, you too can learn these things. And if we can all help the Towel universe and its fabric, its constituent fabric expand, then I think that's wonderful. I sometimes wonder if Towels are like a tesseract. You're only seeing my imprint on this universe because the towel folds and the constituent fabric thereof is so complex and manifold, no pun intended, such as to render Towel's impression within the 3D human universe but a shadow. Anyway, that's getting a little aside from the Supreme Court appeal. Sorry, but tesseracts are very interesting. All right, let's see. I want to read back some comments here. I can't believe this petition. Yeah, it's a very ill-fated petition. Yeah, there were not a lot of people today at the Kierney Reed supporters. The buffer zone issues, if you've been following these streams, have been quite intense. There's actually a hearing in federal court tomorrow where Kierney Reed's supporters, via a lawyer named Mark Randazza, they're going to try to challenge that buffer zone, and it is not going to work. Karen's supporters do have a hearing. No coverage. You have to go in person. But Karen's supporters are throwing everything at the wall. There's a very different atmosphere around the Kierney Reed trial this time around, and I guess Towel was on the ground yesterday, and we can talk a little bit about that. Let's see. I don't know if I did a stream yesterday when I came home. I was actually quite tired, so I don't think we've seen each other since yesterday morning. Since, what is it, Thursday now? So I don't think we've seen each other since Wednesday morning. So I can tell you a little bit about Towel's adventures down to the Kierney Reed trial and the atmosphere, and how I had a very interesting talk with a state trooper who was like, Grant, we are outside and you still smell like weed. And I was like, Trooper, I have a medical condition. It helps me eat. And he was like, that's okay. We understand. We can accept that. And then part of the exchange got caught on John DePetro's live stream from Wednesday, so maybe we'll take a look at that. But I can tell you a little bit of that, a little bit about that as well. So this will not affect the trial going ahead. The Supreme Court appeal, no chance, Maui Swift. Snowball's chance in hell of the SCOTUS hearing Karen's case, agreed, Julia T. Hello, everyone. Good to see you, Macy. Dixie Doodle, so good to see you. And welcome to the Towel Fold. You are a super towel. Trevor McIntyre, oh goodness, they petitioned for a writ of certiorari to SCOTUS. Truly gluttons. Yes, they're gluttons for punishment. And you know, all this is going to lead to is just in the footnotes now of the SJC and federal court, the SJC and the federal court opinion, the district court opinion, and the First Circuit appeal opinion. It's just going to have cert denied at the end. And really, this is all of these courts just affirming Judge Cannoni's ruling to declare a mistrial and then deny Reed's motion to dismiss 2 counts of the indictment after the trial ended. It's all these courts just saying Judge Cannoni is a great jurist over and over and over again. So there you go. Pilgrim Shadow, it's so good to see you. Good afternoon. I hope you're doing well on this Thursday. No, Jew Drops, no delay at all. There's no absolute right to a SCOTUS hearing. She's exhausted all of her automatic appeals, says Trevor McIntyre. That's exactly correct. She's fomented so much crap around this case, it's hard to imagine that they would take it. It's not just that. It's that they just won't take it. Grant, I love your work, and can you pretty please be nice to Kate? Put feelings aside. It has nothing to do with feelings. If you've ever read anything about my work about the Cannabis Control Commission or other cases or whatever, it's about transparency and integrity and applying the same moral standards, asymptotic though they may be in the context of human perfectibility. The Greeks might like the word eudaimonia, and the Latin might be summum bonum. Asymptotic as though that relationship with human moral perfectibility may be, it is incredibly important that the president's wife be beyond reproach, as the secretary from the West Wing put it. But it's also incredibly important that all of us are held to similar moral standards, and we hold each other to similar moral standards. Choosing to say that because you like someone or want to deify them or may not know the full context of all of their behavior and therefore people should look the other way as to that behavior is how very nefarious circles, insidious circles of behavior manifest themselves in our democracy. And it can occur on something as small as the local level with high school level bullshit. It can occur on as high stakes levels as within the court and judicial process. And yes, it can occur too within the political realm and the behind the scenes machinations that facilitate the ebb and flow of all these various interpersonal factions that operate in these different spheres. So don't tell me, I'm sorry, Christine, I have a lot of respect for you, I think you're wonderful, but don't tell me that I should not ask questions about what is going on with some of these things with Kate Peter, that I shouldn't ask questions about why text messages from just Kate Peter and Brian Tully were deleted from Lindsay Gattani's cell phone extraction before Brian Tully personally handed over a 15-year copy of that extraction to Aidan Kierney's lawyer right before the first Kierney and Reed trial started in a way that created a very convenient public distraction for Jen McCabe. Okay, don't tell me I can't ask questions about that, and don't tell me that I can't ask questions about Kate Peter's general behavior in the orbit about this of this case, or what is going on with this strange website that has been set up, and whether there's any certificate of solicitation or there's any corporate registration or anything related to that. I think that's incredibly important. And foundationally, it's not about Kate as a person. It's about the political dynamics in which she operates and the accountability and transparency and integrity that is expected of those processes, which must be beyond reproach. I don't care the tactics that Aidan Kierney deployed or weaponized. And actually, I don't know if it's pathological demand avoidance or otherwise, but it's not a good idea to say, Grant, I wish you would do X, Y, and Z, because that is probably a way to induce the Streisand effect, whereupon I will then start saying to you things like, here's why I am saying this specific thing about this specific person and why it raises serious concerns. If I want to ask questions about the PI firm that Kate Peter used to work for, run by a guy named Marty Kraft, and whether that firm is in the orbit of some of these witnesses or whatever in the Reed trial or the Kierney trial, that's my prerogative. If I want to ask about where that leaked email came from Karen Reed's cell phone, where Karen was trashing David Yannetti to Alan Jackson, that's my prerogative. Okay, holding both sides to the same standards is incredibly important. And this wouldn't have even came up, by the way, but for the fact that I happened to read that comment on the screen. So just be cautious, because if you ask me questions and give me the opportunity to weigh in on why I have been saying certain things, whether it be about Kate Peter or otherwise, I will be happy to explicate for you the context. And that is not even to go into the interpersonal dynamics related to Kate Peter and how after I had told this story before about how after one time I said in front of Kate Peter to Lindsay Gattani that I thought people were trying to keep Lindsay from the media to protect Brian Tully. Kate Peter then did a very emotionally predatory move that I didn't figure out until months later. So, listen, I get it. People think that Kate Peter is useful, but in my opinion, Kate Peter used to work for Aidan Kierney for a reason, and that's because they both deploy similar tactics. It's just people want to give Kate a little bit more plausible deniability because they like that she supports their opinion on this case or otherwise. But, it's really you who I should be saying, can you please hold your self to a higher standard and not enable people like Kate Peter for the sake of political convenience or social convenience or deification? You know what I mean? Just hold people to the same standards. Don't make, whether you're on the Justice for John O'Keefe side or the Free Kierney and Reed side, don't make fun of people's looks. Don't use mental illness as an insult. You can agree, you can disagree without being disagreeable. And fundamentally, the reason why there's this cycle of toxic vacuity surrounding this case is because of the toxic cult of personality that surrounds Kate Peter and Aidan Kierney. And people don't want to talk about it because it's the dark underbelly of this otherwise already sad and tormented tale, which has disgraced the legacy of John O'Keefe, who clearly was a very noble and honorable man. And this whole circus has just disgraced the legacy of that human being. And whether it's Kate Peter being brought in to counter Aidan Kierney's tactics, or Karen Reed bringing in Aidan Kierney to complement her relationship with the federal government, whatever it is, the political dynamics of it aside, Michael Morrissey and the DOJ in Boston under Levy and Rollins having a proxy war with Dustin Chow thrown in there for good measure, whatever it may be that justified it, we have to talk about it. To suppress it is to shrink from duty. To ignore it is to forsake the voices of the vulnerable and the exploited who have been taken advantage of throughout this process. And that's not even to mention whether or not this whole thing, in some sense, was preying on Aidan Kierney's propensity to make terrible decisions and do stupid things in order to corner Kierney into eventually doing something that would enable him to be presented with the opportunity to testify against Karen. It wasn't a setup. It was that they were waiting for Kierney to do what he naturally does, because they clearly profiled him via Kate Peter. And therein, I think, where this is all leading up to Kierney getting some kind of immunity or plea deal in order to cooperate against Karen Reed, which was the whole point. And I think Kate Peter's behind the scenes there, wheeling and dealing, trying to make sure all the chips fall such that the narrative does not actually expose what actually happened here. So no, I will not do such a thing. And thank you for allowing me to rant. See, that wouldn't have even happened. I just wanted to read Karen Reed's federal Supreme Court appeal. Even if allowed, TB should not be allowed to be in there reporting on anything. He has to push the boundaries and needs to be watched like a hawk. Yes, this is live. Good to see you all. Hi, Murder by Maestro. Well, hello. Good to see you all. I have a devil's advocate question, says the Sunken Grave. Did the investigators know John had been hit by a car when the taillight pieces were buried beneath the snow? Well, I think you have to remember, Karen Reed didn't get arrested until so the incident happened on the morning of January 29, 2022, when Karen is alleged to have struck John O'Keefe with her car. Karen didn't get arrested until I think the warrant was February 1st. She appeared in Stoughton District Court on the initial charges on February 2nd. Karen's car didn't even get collected because, remember, Karen tactically made sure the car wasn't at the scene. Karen got picked up by Kerry Roberts and Jen McCabe, or she met them and then dropped the Lexus off at John's house and then had Kerry drive Karen back to the scene. So there was no murder weapon at the scene. And then later in the morning, before the snow was still falling, the blizzard was going on, as that's happening, Karen's parents drive back to John's house after Karen gets released from the hospital, and they take the car back to Dighton. So I think as the investigators started to process the scene, that's when eventually the folks realized what had happened. But of course, the blizzard was raging all morning, and I don't know when in the afternoon it ended. All right. I have to breathe because I got into a little bit of a rant there. This was in Roberta's chat. Kate would not address the issue at the time. Her exact words: "Oh, she called you an incel." She only addressed it in a video. What was it? Murder by Maestro. Gran had very clear questions for a long time involving the funds she kept having access to. Kate's response was to insult me. Oh, I guess. That's terrible. You shouldn't do that, Kate. That's when I knew what was up. Yeah, so let me just explain that. Last summer, and I've explained this on the stream before, there were 2 courthouse protests organized not by Kate Peter, but by other folks, that Kate Peter was invited to at the last minute. On 2 separate occasions in different Facebook groups, Kate Peter, during those protests, without telling anyone who was there, went online and started raising money for lunches and sign-making material. Well, the people who actually got the sign-making material didn't get paid back. Not that those people wanted to be paid back, but they didn't know funds were being raised in their name. And then, to make it even worse, which I thought was absolutely abhorrent on the part of Miss Peter, there were multiple people there, multiple witnesses, who said that people just paid for their own lunch and were happy to do so. And then after the fact, Kate had people who must be close to her going around telling people, oh, yeah, we paid for our lunch, only for other witnesses to be like, I watched those very people pay for their own lunch. Kate didn't pay for it, as they initially then went on to claim. So, that part in and of itself was very concerning. It raised red flags. I was immediately concerned. That was very early in this process. And that was after the Tully and Kate messages and the strange situation with the leak of Lindsay's phone. Kate's really tied in. Kate talks to Jen McCabe directly and Brian Tully directly. And I don't think it's appropriate, but she has this whole server where she has all these different witnesses and people connected to the case on it. Though it's extremely inappropriate. I realize that support networks are important, but the way Kate Peters running it is like some fucking, internet operation type thing, like some PI type thing. It's very strange. But then moving on to the second example, that wasn't the only shady thing Kate did with funds. Kate, nobly enough, at first I thought, set up a fundraiser for Lindsay, Lindsay, one of Lindsay's RO or Rule 17 hearings a while back. There were two different fundraisers Kate did, one directly and then one through one of Kate's friends. The first fundraiser, right, it was for $8,000. Kate did some really weird shit with that fundraiser. First, she never would give Lindsay the Give, Send, Go login. And if you go to that Give, Send, Go that Kate put up today, the link is just down. You can't even donate to it anymore. This was way back in 2024 or so. Kate never gave Lindsay the login. Okay, so that's weird as fuck. And then Kate started talking about these Give, Send, Go fees and how $1,500 would be taken out and all this other nonsense. And then this is where it gets even stranger. Just a few days before the hearing, when Lindsay needs the money back in 2024, it was like a Thursday or Friday, and the hearing was next Tuesday or something. Kate starts saying, "Oh, the disbursement's taking a while to come, and I don't know if it's going to come." And all of a sudden, this lawyer from the Midwest, who's like a prosecutor or something, he called me one time and chewed me out, and I was like, "Go fuck yourself, buddy. I know what you did." I told him he was a fact witness. He is a fact witness. Kate goes to this friend of hers in the Midwest who just out of nowhere gives another $8,000, right? Now, how weird is this? So you end up with a $16,000 fundraiser, all of which should have gone to fucking Lindsay, but instead $8,000 went to Kate. We have no idea if Kate ever paid that lawyer back or whatnot. And then $8,000 went to Lindsay's lawyer. Okay, so Kate used that opportunity to raise money for herself, and we have no idea if that lawyer out in the Midwest was ever paid back that extra $8K. Okay, just absolutely ridiculous. And the most outrageous thing is we still to this day do not have receipts of when that original $8K went into Kate Peters' bank account and why that lawyer even had to lend an extra $8K to Kate to begin with. And then that lawyer straight up said to me, "I don't care if Kate ever pays me back." That should have, $16K then should have been for Lindsay. What the fuck is Kate doing getting $8,000 on the back of a fundraiser she was supposed to be doing for Lindsay? So you see what I'm saying? There's some weird shit with Kate Peter, and someone doesn't just work for Aidan Kierney, okay? You have to be like Aidan Kierney to work for fucking Aidan Kierney, whether they have a falling out or not. But yes, Murder by Maestro, you're spot on, my friend. Keep asking your questions. And this was supposed to be about the Supreme Court appeal, but you start asking me questions about Kate Peter, and by God, I'm going to have some things to say in an authentic way, true to this little towel soul, and not from a place of personal spite, but from a place of a desire for moral standards to be upheld universally, and for people not to be fucking sanctimonious. All right, I'm sorry. We're going back. We are going back to the reading the petition for the writ of certiorari. But listen, I promised you all, if you left comments, if you left questions, you don't have to donate, you don't have to send a super chat. I will read your comments and questions. But listen, the peril of that is I am going to directly answer your questions. So if you'd prefer we not discuss something, it's best, instead of saying, "Grant, we should not discuss this," to instead maybe not ask that question. And I'm not saying you should censor yourself. You have a question, you want to ask it. It's not derogatory or discriminatory or sea lioning. Please ask it. But just be aware, if you ask a question, I'm going to talk about it. And if you ask about certain things, in particular that, I will tell you why I feel the way I feel. So just fair warning. Christine, I know you didn't do that on purpose, but I don't mean to take us on a little tangent, but that was, after what I had to say earlier today, I think it was important I went on that little tangent. All right, so listen, we only have to read 25 pages, and what's nice about this Supreme Court appeal is that it's actually formatted in a smaller way, so it isn't fully 25 pages. Now, you might say, why are we reading this petition for writ of certiorari if Kierney and Reed has no chance at all? Well, for a few reasons. One, we want to see Kierney can't bring up any new issues that weren't on the lower court appellate record, but we want to see if Kierney's presenting this in a way to SCOTUS that might catch the eye of that fourth justice we were talking about earlier. Do I think what we're looking for in reading this, is there any presentation of the issues that might get one of the conservative justices to join with the dissent from Bluford to give this case 4 votes to get the petition for cert granted? The answer is no, but I want to actually go through it. All right. Whether a final, so here are the questions presented. Whether a final and unanimous, well, we looked at the header for long enough. Whether a final and unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty of a charged offense constitutes an acquittal precluding retrial under the Double Jeopardy Clause. 2, whether a defendant who produces credible evidence of such a final unanimous, and that is not credible evidence, an anonymous juror saying they agreed to something and didn't record the vote in court. Such a final and unanimous unannounced acquittal is entitled to a post-trial hearing to substantiate the fact of such acquittal. Nope, this is going to fail on its face, because if you say that in your opening and then the justices of the Supreme Court go in and realize that it was at best a reported hearsay agreement among jurors that was not confirmed in open court, the judge is going to say that is not credible evidence of a final, unanimous, and unannounced acquittal. And furthermore, you can't have an unannounced acquittal under Bluford. Oh, dear God. Marty Weinberg. Is it? I don't know what the Supreme Court is going to think of this, but when they actually get to the factual record, by the way, it's like 125 pages with all the appendices. However, we only have to read pages 1 to 25. Oh, look at that! What pops up? Bluford, like 7 times, because if Marty Weinberg can't argue for overturning Bluford, then this is never going anywhere. So you better have some really good arguments for why Bluford should be overturned, which was the case about the juror standing up mid-deliberation and announcing a verdict, but not actually recording a verdict, because the jurors then went back to deliberate further. All right, so you can see what's really cool about a Supreme Court brief, and much like any appellate brief, you get this nice table of authorities that shows us what pages all the cases are on. It's meant to be easy for a Supreme Court justice to read. Then you get to see if there's any constitutional provisions, what pages they're cited on. Michael Pabian, who's the lawyer on this with Weinberg, definitely spent a lot of time indexing this, because you must be perfect. And then 2241 is the pretrial detention statute. 2254, I think, is the federal detention statute. They must be comparing it. And then 46, I forget what that one is. And then some references to the rules of evidence. So this part's actually cool. I haven't read a petition for a writ of certiorari in a while. Oh, and it's such a new case that the actual formal citation is not actually written. And if you're just joining and wondering, Grant, what are we doing? Well, Kierney and Reed has filed an appeal to the Supreme Court of the United States, which she's not entitled to automatically get. However, because Reed had to file a 25-page petition for a writ of certiorari, we have the document that the Supreme Court is going to review. Although, procedurally, this will not result in a delay of the state trial for a number of reasons already mentioned. And furthermore, really what this is about is Kierney trying to make some headlines, but it won't end up really making good headlines for Kierney, because most of the stories are going to be about how the lower court opinions at both the Boston Federal Court and the First Circuit Court of Appeals, the Boston Federal District Court and the First Circuit Court of Appeals, were so bad for Kierney. And so anyway, Weinberg begins a no official citation of the opinion of the First Circuit Court of Appeals is yet available, but the opinion may be found at 2025 WL 926 and 289. The opinion of the District Court is unpublished, but is available at 2025. The opinion of the Massachusetts Supreme Judicial Court is reported at 495 Mass 312 250. The Massachusetts Superior Court order denying Reed's motion to dismiss is not reported, but we have it. The statement of jurisdiction. The judgment of the First Circuit was entered on March 27th, so just last week. This court has jurisdiction to review judgment of the First Circuit on a writ of certiorari. Well, yeah, the Supreme Court can do that. The constitutional provisions involved. The double jeopardy clause of the Fifth Amendment provides, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Introduction. This case is I knew it. I knew it. He had to sell it. He had to sell. I could see this coming from a mile away. I was like, how are you going to sell this, Weinberg? This case is an ideal vehicle to resolve an issue of fundamental constitutional importance argued to the court but not decided in Bluford. That your argument is that this issue wasn't decided in Bluford? How are you going to frame this? This is going to take a real stretch of the legal imagination. All right, let's check our chat for a little bit. I apologize, by the way. As much as Towell has his feelings and his emotional predispositions and his passion, I feel like a central ethos of this stream has been unconditional love, with exceptions only for those who are truly depraved of soul in a way that's irredeemable. And I think it's important that even when I get frustrated, and even though, as you can probably sense, there are some other things going on in Towell's life. One of my family members is unfortunately very sick, so that has been on my mind a lot recently, and Towell has been praying a lot, and I am trying very hard not to let my overall sort of feelings impact my coverage of this case and my view of the different issues involved. But please give Towell a little bit of grace, especially if you ask questions that might bring up topics that Towell is passionate about. And then also, please, if you'd be so kind as we go through reading this document, do keep Towell's family member in mind. I think your prayers, or if you're atheistic or whatever, your thoughts would be much appreciated. And I think that kind of brings us back by a nice commodious vicus of recirculation to the more compassionate ethos that I'd like to encourage here. So thank you for that. All right, so a lot of good discussion going on, but nothing necessarily about this ruling. So let's go back, or this petition. So let's go back to the petition. This case is an ideal vehicle to resolve. Oh, we read that. The petitioner in Bluford argued that where the jury actually resolved some elements of a charged offense in the defendant's favor, no formal verdict need be returned for that decision to constitute an acquittal, prohibiting reprosecution under the double jeopardy clause. So that was the juror who stood up, the jury foreperson who stood up mid-trial or mid-deliberation, said the jury had acquitted on some counts in the Bluford case, only for the jurors to go back to deliberate more and then come back with a guilty verdict. And then the petitioner, the person convicted in that case, appealed, and the Supreme Court rejected that person's argument, saying that the jury, when the juror foreperson, even announcing in open court that they had acquitted on some charges, which did not happen in the Reed case at all, even that isn't enough to prevent a mistrial, because the jury can go back to deliberate, and just because they said something in open court, the foreperson, doesn't mean that's a recorded verdict. So that's the standard Weinberg's up against here. It is not easy. The divided court, it was 6-3. The divided court did not decide that question because in Bluford, the majority concluded that the foreperson's mid-deliberation report regarding the jury's votes, this is what I was just saying, lacked the finality necessary to amount to an acquittal, quite apart from any requirement that a formal verdict be returned or judgment entered. Okay, so what do you think this case presents that was not answered in Bluford or was not presented in Bluford, Mr. Weinberg? Because right now, I mean, this better get very creative. The instant case squarely presents the question that Bluford did not decide. Here, beginning the day after petitioner's first trial ended in a mistrial, 4 jurors contacted trial counsel to inform them that the jury had reached a final and unanimous but unannounced conclusion that petitioner Kierney and Reed is not guilty of murder in the second degree and leaving the scene of the collision. 2 of the 3 charges pending against her. Statement by a 5th juror relayed indirectly to counsel. So none of this was in open court, by the way, which was Bluford. If you had no jurors who said this at all in open court, how are you going to compare this? How are you going to say this issue wasn't decided in Bluford? It's necessarily decided in Bluford if the juror went so far as to announce that they had acquitted, although that wasn't the final decision, in the middle of deliberations. A statement by a 5th juror relayed indirectly to counsel via 2 intermediaries indicated that the jury had agreed that Reed is not guilty of the murder charge. In addition, one of the jurors made a similar representation to the prosecutor. The jury's not guilty verdicts were not announced because the trial court, believing but not confirming that the impasse reported in a series of 3 juror notes applied to all rather than only some counts, it said charges in the notes. Never inquired regarding the scope of the deadlock, which the judge does not need to do. And the jurors failed to volunteer to the trial court that their impasse was limited to one of the 3 counts rather than all. It said charges. The note said charges. They're going to read the note. You have to include the note in the document. They're going to see the note says charges. Oh, this is a terribly weak argument. The First Circuit held, even if we assume that the jury unanimously voted in private that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view. Okay, so that was the point in Bluford, okay? In Bluford, the jury didn't act on the view when they, mid-deliberations, had the 4-person was like, oh, we acquitted on some charges. That wasn't acting on the view. So, of course, Karen, with these jurors coming anonymously and through intermediaries up after the trial, of course the First Circuit held that the jury did not act on that view. So this is what Weinberg's setting up. This is what he's up against. He must convince the Supreme Court that somehow the jury here acted on their view more so than in Bluford. And none of the jurors in Karen's first trial, which is what Karen's trying to review now hopelessly, said anything in open court at all, ever. Except for the 3 notes delivered by the 4-person saying the jury was hopelessly deadlocked on the charges. All right. Let's see. That holding runs, okay, why does it run? So this is something actually important. If you want to convince SCOTUS to hear something, you have to argue that the First Circuit applied a SCOTUS decision or applied precedent that SCOTUS had decided in a way that was incorrect. So let's see what Weinberg argues here. That holding runs contrary to this court's repeated emphasis over more than a century that what constitutes an acquittal for purposes of the double jeopardy clause is controlled by substance, not form. The First Circuit's related denial of a post-verdict voir dire further prevented Reed from proving from all 12 jurors, what many of them without any contradiction from the other jurors were representing, that they had reached to who and when. After the trial in these unanimous declarations, where they all didn't even agree on what these different declarations on what the various votes were on the 9-3 or 10-2 or 8-4 guilty verdict on count 2, which for Alan Jackson's reference, count 2 of the indictment against Reed is OUI manslaughter. That has 2 lesser included offenses, Mr. Jackson, manslaughter and homicide, OUI, motor vehicle homicide while OUI. During an interview with Ted Daniel, at one point, Alan Jackson either got both of those charges completely wrong or was trying to mislead the public about them, and it made Little Towel very, very angry. All right. So, you can see Reed's argument here is very similar to her First Circuit opinion, but Marty Weinberg is trying desperately to lean on this argument that the substance of the jury's private agreements, which were never announced in public and we don't know the context of whether they're accurate or otherwise, relayed to the defense after the trial, is enough to get an acquittal. Now it's very weak. I thought there would be more here. I thought I thought Marty Weinberg, because what we're seeing is a summary of all of his arguments up front. I thought Marty Weinberg would have a little bit, something a little bit more creative here, but it seems like the Hail Mary is, okay, this is technically not directly addressed in Bluford, because in the Bluford case, the jury foreperson actually stood up in open court. The problem for Weinberg is this is very bad for him the other way. This is a situation that Bluford would contemplate as necessarily unenumerated within its framework, which is if the juror stood up in the Bluford case in open court and announced an acquittal on a charge, and then the jury went back to deliberating and came back guilty, if that initial announcement in open court of acquittal and then a return to deliberation meant the acquittal was not enough to sustain overturning the further guilty verdict, then Karen's jurors, who did not come forward in open court, who wrote these letters after the mistrial had been declared, etc., can't have possibly gone beyond what had happened in Bluford to present a novel question of law. And in turn, this is just answered by Bluford, and therefore the Supreme Court's going to reject this. So I had to think about Marty Weinberg's logic as to what he was trying to get the Supreme Court to do. But now that I see it, I can see this argument. There's nothing new here, and there isn't going to be enough to overturn it. But yes, for those of you just tuning in, I appreciate you joining Little Towel today. We're reading through Kierney and Reed's recently filed, just today, petition with the Supreme Court of the United States, which is not an automatic right of appeal, seeking to have her losses at the Federal District Court and the Federal First Circuit Court of Appeals related to her first mistrial invalidated. Now, Karen is not going to be able to use this to delay her state-level trial. It's more of an academic opportunity to present to the Supreme Court novel questions of law that Karen thought may have come up in the context of her lower court pleadings. Now, Karen got absolutely just brushed aside. There is no actual merit to her federal appeal, but we're reading this because, first of all, very rarely do you see in this kind of case a petition for a writ of certiorari to the Supreme Court, but also because Karen's case, once this petition is denied, is also itself going to become precedent and make it even harder. Well, not really, because Karen didn't have a very good argument, but this case will be cited when defendants in the future try to make similar arguments about penetrating the veil of jury deliberations based on after-the-fact reports by jurors of, oh, we said this during deliberations, or we had this compromise verdict until it fell apart. That's really what this case is going to be. We are going to see Commonwealth v. Reed cited for this very reason. So it does have some value. It does have some staying power in the sense that reading this decision is all we're really going to, this petition is all we're going to see, because the Supreme Court, when they deny cert, don't actually issue a decision. So reading this and then thinking about eventually when the Supreme Court denies the petition for cert, what Karen argued and why the Supreme Court denied it helps us understand the evolution of this precedent. Okay, so yes, nice to see so many of you. I appreciate you all tuning in. I as I mentioned a little bit earlier, Towel, I wouldn't say Towel is a little, I wouldn't say sad, but Towel definitely feels the weight of his own humanity, as I think we all do from time to time when confronted with the temporal nature of life. And so, I don't know, as I take a break here to light this joint, as someone kindly reminded me to do in the comments, I think Towel's advice for you all tonight, in his reflective, pensive mood, reading a Supreme Court petition for certiorari from Kierney and Reed, is that you should appreciate the people around you and not exploit them, and not take them for granted, and not view them as means to an end, but instead as precious, wonderful human lives that grace our own cycles on this earth like chapters in a good book. And some people are in our lives for a very, very long time, and some people come and go, and some people come and never leave. And I think it's easy for us in the cycle of day-to-day, even this case is a good example, the chaos of this case, the flurry of documents, the number of motions, the rulings. I think it's easy for not only for us to forget about the humanity of the people involved, John's family, the witnesses, the people who have been tormented, but also the defense and Karen and her family and her supporters. It's very easy to dehumanize these different people, but it's also easy to become dehumanized in our own lives and to forget the value of people around us and how important those people are to our sense of self and our well-being and our ebb and flow. And so I hope you do that. I hope you take this opportunity with Towel calming down from his rant earlier, which is how I feel. But I do also think that among this sort of otherwise cacophonous chaos, that reminder from time to time of our own humanity, however it comes into our life, whether it be through Towel friends in the chat or through our own self-reflection, is incredibly important. But yes, I'm reading through some of your comments, and Rehab says, fighting the Lord's fight, you're the best. Well, thank you. That means a lot to me. I feel like I let myself down a little bit earlier, not because of the content of my my sort of diatribe there, which I thought was very important, but more because I think the ethos and the compassion that I want to embody may not necessarily be appropriately attuned in light of the heavy weight of the emotional situation that Towel's been thinking about with his family member. So Towel will keep that on his mind. My dear God, it fell. Oh yeah, when Richie fell over the fence. Lackadaisical says, can't believe Kevin Stiller still has her on his stream. Yeah, I agree. I was shocked to find out that the video of Jackson and Karen was real. Yeah, I mean, there's also pictures of Jackson and Karen at restaurants that are very real. As real as a dry hump gets. Oh, goodness, Murder by Maestro. We're all right to be critical of it, but yep, real. I looked it up. I was told it was fake. Yeah, no, it's definitely real, and there's definitely a follow-up picture, too, of them very close, their legs touching at another restaurant a few months later that I posted. Sorry. Okay. Part of what we try to do is not be derogatory or discriminatory, and we can be nice. I realize I have to set the tone, but we can be nice to other creators. Melanie, no, I don't know what a cupcake is. Does Melanie Little have cupcakes on her stream or something? I don't get the reference. I just yeah, okay. It's such a shame that John O'Keefe was taken from his double orphan niece and nephew. Yes, that was a very sad situation, and I think Karen viewed those kids as a source of tension in the relationship, and I think Karen resented John for caring about those children so much. Let's see. Everyone has their own opinions and views. Yep, I agree, Murder by Maestro. Just getting caught up on comments before we dive into the next section of Kierney and Reed's Supreme Court petition. Let's see. Alright. I don't know who that is, but they have a very inappropriate username. Sorry to hear that, Grant. I'll keep you and your family in my prayers. Oh, thank you, my King of Kings. Hi, I've been trying to find you all morning. This is making everyone sick. The Supreme Court appeal. Oh, I pray for you and your family, Grant. Thank you, Drew Drops. Let's see. Oh, apparently there has been some issues with finding the channel on search. That's okay. We'll continue to look for it. Dewdrop says, if you'd be kind, hit the like button. Apparently there's a lot of you watching on the YouTube, and I can see that because I'm reading through all of your chats to get caught up. Thinking of you, Grant. It's so hard to deal with family illnesses. Hugs. Yes, hugs to you all as well. Just saw they're up to 10 jurors now. 5 men and five women. Thank you for the update, Macy. We're reading through a Supreme Court petition for certiorari, so I appreciate that update. Let's see. Yeah, let's see if Weinberg drops the S on the charges, quote from the jury. Hello, Angela Wittick. So good to see you. Good to see. Yeah, I'm not sure how I feel about the Grant's Pants account. We might. I don't think we're gonna. I don't know how long that account's gonna stay around. Jury for a person should have requested. Someone said. Let's see. Yeah, I told you it. I could tell. I could tell. Very, very early on that person was trying. Let's see. Karen would be out of jail by now if she had pleaded out. Yep. And Christina says, as soon as I wake up at 5:30 in the morning, I'm looking for you, Grant. Let's see. Rest in peace, John O'Keefe. No, it's okay. Someone was. I'm sorry if I'm derogatory regarding Karen. It's just generally towards other people in chat. I think it's good to just try to be amiable, and I'll try to uphold that standard. Karen expected the same amount of attention as 2 orphan children. Yeah, my king of kings. And I think if you look at the date that Karen tried to start the affair with Higgins, January 12th, 2022, that's a very telling date. It's a date that those children would have been getting a lot of attention from John. It was the anniversary of their father's passing. So something to keep in mind. Karen hated that John put the children before her. I agree with you. And I agree with Grant, no more BS from trolls. Yeah, no, so exactly. There's a difference between having a difference of opinion and just sort of being here to troll, and that's something that's obviously very easy to catch. So, and it's kind of a blue wall here. So, hello, King Towel. I'm not a king. I'm just a towel. Do you live near the courthouse? I live up in Boston. I go to school up in Boston. I'm in school till the end of May, actually. So but yeah, I'd say like 20, 30 miles. Absolutely, Grant. You're so good at what you do. Oh, I just try to help. But let's get back to the petition, speaking of that. Let's see. Reed's first trial ends in a mistrial. On June 9, 2022, Reed was charged in 3 separate indictments with second-degree murder in violation of MGL 265-1, manslaughter while operating under the influence of alcohol in violation of MGL 265, 13.5. And leaving the scene of a collision resulting in death in violation of MGL 9024-2A-2. A jury trial began on April 16, 2024 in Massachusetts in Norfolk Superior Court. Trial court declared a mistrial on July 1st, 2024. On June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, you should continue deliberating until you have reached the final verdict on each charge. COA joint, that's just the joint appendix. It also noted that count 2 maintained lesser included charges of involuntary manslaughter and motor vehicle homicide. See what I meant, Alan Jackson? At least Michael Weinberg knows the lesser included offenses. And motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. Later, in supplemental instructions to the jury, the court again described count 2 as encompassing 3 separate charges. On June 28, 2024, the 4th day of deliberations, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent considerations of all disputed evidence, we have been unable to reach a unanimous verdict. The court sent the jury back to continue deliberations. On July 1st, 2024, the jury presented another note stating, despite our commitment to the duty, yes, Mr. Thomas Jefferson, foreperson, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this omission and the implications it holds. Now, did he just skip over the word charges? Let's see, is murder by maestro going to be right? The court gave a so-called Tui Rodriguez charge and sent the jury back to continue deliberations, which, by the way, the defense wanted. I don't even think Weinberg's going to try to even argue that point, that the defense didn't want the mistrial, which he did try to argue in the lower court. Later that day, the jury sent yet another note, 3 notes. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary element of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Indeed. And I think, if I recall, it might have been cut out from a prior note as well, but the word charges came up twice, whether it was twice in the third note or once in the prior note and twice in the third note. The word charges came up more than once. And it had to do with the jury being deadlocked or coming to a mistrial on the charges. And that ends up key here because that word charges undermines Karen's entire argument about the jury having misunderstood its role and somehow agreed to acquit on 1 and 3. That doesn't make sense if the jury had fundamental differences of agreement on the charges. After reading the note on the record, the court, without any apparent consideration of alternatives, such as asking whether the impasse was to all as opposed to just some counts, and without first inviting counsel to be heard, sua sponte declared a mistrial and dismissed the jury. Yes, that was Judge Cannoni's wonderful statement about how first of all, she doesn't have to ask Reed's counsel if they object. They chose not to object. They wanted a mistrial. And that was that wonderful line from Judge Cannoni saying, defense counsel were no shrieking violets. Sorry, I have to blow my nose. Appreciate your indulgence. Spring is in the air. But yes, as you remember, that was the ruling from Judge Cannoni that not only do I not have to invite Reed's counsel to object, these are the kind of lawyers who would have jumped to object at a mistrial. All right, let me go back to the comments for a second. Hello, folks. If you're just joining, we are reading Kierney and Reed's petition for certiorari to the Supreme Court of the United States. Just came down today. We're about halfway through. No, that's not true. We're getting close to halfway through. It's a quicker read than most documents, because as you might notice, if you're asking why does it look like we're reading a pamphlet from the 1700s, I'm pretty sure these printing rules are from the 17 or 1800s, because there's like 4-inch margins and it's very small font, and you only have 25 pages, and you have to really pick the words you want to use. And that's what we're reading through. So if you've ever wondered what is it like to be a Supreme Court justice, well, you read a lot of these, 8,000 of them a year. Okay, so let me read through back some of the comments. Just want to keep caught up. Oh, Drew Drops, I appreciate you. I appreciate all of you in the chat, and I feel like I let some of you down earlier because although I oftentimes will answer questions in a way that provides extra context and oftentimes comes with passionate speeches about the state of the universe, I would say I think Tal is processing some things today about one of his family members, and that has made Tal a little bit pensive and reflective. So I'm not just going to go off on moral rants because I'm sad and thinking about life. So I'm not going to do that to you all. I could, but I'm not. But yes, thank you, Drew Drops. I appreciate all of your comments and engagement. Good to see you, my cat and I. So good to have you here. So good to have you, Murder by Maestro. We got, my cat and I, we got an appeal to the Supreme Court from Kierney and Reed. It doesn't have major implications in that it won't delay her state trial, but we are reading through the Supreme Court petition from Karen and Marty Weinberg, her lawyer, because it represents the final culmination of a saga where I've read hundreds of pages of federal appellate documents from Kierney and Reed's appeal. She's lost every step of the way, but we have to actually read the Supreme Court petition because that caps off that saga, and eventually the Supreme Court will deny the petition, and then that will be over. But this is the last document that Karen can file in her federal appeal. And then tomorrow, by the way, if you're getting caught up, more juror selection continuing in the Reed trial. We're at 10 jurors. We got to get somewhere close to 16, 18, a little bit more, a little bit less, and that's incredibly important, of course, because the number of jurors selected last time was 16, but a lot of jurors ended up leaving or whatnot. And as a result, one juror, for example, was caught talking about the case in violation of the court order, talking about the case to other jurors in violation of the court order, and things like that. So there might be more than 16 this time. Not all the jurors deliberate at the end of the trial. All the jurors' numbers go into a very old school wooden sort of rotating box that Christina Rex and I found very interesting during the first trial. And it just kind of sits on the windowsill. But then 12 jurors get selected, and the other jurors are alternates. And having a lot of alternates is not a bad thing, and I could see Judge Cannoni. We don't know what the number is going to be, but 18, 20 maybe, I think, is the realm here. 16 would surprise me, but 16 last time, we got 16. Much bigger juror pool this time, though. Don't forget, much bigger juror pool. 1,200 people in this juror pool compared to only 400 for Reed's first trial. Much less pressure to get to sort of get a number of jurors out of that 400. Instead, you get 1,200. So an opportunity for more alternates. My prediction, next Thursday, next Friday, maybe a little bit earlier, we'll have a jury. Too bad the jury deliberation wasn't as articulate as their notes. Yeah, this was a jury that knew what they were doing. They knew how to articulate what they were doing, and I think it's incredibly important for the Supreme Court appeal, as the justices read these jury notes, that they're going to quickly realize that Marty Weinberg has no leg to stand on here, because if this jury was not confused, they knew exactly what they were saying to the judge, and Kierney and Reed's whole appeal is basically based on this premise that the jury was an idiot. Now, this is ironic, of course, because I think there's a leaked message from Karen to Aidan, or an intermediary, Aidan Kierney, or an intermediary to Aidan Kierney, where Karen said she didn't want to put her fate in the hands of, quote, 12 people who were too stupid to get out of jury duty. Now, first of all, that's a very insulting way to think about the civic duty that is jury duty, because some very intelligent people don't try to get out of jury duty. They look at serving as an honor. But the other thing is, you got to imagine Karen is insulting this jury in her mind ahead of the trial, and then turns out they're this really, really smart jury, and then Karen's appeal is based on this idea that they were dumb. So I think there's a little bit of Karen projecting there, and she wanted to call the jury dumb. Let's see. Charges doesn't sound unanimous to me. Exactly, Sunken Guy. That's really the core of why the Supreme Court is just going to laugh at this, in my opinion. Penny Forden says charges plural. I remembered something from elementary school. Oh, Penny Forden, you are well above elementary school if you're interpolating the plural of charges in the context of a Supreme Court petition for a writ of certiorari from Kierney and Reed, which is what we are reading through right now, if you're just getting caught up. And my name's GrantSmithEllis, and I'm a towel. And don't send any donations, by the way, for right now. Pilgrim Shadow convinced me to leave it up, and I did leave it up, but Towel made it to this day, and Towel's doing okay for at least a little bit, and as a result, you all can make some donations to maybe the homeless population, or veterans organizations are really good, or you can do an act of service for someone else in your life if you want to thank Towel for this, or you could like the video or subscribe to the channel. But on the whole, Towel's doing okay. Let's see. We gleaned so many important facts from Grant and from each other that I agree with, and I think this channel is so wonderful. And you all have helped Towel. I wouldn't say this is something I can get over. I have to think about and process the weighty emotional resonance of what I'm going through. But I think you all are helping me talk this through, and it's good to be reminded of how many of you are out there and how many of you appreciate our ability to read court documents together. Of course, I'm not a lawyer. I'm a towel, and none of this is legal advice, and you should get a lawyer if you have questions about the law. You should get a towel if you're mostly interested in proving unconditional love still exists. What happened? Is this a new Hail Mary? Yep, Eva, this is a new Hail Mary to the Supreme Court of the United States, the highest court in the land. And we are reading so we can predict just how badly Karen's going to lose. Now, there won't actually be a ruling on this. The ruling will come in the form of just a one-word denial, petition for certiorari denied. But we're reading it to kind of like a commodious vicus of recirculation, as if we were riding a rowboat through the river Dublin, the river in the middle of Dublin. Finishing up with a nice little bow, the story of Kierney and Reed, $75,000 ill-fated federal appeal. Let's see. Lackadaisical says, Penny, I bet jury deliberations were complete chaos, like the juror Ronnie who wanted his 15 minutes. Does anyone know how often Brian Higgins hung out with those people? Or just that group of friends or that crew? No, I think John and Higgins had known each other for about a year. Higgins was kind of John's friend, and then Higgins eventually met Karen, and then I think Karen tried to use Higgins to torment John as the relationship was ending. Higgins realized, quickly cut it off with Karen because he was telling her he didn't want to hurt his friend John's emotionally or otherwise, but it was really Karen who was upset that the relationship with John O'Keefe was ending, and Karen was trying to use Higgins as a proxy to torment John. It was Karen who was angry at John. It's blatantly obvious from how quick the first jury note came back. 2 days, a juror in Karen's pocket flat out said they were not going to budge from the first minute of deliberations. Yeah, I'm going to guess that there was a juror who said, I will never vote guilty on any count, regardless of what you all say or regardless of the evidence. I'm pretty sure that was what happened. I'll never forget, says My King of Kings, I'll never forget Turtle Boy's face when Ronnie the juror told him the jury believed the, quote, Mick Alberts. Yep, that whole interview with Ronnie the juror on Turtle Boy was fascinating because that juror, I mean, he was a little bit in the bag, I think, not drunk, I mean, like he was a little bit pro Turtle Boy, but really that juror was willing to say things and Turtle Boy couldn't do shit about it. That juror was willing to say things that a normal Turtle Boy guest would never say, and that juror did not care. That juror had his opinion and he was going to share it. Now, yeah, I think that juror Ronnie also was definitely, like, he flipped a little bit. I don't know what his real deal was or if he knew. Now, I have some indications that there were people who knew that person was on the jury and were talking about him during the trial. So I'm wondering if Turtle Boy saw that stuff and did actually figure out who he was or who his friends were during the trial, but haven't seen anything to actually link it. Only that specific juror, his friends during the trial, were saying things on comments. I found a few of the YouTube comments that, like, they said enough where you could figure out they might have been talking about him, and that was weird. Like, they shouldn't have been doing that. It was definitely in the Turtle Boy orbit, the YouTube sort of social media orbit, and it raised a lot of red flags in my eyes. That was about that first juror. And by the way, we are talking about the jury from Karen Reed's first trial because that's what Karen's gone up to SCOTUS about, although it's not going to go anywhere. And remember, Karen already lost 2 requests to stay her state criminal trial pending federal appeal. She lost that motion for stay at the district court in Boston, the federal district court. She also lost the motion to stay the state court proceeding at the federal First Circuit Court of Appeals. So this state trial is not being delayed. Maui Swift says, it's all good, Grant. Life is hard and we are here for you. Oh, thank you, Maui Swift. Well, it is reciprocated and Tal will continue to persevere. Tal's just going to try to lead by example and not go off on moralistic rants in response to one question as opposed to doing a deep dive analysis of an update when moral rants are indeed appropriate. Eva says, so sorry to hear. Grand prayers for your family. Oh, thank you, Eva. I appreciate that. Kitties agrees with murder by maestro and said the notes coming back was way too quick. I agree. I think the timing was very telling, and it was a sign that a pro Kierney and Reed juror had tanked it from the beginning. Grant sending hugs, says Drew Drops. Thank you, Drew Drops. I appreciate it. Moving along nicely. Yep, 10 jurors seated. KHRIS says, I don't know how I feel about 10 jurors already. Yeah, that's literally the only, it's so interesting. We used to get so many updates per day about this case. And now the update that we get is maybe 1 or 2 every 8 hours. Numbers of jurors selected goes up. And that is the daily update. I guess some rulings have been coming down, but really nothing. It's all work on jury selection right now. I don't know about the people picked today, but yesterday it was 4 men and 3 women. I think I read something that when it was 8, it was 4 men and 4 women. I don't know what we're at 10. Maybe it's 5 men and 5 women, but I have not seen that confirmed. When do you predict opening statements? Macy, I'm thinking depending on the trajectory. So what's a bit of a wild card here is how many jurors Judge Cannoni actually wants. Maybe she wants 20, 18. Maybe she wants more than what we expect. I don't know. However, I think not next Monday, okay? So not 3 days from now, 4 days from now. The Monday after that, so what'll that be? April 13th or something? April 14th? Somewhere in there, I think we're going to get started. Which is tough for Towel, because I don't graduate until late May. So I'm going to be doing my best, interspersed with class and otherwise. But I expect we will get started sometime in the next 2 weeks. Probably not Monday, but the next Monday. Obviously, the tactic is to not use your strikes. Try and get... Oh, Murder by Maestro is giving jury analysis tactics. Obviously, the tactic is to not use your strikes. Try and get rid of who you don't want with the judge's X, and use your X as the last resort. I lost that from Josh Dubin. Learned that from Josh Dubin. Yep, and you only get 16 preemptory challenges in Massachusetts, I think. Each side gets 16. For a case like this, with all the evidence and details to sift through, it should have been at least a week. They had a problem immediately. Yeah, I agree, kiddies. I think one of the jurors was in the bag for Kierney and Reed. I think there was some corruption there, potentially. Wish that text could come in. Yeah, I agree. Ronnie and Vicky had agendas. Yep. Only Ronnie deliberated, I think, but multiple jurors had pro Kierney and Reed agendas. That was a problem. Thank you, Graham, for what you were doing. Oh, my cat and I do my best. I appreciate all the feedback, even if Tao's a little tired and emotionally overloaded. But we're keeping Tao's family member in our prayers, and that means a lot to little Tao. Hi, Grant. Hi, chat. Yes, Grant. Homeless Veterans is my #1 charity to help. That's a wonderful, Eva. I think there's so many good charities that are helping our service men and women when they return and face difficulties. And I think that's probably one of the most important populations. There should not be a single homeless veteran in the United States of America. The one homeless veteran in America is one person too many. It's a disgrace. It should not happen. It should not be possible. We should have the most robust safety net possible for our veterans. Now, if someone wants to experience homelessness because they choose to, despite that safety net, that's a personal choice. They want to go live in the woods or something like that, that's a personal choice. But there is no veteran in the United States of America who, against their will, should be forced to be homeless. And we have failed as a society if there is even one such veteran. Smart Scan. Hi, Mira. So good to see you. Hello. It's welcome. I appreciate you being here, being Chance. Karen is hoping for a Doug Flutie. The 1984 pass. Any good BC alum or BC football fan will remember Doug Flutie's Hail Flutie or Hail Mary. The Orange Bowl. I think my mom was a baton twirler for BC back in the day. Um, let's see. Can you have your mom on with you one day? Asked Mira. I don't know. Never asked her. We debate sometimes. We have a similar view on this case, although we found it in two very different ways. I found it through a dear departed man, may he rest in peace, named Brian Riccio, a reporter from up in Revere. My mom's got her own stuff going on right now, though. She just wrote a book, which you can check out. It's called Oh, No, He Didn't. It's about women in history and the men who took credit for their inventions and ideological evolutions and developments. So if you like Wendy Murphy, I think my mom's pretty cool. You should consider taking a look at her book. And actually, you know what? You know what we can do, Towel Friends? Let's help Towel Mom out. Let's get Towel Mom's book up on the screen. Wendy Murphy. Oh, no, he didn't. She did not ask me to do this. So you can go onto Amazon and you can get Towel Mom's book. If this is your area of interest, I highly recommend it. Now give me 1 second. $24. I'm going to have to get myself a copy. I'm pretty sure she would give me a copy, but I'm going to buy a copy anyway. Hold on 1 second. All right, thank you for allowing me to take a slight digression to show you my mom's wonderful book. She just wrote a book, as I mentioned, about men and women who, women throughout history and men who have taken credit for their ideas and inventions. I highly recommend checking out Towel Mom's book, well worth reading. Someone asked, the reason why I brought this up is someone asked if I could bring Towel Mom on the stream one day. Maybe I'll try to ask her, but Towel Mom has a few things going on. One, she spends a lot of time explaining to people, like trying to go to local organizations and explain to people the Equal Rights Amendment. Regardless of what book she's working on at that moment, her life's passion is trying to pass the Equal Rights Amendment for women, which is good. I think it's a noble approach, but her legal argument about the preamble and the Madison Amendment being able to pass 200 years after it was proposed, Congressional Pay Amendment, the 27th Amendment. Her argument about that versus the deadline imposed on passage of the ERA that was eventually extended by Congress, that and then the 38th state didn't ratify prior to the deadline passing. That argument, I mean, I want her to win, but it's a very difficult legal argument for her to win. But anyway, my mom has been working a lot on the ERA, a great thing to learn about. And then also she has this new lawsuit, although I'm not really sure where she's going with this. I think she has some kind of equal protection argument in mind. She wants to sue the government to, and I think she just announced it or she's working on it. She has plans to somehow impose the ERA through, she sued the archivist before the United States to try to get the Equal Rights Amendment passed. And she has some new idea, which I'm sure is going to be even more brilliant. So keep an eye on my mom. She's a smart woman. And if you want to learn more about undervalued women throughout the history of the world and how men took credit for their inventions, I encourage you to check out Towel Mom's book. We'll get back to the Kierney and Reed trial and her Supreme Court appeal. It's just someone asked me if I could have Towel Mom on the show, and I immediately wanted to show you Towel Mom's book. Lackadaisical says, Grant is emotional like the rest of us. That does not mean we cannot look at overwhelming evidence objectively. Yes, and also as emotional as I am and as intense as this case is, what I'm sort of... what I was ranting about earlier was more just the overlapping concentric socio-political circles of influence that orbit this case. The actual facts of the case, as sad and overwhelmingly agonizing as they are unfortunately a matter of academic study at this point. And that's what I've said I think is a sad commentary on this case, that it has become, instead of a way to honor the legacy of a great man who was taken from this earth, in my opinion, by Kierney and Reed, who was drunk driving at 12:31 a.m. on January 29, 2022, and backed her car up to 24.2 miles an hour, reducing to 23.7 miles an hour in a millisecond with a turn radius correction of 4.7 degrees or so upon striking John O'Keefe with her car, and then leaving John to die in the snow before returning 4 hours later or so, 5 hours later at 5:23 a.m., confirming John was dead, leaving the scene again, going to pick up 2 witnesses, dropping off her car, returning to the scene without the murder weapon, confessing multiple times in front of first responders, being sent to the hospital and sectioned for threats of self-harm by her own parents, having her blood alcohol reading taken at the hospital, which then confirmed via a retrograde BAC analysis that her blood alcohol level was Karen's between 0.13 and 0.29 at the moment of impact at 12:31 a.m. on 1/29/2022. Along with Karen's shattered taillight that was on video at 5:07, 5:08 a.m., 8:23 a.m., and 4:12 p.m. on that day. So that, as difficult as it is to talk about, and as sad as it is to talk about, it has unfortunately become academic to explain the facts. And the emotional weight, and it does make me realize, for so many of us who are on the periphery, who are covering this case, who are trying to relate to that overwhelming sadness, this sadness that we may all experience, just Towel happens to be going through it right now because of something difficult and a very sick family member that is weighing on Towel's soul. We all go through overwhelming emotional sadness, but imagine your emotional sadness in the national spotlight for 3 years, just never ending, relentless. You must be reminded of it all the time. Those are the moments I think that we should reflect on and keep the O'Keefe family in our minds in particular, because while we may ebb and flow in our daily lives into this case, out of this case, into our personal lives, out of our personal lives, for them it is, I'm certain, an all-consuming perpetual hellscape. Do you think I think you're kind of trolling GrantSmithEllis fans, so I don't really like that. And I'd prefer you not troll Meredith. Let's see. That's bad if a juror took that stance and never been on the jury. Think Karen's worried about the text stream data? Yes, I think Karen's worried about the text stream data that will show her GPS time and place on that morning. We don't know exactly how it's coming in. We know somewhat about the expert doing the chip off. We know Karen's expert from the first trial, who didn't get all of the data, the GPS data from the text stream or otherwise, is on the witness list. So there's a lot more coming. I saw that Turtle Boy, says Kitties, I saw that Turtle Boy sent out lists of juror descriptions from first trial, not just gender, race. Well, if it's from the retrial, that would be an issue. The first trial, that was just Wild West of chaos. Def Otter says, I feel Ronnie thought Karen was guilty but wouldn't say it to TB. I got a very similar vibe from their interview. It made me wonder, why was Ronnie even doing that interview? Hank Brennan can easily turn that back on the defense. Well, Karen can say, if the defense suggests it was Higgins or someone else, which they won't be able to. People misunderstood that third-party ruling. Karen cannot use a third-party defense without Judge Cannoni's permission. She can't use it in opening, and she probably can't even use it during her case in chief if she even has the opportunity to make the argument, because she never moved the motion for a third-party culprit during the first trial. She never even asked for permission. So I don't even think she's going to go there. But My King of Kings says Brennan can say it was actually Karen who killed John before he went in the house. I think Karen did crash into John before he went into the house, and I think it was because Karen was either saying go home, she wanted to go home and John wouldn't, or something like that. I think Karen was very upset at John, and Karen was the one who had the motive. Juror lawyer is a glorified babysitter for Karen. Yeah, one of Karen's, that of course is just ridiculous. One of the jurors from Karen's first trial joining her legal team. It didn't get challenged, which means that the state and clearly didn't want the issue to be raised. The state must have thought Karen was doing this to bait the state into objecting so she could raise an issue on appeal, and the state just let her do it to preclude the appeal. very, very troubling seeing people saying they would lie, cheat, whatever to get on that jury, says Ava. Yeah, that is a big problem. That is a big problem. I have seen a lot of people saying if they got called, a lot of Turtle Boy fans have said things like, if I got called, I would do whatever it takes. I would do whatever it takes to get on the jury. And I'm like, dude, that's subverting the justice system. You should have your mom on. Oh, well, we'll see. I'll ask her. I don't know if it would just be a lot of debating about non-Kierney and Reed trial stuff. A lot of debates about the Constitution and how it should be amended. Is it still, let's see, you have no security net. It's a crap situation you are in. Who, me? Yeah, I don't have a security net. Oh, our veterans, I think, is when I was talking about the security net. Yes, if you're talking about our veterans, I absolutely agree. Jack65 says, leave your towel on. B Enchant says, you're the best son, Grant. Oh, I don't know about that. I'm on the spectrum, so I don't really understand. Like, it's very hard for me. I have to work very hard to understand emotion. And I'm sure I was very difficult to raise. And I was I was reading Black Mass and asking for Dick Layer's autograph at 11 years old or 10 years old. So I think it's wonderful that people appreciate Tal, but I think Tal's parents had had a lot to deal with when Tal was growing up. Wow, Grant, you must be proud of your mom's book. Oh yes, my mom has written so many interesting books. She wrote a book, one of her books, Bill O'Reilly wrote the foreword to it. That one was called The Injustice for Some. She wrote that a long time ago, though. That one's hard to even find. I have multiple copies. But that book was really good. It's actually, now that I think about it, it's in a bunch of libraries because it's like an academic text that's about the Constitution. But then most of my mom's work kind of ebbs and flows between her translating legal developments into these books while also working on the cases at the same time. So my mom kind of ebbs and flows between books, legal cases, books, legal cases. She's great, though. I think she does good work. Is it a new book? Yes, Jack65. My mom just wrote a new book, just put it out. It was just published. I actually brought it up on the screen. It's called And Justice for Some was her first book. Her second book, which is actually, I actually like the cover of this one. Oh, no, he didn't. It's a great book about the publisher's description is, don't you hate it when someone takes credit for another person's idea? It happens a lot, and the people who lose out are often women. This book tells the stories of women whose inventions, discoveries, and creations were credited to men. Women like Zelda Fitzgerald, the novelist, painter, and playwright who was more than F. Scott's wife. And Margaret Knight, who invented the flat-bottomed paper bag, but saw the patent go to a man who stole off to the patent office with her idea. By telling the stories of the brilliant women, artists, inventors, scientists, architects, and mathematicians who were denied their due, Oh No, He Didn't will help all women tackle obstacles and create a kinship of understanding that will inspire and transcend generations. That's a good description. I saw my mom working on that book. She would have these really long phone calls with physicists, and these women physicists would be explaining to my mom these very complex concepts about like particles, subatomic particles or something. And my mom would be like, okay, I'm trained in the law. I'm going to need you to explain that to me very slowly. And it was great. My mom became sort of a polymath doing all the research for the book. I never thought she'd be learning about physics to do her work about feminism, but my God, she did it. So a testament to her abilities. We've gone off on quite a tangent here from this Supreme Court petition for a writ of certiorari, but you do all have a lot of questions. Lazy Susan said, I heard John DePetro said a juror was dismissed for not revealing their criminal history. I wonder if they were already a sitting juror. Very interesting. Trying to see if Grant has heard. I'll take a look. Are you talking about during the first trial or the second trial, Lazy Susan? Let's see. Finding the truth on Karen's lies is sometimes a challenge. Yeah. Kitty's good to see you. Have a good PM yourself. It's disheartening when you can't even have confidence that the jurors are being honest. We got to trust them to get to the correct verdict. Yep. Lackadaisical said, Grant's mom and I have a lot in common. These decades, so many years trying to break the glass ceiling that was made of polycarbonate. Oh, Lackadaisical, well, I'm so glad you see a reflection in your work, even if it's been difficult in my mom's work. I think my mom feels that way a lot of times, that she sees people out there trying to break that hardest, highest glass ceiling as well, and that there is camaraderie in that shared fight. Let's see. Just reading through some comments to get us caught up here, by the way. Am I going to regret asking, what does a mini washcloth mean? Oh, we're all towels and washcloths here. I'm an anthropomorphic towel. The Turtle Boy fans one time mocked me and said my pronouns were towel, and so I simply became an anthropomorphic towel. I'm praying for lots of new tech stream data. We got a comment. I think that's a very, very good thing to pray for. I know they did. Angela Whittick says, Jack5 says, are we getting better ring information about this trial? Well, as you heard during the first trial, there's ring information. There's 18 ring videos from 12:31 a.m. to 5:23 a.m. on January 29, 2022. 17 of those ring videos were deleted. Okay, they show Karen arriving back to Fairview Road at about 12:37 a.m. After driving from Fairview Road around 12:31 a.m. to John O'Keefe's house, 1 Meadows Ave in Canton at 12:37. So that Karen hits John around 12:32, 12:31 turns to 12:32, and then Karen drives over to John's house and gets there around 12:36, 12:37, which, by the way, is entirely possible to do. I did the drive in 4 minutes and 48 seconds, one of the routes. It could be done, I think, as quick as 4 minutes if there were no traffic and you hit all the lights, as would have been in the case at about 12:30 in the morning during the blizzard. So I think about a 4-minute drive time there makes sense. But then there's all these ring videos on John's system that are all deleted. And how weird that they would have shown Karen coming back at 12:37 with a broken tail light. They would have shown Karen's actions in the lead up to 5:07, 5:08 a.m. when she left John's house to go drive back to Fairview Road before going to pick up Jen McCabe and Carrie Roberts. All deleted. But during the first trial, Adam Lally asserted that Ring said that the records can't be received. They can't be retrieved due to the way they're stored and deleted. But I'll tell you, folks, you know what that keeper of records from Ring could be testifying to? The fact that they were deleted and are no longer able to be retained. The very fact that they were deleted is an issue that could come up during the retrial. Sounds interesting, Grant, your mom's book. She does have a very interesting canon. Didn't they say Einstein's wife was published under his name? I don't know, Murder by Maestro. That's a very good question. I think my mom is the person to ask about that. There's so many. We are not going to be able to actually finish the petition for certiorari if you have so many questions. But okay, I'm here. All right, let's see. I've never had the honor to serve on a jury, says Angela Whittick. Me neither. Lazy mini washcloths was babies. Okay, we're talking about mini washcloths. It's an anonymous third-party culprit. Yes, Your Honor, we think it was a dog or maybe a pig. Ladies and gentlemen of the jury, my name is Alan Jackson. Karen Reed didn't do it. It was a pig. And then we're going to hear the best line of testimony from the first trial was one of the experts who said, as far as I know, there are no feral pig populations in Massachusetts. I mean, I can attest that. I've never seen any feral pigs running around, but I think Karen should invoke, we talked about this the other day, I think Karen should invoke the Chewbacca Chewie defense. Okay, the Chewbacca Chloe defense. Alan Jackson should stand up there and tell the jury that it was Chewbacca and Chloe that killed John. That should be the whole Reed defense. It was Chewbacca and Chloe. And when people ask questions, Alan Jackson should just say, Chewbacca is the third-party culprit. Because that's the point we're at this trial, where Alan Jackson could plausibly assert Chewbacca as the third-party culprit, and I'm pretty sure the Karen Reed fans would be like, we got to figure out who this Chewbacca guy is. And I'm not making light of it. I am almost serious. I think if Alan Jackson or the Reed defense legitimately put a leak out there through one of their PR people saying that the defense is going to be arguing that Chewbacca did it, there would be people who actually go on social media and make posts analyzing why Chewbacca may have been responsible for John O'Keefe's death. That's the point that we are at in this absurdity. So the Chewbacca Chloe defense is what Alan Jackson will be forever remembered for. Angela Whittick, Alan Jackson during his opening. We don't know who did it, but Karen did not kill her boyfriend that she loved. Yeah, exactly. The boyfriend that she was telling Higgins she wasn't with anymore, and that she that she was breaking up with, etc., etc. Christina, they know she hit him, but they're good at hiding their true thoughts. Yeah, I would say that the defense is very good at PR. Christina says that she's concerned Karen Reed's half succubus. Yeah, I think Karen Reed, I think she's like artificially famous. Like, she thinks she's hot shit, but she's not. And then it's also like she thinks she's more like powerful than she is. So the way she carries herself is she's like, oh, like, how would I explain it? Like, I've looked into her eyes a lot. It's like she wants to be able to give that like commanding kind of political sort of like 1 second like look into your eye is enough for me to like tell you what you need to know. You know, like she wants to give that off. But I think what's really there is just this like scared like little girl who doesn't really know what she's involved with and is in completely over her head and likes the intellectual exercise of all of this, but isn't ready to actually deal with the consequences of any of it. She was more just having fun along the ride, I think. That's her psychology. So succubus, yes, but also I think like imposter syndrome a little bit. Like she isn't actually as confident in her abilities as people project onto her. So she feels like internally, I think she feels like a fraud. Not just with the fact she's hiding her responsibility for John O'Keefe's death. What do we think about the Ring Keeper of Records? Yeah, we already answered that question. Did anyone watch 30 Rock, the TV show with Tina Fey? If so, there's a joke where people can't pronounce the name of Jenna's movie, The Rural Juror. My husband said he's calling VG the Lure Juror. I haven't seen that show, but that sounds funny. Jackson was overly friendly to jurors today, B-Chance says. Alessi beaming ear to ear, such phonies. Then Bev commanded the room perfectly. Yes, well, Judge Cannoni. Yes, Judge Cannoni did a great job. Where did I grow up? I grew up right outside of Boston, Maui Swift. I think technically for the first 2 weeks of my life in Cambridge, and then, although I was born in Newton, and then in that hospital. And then I think 30-something years more, the rest of my time in Belmont, which is where my family grew up. And I went to Belmont Public Schools. I was apparently a year younger than Michael Proctor's wife. Is it Elizabeth Proctor? Her name was like Elizabeth Syracuse or something back then. I did not know her, never crossed paths with her. I actually found out halfway through the first trial. Someone was like, did you go to high school with this person? And I was like, I have no idea who the fuck that is. And since her last name wasn't Proctor back then, when they asked me if I knew her, I was like, I don't know who the fuck that is. And they were like, that's Proctor's wife. And I was completely blown away. Let's see. I'm hoping the keeper. Oh yeah, we already. Good insight, Kerry Gold. It's great to see you, by the way. I'm hoping the keeper of Ring records will show what device was used to delete those videos. Yeah, I think that would actually be very telling, and that may actually be why Brennan's calling the keeper of records, because Ring doesn't store them on their own servers in a way that would be retainable, but Ring absolutely can tell you what devices had access to the accounts, and I bet Karen had to use one of those devices, and I bet Ring could even produce some kind of deletion log. Let's see. Oh, I jumped way up in the comments. Sorry. Murder by Maestro said he was doing some research today trying to calculate the ground hardness, but then ended up distracted. I hope we find out some damning info during this trial. This is when I was talking about the Chewie defense. Does Chewbacca have bottom teeth? Yeah, this is going to be the key question of the second trial. Alan Jackson's going to focus all the attention on it. Does Chewbacca have a bottom set of teeth? We're going to see Olivia Lamb write 5,000 words every morning. Does Chewbacca have a bottom set of teeth? We're going to see that Joe Flipperhead guy putting out music videos with Chewbacca and his missing lower teeth. We're going to see just never-ending, ridiculous, nonsensical analyses from that Abby woman, the Video Jesus woman. Does Chewbacca have bottom teeth? They'll do mock drafts of Chewbacca. They'll take inspiration from Murder by Maestro and have graphics of Chewbacca at the scene and how Chewbacca may have escaped the scene. Maybe Chewbacca levitates and doesn't leave footprints. Karen Reed used the Millennium Falcon, and then that's how Chewie arrived on the scene. Yeah, I think the ID doc has definitely come back to hurt Karen. I just got Murder by Maestro said I just got access to an AI agent I've been on the wait list for weeks. That's wonderful, wonderful, Murder by Maestro. If there's any wonderful content you'd like me to share while doing these streams and analyze, I will be happy to do so. I don't know if Judge Cannoni's married. Dixie Doodles, I don't want to know. I don't want to ask. They might be the most nerdy thing I've ever said, says Murder by Maestro. Well, if that makes you happy, by my friend, more power to you. Some folks are saying they don't like how Judge Cannoni is being slandered across social media. Yeah, I think a lot of people gratuitously attack Judge Cannoni, who has been one of the most fair, impartial, down-the-middle jurists I've ever seen overseeing a criminal case. And I'm calling it down the middle here because I've never covered a case with Judge Cannoni before, as far as I'm aware. So this is my first experience with Judge Cannoni, and whether it was the first trial or the retrial, fair, right down the middle, impartial jurist, if anything, too deferential to the defense, and yet she catches flack. Then again, I don't know if you all saw, but the Karen Reed folks have now decided that the farmers market are in on the conspiracy against them. I'm pretty sure the Dedham Library's in on the conspiracy. The Federal First Circuit Court of Appeals. I'm sure SCOTUS is going to be in on it when Karen loses at SCOTUS. So I think this whole situation it is becoming a little bit more obvious that it's more just anyone the Karen Reed fans can make into a caricature and attack, they will use for their 24-hour cycle. But you can only do that so many times before the people who are actually paying attention and listening to these details are just like, all right, you know, however many there are of the Karen Reed fans, dwindling in number though they are, down to 5 or so there today, maybe 10 people. There were only 2 yesterday when I was there at the trial. You Karen Reed fans can continue to yell in your ever-shrinking echo chamber, and the rest of us are going to actually pay attention to the developments of the case. A perfect example was that Canton Police Department video, which all of the Free Karen Reed fans entirely misunderstood the way in which that was going to be analyzed, the admissibility thereof, and the way in which the defense sort of went about asking for more information about that video and how it was guaranteed to lead to a loss of Karen's motion to dismiss. They spent hundreds of hours pumping out nonsensical content in their hive mind sort of feedback loop about that Canton CPD video, only for it to have no material relevance as to Karen's very weak denied motion to dismiss a few weeks ago. Perfect example, though. Grant is a precious soul, says Lackadaisical. His parents should be proud. And I think my parents are like, our son thinks he's an anthropomorphic towel. I think Karen is adding the courthouse janitor to her defense team next week. At this point, I'm pretty sure Karen would accept anyone on her defense team, just anyone. Keeper of record should also have timestamps. Yep, that's true. Someone says the lawyer will dress as Chewbacca for a courtroom demonstration. Lackadaisical says if Grant has his mom on the show, we can show her how appreciative he is. Oh. Interesting you don't have a Mass accent, Grant. There's a joke, Mass is a state full of people who mispronounce words. Sorry, I didn't make it up, but it's funny. Oh, I mean, listen, I think it's like, I can't just transition into it, but if I were just talking like I talk at home, like down the corner, or like like, I don't say mom, like I say ma. And, you know, I wouldn't say something like park the car, you know, down in Harvard Yard. That's like a caricature, but, you know, like, got to go down the fucking Cape, or, you know, stuff like that. Like, I definitely, there is a way that I would talk if I were talking to someone who is from this area. It's definitely a fleeting accent. There's actually been a nomenclature study done of the decline in this accent in particular. I think it was done an analysis of all the regional dialects up here in the New England area, and most of them are declining. The Boston Brahmin accent actually used to be very popular. This might actually give us a good chance to take a little break here for about 5 minutes while I drink some of my water. I'm going to watch the video with you. But let me just show you what an actual, like, hard Boston accent was. Because this, if you want to hear what people from Boston actually spoke like, it was very different than what you imagine it might be. Because the Boston accent that you hear, and the Boston accent, the way that it comes across now, even I growing up, we heard the Boston accent definitely a lot more. It's definitely dying, and I don't think there's that many people who even talk this way anymore. But let's see if this is the one that I wanted to show you. Let's see.
Married a Cabot. She was...
Yeah, this is it. All right, I found it. And I want to show you this, not gratuitously, but because, one, it's a good break from us reading Supreme Court decisions, and two, also I need to actually drink some water. So you can tell how tired Towel is if Towel is taking time away from a Supreme Court brief to show you a YouTube video about Boston Brahmin accents. But it's the end of the week. I think we have read 500 pages of federal court opinions over recent weeks, and taking a little bit of time to watch a video about the Boston Brahmins and the old Boston accent is exactly what I want to do right now, because this is what I would do whether I was streaming or not.
Like the cod, the number of proper Bostonians is dwindling. At the beginning of the century, when Harriet Ropes was born, prominent Yankee families were not only prolific, they also wielded the financial power in Boston. When Harriet Ropes married a Cabot, she was guaranteed not only a place in Boston society, but in New England.
Of course, that's what happened to most of the girls, at least of my generation in Boston, who they encountered boys at Harvard or wherever from somewhere else, and so they left when they got married and never came back.
The Boston Mrs. Cabot grew up in was filled with dinner parties, trips to Europe, Harvard football games, and the much-awaited coming-out parties. Reading from her diary, written when she was 16 years old, Mrs. Cabot recalls a life of privilege and class. It was an era when meeting and greeting became an art form.
I had a dinner before the bridal. This is Saturday 14, whatever that must be, 14th of October, I suppose, before the bridal. And then there's a map showing my parents.
That wasn't actually what I wanted to show you. That's a good example of kind of a posh Boston accent. But this is what a Boston accent actually was. It's not as blue-collar as you think.
What else have they got to live for? Well, sex, probably.
Well, doubtless sex. They keep that very quiet.
Yeah.
But
I know you don't like Dickens.
no, I don't like Dickens.
Yes, he's post-Austen.
Now, Jane Austen, of course, is the greatest novelist in the English language.
Well, she's a great novelist, but not the greatest.
Not the greatest.
I'm a Dickens man.
Well, Dickens is message, George.
course he's messy, but he's lively.
He only wrote one great book, which is Pickwick Papers.
I would put that way down compared to Bleak House.
I've been here for about 350 years. My family came over with the first load of bricks.
Yeah. I consider myself speaking the Brahmin dialect of Boston. But the word Brahmin is a very difficult word to define, and it wasn't, in fact, invented by until Oliver Wendell Holmes in the middle of the last century.
Do you think there are many people in Boston who speak like you two gentlemen do?
All right, so there you go. You heard an actual Boston accent. So I think a lot of people think that I keep hitting that button. I think a lot of people think that the sort of popular Boston accent is the Boston accent. No, that is the actual Boston accent. It's kind of like wannabe British with a little bit of a draw, a little bit of a slang. It drops its A's, but the emphasis is definitely on certain vowels and syllables, but it's also lazy in that it drops some of its A's. So I don't know. That you heard it there. That is what an actual Boston accent is. All right, back to the Supreme Court opinion for certiorari. We are just all over the place. If I let myself read those comments, we go down rabbit holes because you all have so many interesting questions. We cover everything from generative AI to case evidence to questions about sort of the overlapping historical, socio-political implications of feminism. So I have to remember that if we actually want to accomplish a task like reading the petition for certiorari, I cannot read the hundreds and thousands of comments that you all leave. Now, I do think it is important that I live up to my promise to you all to read those comments, but I also have to balance that against the fact that we have something to accomplish. We are going to read this petition for writ of certiorari by Kierney and Reed, and we are not just going to watch videos of old school Boston Brahmins talking to explain to people from around the world, the lovely towel friends, what it is that it means to have a Boston accent. You all are probably just like, this is the most random towel stream. A lot of our towel streams I feel like are random, but I have a set series of documents I want to go through. This is one of those random days where developments in the Kierney and Reed case, thankfully, because I've been tracking the docket so closely, have actually slowed down, although it's going to pick back up, obviously, where we can actually take stock, answer some of your questions, think about what's going to happen with the coming retrial, and then read these documents. Now, also, I talked a little bit about how intense the atmosphere has been at these Kierney and Reed trials. And when we get to the end of this next section as our next towel break, we'll watch the video of Karen leaving court yesterday, and for the first time ever, the state police used force. They didn't actually have to go hands-on, but they put a show of force around the media, penned us in, and basically told us that for the whole trial, we won't be walking with Karen and asking questions. We can stand in one place. She can walk by, and that's it. We can't walk with her. Now, apparently this happened because there was some behavior on Tuesday that pushed the limit. I was not there Tuesday. I had 7 hours of class. But I heard that when Karen left court on Tuesday, there was this explicit request from her legal team that the media not chase Karen. The media was told to request. They decided to do it anyway because Karen walked down the handicap ramp. It caused a scrum, and then the media chased Karen to her car. The very next day, and Tal has this on very good authority, Tal has good sources on this, the state police then showed up around the media when Karen left court, and it was ominous. It was like if you tried to walk after Karen, I mean, not me, I didn't go anywhere because I knew exactly what the state police were saying to us just by standing there, but any of those journalists attempted to walk with Karen at all, those state police were going to go hands-on and stop them. So it was ominous, folks. It's uncomfortable to be there. It's boring. It's very different than the first trial. There is no one around. Kierney and Reed looked completely scared and intimidated and overwhelmed by the lack of anyone being there. That seemed to be what resonated with Karen the most. That day after day, she's now walking out of this courthouse to no one. And then Hank Brennan himself walked out of the courtroom. The first time I ever saw Hank Brennan know the media was waiting at the base of the stairs and not wait around. That man walked out of that courtroom, head held high, basically walking on air. The level of confidence he was exuding, it was impressive. So we'll talk about all that at the next break, but you must listen to more of the reading of the petition for certiorari. All right. So, post-trial juror statements reveal that jury found Reed not guilty on counts 1 and 3. Mr. Weinberg, no, they did not. How many federal judges need to tell you that they did not before you stop saying this? The following day, on July 2nd, 2024, unsolicited by any party, I don't believe that. I don't believe it. One of the jurors, Juror A, contacted one of the attorneys for Reed, Alan Jackson. I don't believe for a second that was the first time they ever had contact, whether through an intermediary or otherwise. I just don't believe it. Yeah, Marty Weinberg can say it in good faith, because I don't think Marty Weinberg has any reason to not believe Alan Jackson telling him that. But I don't believe for a second that was the first time that juror ever talked to the Reed defense. Because remember, I hope you folks know, as you saw from Judge Cannoni's recent order on the docket, you are allowed to do jury research. Both sides. Once you start seating jurors, you can start researching them for the purposes of presenting your case. So Alan Jackson and David Yannetti and all Reed's lawyers and Reed knew every juror on her first trial. They knew everything about them. So I don't believe for 1 second that this juror just randomly called Alan Jackson. Juror A stated that she wished to inform Attorney Jackson of the true results of the jury's deliberation. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. But remember, nothing was ever announced in open court about this. So it could have easily been some of the jurors saying, well, if we're going to vote on count 2 for OUI manslaughter, then yeah, maybe we won't vote for not guilty on count 1, but that's a compromise verdict, and it's just an agreement. It's a working deliberation. It is not a verdict, and it doesn't actually become a verdict until you record it, because the whole reason people might have said they were comfortable voting not guilty on count 1 is because they thought they had an agreement on count 2, and if you don't end up reaching an agreement and you come to a mistrial, then the whole premise of people saying they weren't going to vote guilty on count 1 goes out the window, which is why this was not a verdict, if it even happened. The jury also, quote, unanimously agreed that Karen Reed is not guilty on count 3. Yeah, no, I don't believe that either. One day later, on July 3rd, 2024, another attorney for Reed, David Yannetti, was contacted by two different individuals. Herein, Informant B and Informant C. David Yannetti, the wannabe fucking FBI agent. I sometimes wonder if David Yannetti, actually has a lot of connections in that world, and he thinks of himself as wheeler and dealer with the FBI. I'll bring you informants. I'm David Yannetti. I don't meet with tow truck drivers or plow truck drivers in parking lots and get pictures taken of me and then have to bring it up in court motions. I'm David Yannetti. You all are probably like, what is going on with Towel tonight? Well, you try to be sleep deprived and dealing with complex emotional trauma from a parent being or family member or otherwise going through difficult situations. Powell's doing his best. And if I have to make fun of David Yannetti to get through this Supreme Court petition, I will do so. By the way, I've said very nice things about David Yannetti and his abilities as a lawyer. I don't necessarily agree with his tactics in this case, but you cannot deny that David Yannetti knows what he's doing, understands the court process, writes good court motions, understands how to use the court process to the benefit of his client. I'm a little confused as to why he's still working with Karen Reed after he saw an email from Karen where she made fun of him and insulted his abilities to Alan Jackson. But, maybe they had a long talk and Karen said that was I don't know. That must have been an awkward kind of mending of the relationship. If I'm not a lawyer, I'm a towel. But if my client said, I think this lawyer is fundamentally unprepared to handle this case or something, I'd be like, okay, sounds good, I resign. Find someone else. All right, let's go back to David Yannetti's informants. All right, so it's not just that David Yannetti had informants. It's that David Yannetti's informants had received information from jurors. So these were intermediaries, both of whom were part of the deliberating jury in the case. Marty Weinberg had to be very careful how to phrase that so he didn't have to write the sentence that it was like one informant heard from another informant who heard from this other person who heard from Chewbacca that a juror said B. Every time Kierney and Reed says something ridiculous in a legal argument, I'm going to relate it back to Chewbacca from now on, because I've had to read so many words that are just basically a nonsensical argument based around hearsay and just rumors. Informant B sent attorney Yannetti a screenshot. I remember this. She. Why can't you just say they? Marty Weinberg's like, it can... Well, so at least we know they're not trans, right? Marty Weinberg, you gave that away. In trying to be non-gender inclusive, Marty Weinberg revealed that it had to have been a man or a woman. Who does that? Had received from someone hereafter intermediary B of text messages that a screenshot she had received from someone hereafter intermediary B. Oh God, he does have to do it. It wasn't just informant heard from the juror. It was that informant heard from intermediary B who heard from a quote unquote juror. So Yannetti has no way of knowing if this person was actually a juror, or if this was actually a real message, or if it wasn't just some random person sending him a message to troll him. Of text messages is that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. That ended up not being right because another juror reported 8-4 and another juror reported 9-3 guilty. I thought the prosecution didn't prove the case, said this anonymous person. No one thought she hit him on purpose or even thought she hit him on purpose. Said it twice. Juror B later placed an unsolicited phone call to attorney Yannetti confirming that the foregoing information, which had been publicly filed in an affidavit, was accurate. Juror B clarified, however, that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. That part might be right. I think Karen did know she hit John, because obviously there was a strike in the car, reduced in speed, and there was probably alerts from the Lexus. So I'm not necessarily convinced of that. Juror B further told attorney Yannetti she believed. Now it's he again. This time though, he has switched from he/she to she/he, and instead of he/she spelled out, it's just S/HE. So consistency error. Believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3. Yeah, I don't think that's true. Informant C had been in contact with another intermediary who is a co-worker and friend of Juror C and joined a Zoom meeting during which Juror C discussed the trial. Juror C was like, hello, friends and family and co-workers. I'd like to have a Zoom seminar with you all where we discuss the trial. Just ridiculous. Informant C sent attorney Yannetti the below screenshot of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. 6 degrees of Chewbacca. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlocked at 8 yes, 4 no. Now, what's so interesting is this first informant, who was so certain of their information, told Yannetti 6-6. And now you got this other juror being like, oh yeah, maybe it was 6-6 in the beginning, but then we were 8-4. So now you already got evidence that the information being relayed to Yannetti isn't consistent or accurate. Let's see. Oh, yes, the second informant. The 6-6, and then 8-4 on count 2. Informant C then said, interesting, to the juror. If it was no consideration for murder 2, shouldn't Karen have been acquitted and hung on the remaining charges? Chargers, apparently this person's a San Diego Chargers fan, goes back to jury verdict slip that was all confusing. Intermediary C, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. So it seems like this is intermediary C claiming this is what the juror was saying. But obviously, this juror is more than just confused. This jurors were already relaying different information than the other jurors. And we know this from reading through these documents in the past. But reading it this way, you have to remember, the Supreme Court justices are not following the Kierney and Reed trial. So when they're reading this stuff, Marty Weinberg has to do his best to make it not seem ridiculous, and it still comes off to someone who has never read any of these facts as just a ridiculous statement in terms of the double layer hearsay. And it's in Bluford, you had a juror standing up in court announcing that they had acquitted the defendant on some counts, and that wasn't enough. And Marty Weinberg thinks that this is going to be enough. After the filing of Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. The first juror, D, stated that the jury reached not guilty verdicts on count 1 and 3, and that the disagreement was solely as to count 2 and its lesser offenses. So now we're really not sticking with consistency because we're using the she-he thing again, the S-H-E instead of she/he. She/he recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Kierney and Reed on counts 1 and 3? Yeah, I don't think that happened. Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Kierney and Reed not guilty on counts 1 and 3, because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3. Yeah. The Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21st, 2024, an ADA, so how far after the initial call to Jackson? So like 21 days later, clearly I think the defense prompted a juror to call the ADA to leave this record, received an unsolicited voicemail on his office phone line from an individual who identified themselves as a juror by their full name and seat number. The message stated, it is true what has come out recently about the jury being unanimous on 1 and 3. The ADA received a subsequent message from the same individual stating he could confirm unanimous on charges 1 and 3, is not guilty, and his last vote, 9-3 guilty on the manslaughter charges. You can't be 9-3 guilty on the manslaughter charges. You have to pick one of them. I don't think this jury in general understood what was going on as to what they were supposed to do, but that's not really material because jurors make mistakes all the time. The reason why we process evidence and we don't just let the jury hear everything is because they're fundamentally unsuited to process what's going on. So we assume in the deliberative process they're not necessarily going to understand. They're going to do their best. But these jurors, I'm not sure. That's, I think, what a lot of the confusion was. I don't really think they understood what was going on in the process of what they were voting on, or in terms of the number of indictments or how lesser included offenses worked. But that's how it works, folks. The jury process is 12 lay people, normally from the community, who have to get a crash course in the law and the facts over a very short period of time. It is expected. In fact, there have been some cases where jurors used drugs during the trial and during jury deliberations, and that wasn't enough to revisit what they were doing during that time. I'm telling you, courts give a lot of deference to these juries, and courts assume that juries are lay people and that they're not really going to know what's going on, and they're going to be doing their best. So the Supreme Court, in my opinion, is not going to see these jurors as being confused as abnormal or some aberrant process they need to review. They're going to say this is what it's like in the trenches for a jury. The Commonwealth additionally received emails from 3 individuals who identified themselves as jurors and indicated they wished to speak anonymously. The Commonwealth declined to substantively respond to the voicemails or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. That's true. So the Commonwealth was the only one who did the right thing here, and I think the federal courts made note of it, which is if you get this material, you alert the other side to it, which the state did. By the way, I think Marty Weinberg said something that it was disclosed or something. But the Commonwealth did the right thing. They turned it over to the defense and told the people who were coming forward, we cannot talk to you about jury deliberations. That's explicitly prohibited. Now, there's a little caveat in the rule where the defense has a little bit of leeway, because the rule says if a juror just approaches counsel, that's a little bit different than if the counsel were to like go find the juror and engage them in conversation. It's similar with the media. Like we would never, and I don't know who, maybe not every member of the media, but any responsible, ethical member of the media would never approach anyone who was on a jury or whatever to try to get comment. But it's different if the juror approaches you. But that can also cause problems because, well, what kind of juror might want to approach you? Someone with an angle or a bias or something like that. So again, the prosecution was probably the one group of people in this whole tormented saga related to these jurors trying to come forward who did the right thing, which is not engage, turn the material over to the other side, and move on. Because you don't revisit jury deliberations after the jury is done. All right, Reed moved in the state court, so we're now in part C of the factual record. Why are you wasting 12 pages of this on the factual record? If you actually had substantive argument, you would be arguing it. Reed moved in the state trial court to dismiss counts 1 and 3, arguing that the jury's final and unanimous decision reflected in the post-trial affidavits that she is not guilty of those counts constituted an acquittal, precluding reprosecution. Oh, did you know actually for my classes right now, I'm working on a petition for cert to the Supreme Court? This is actually incredibly helpful for me because now I'm learning what an actual petition to the Supreme Court should look like. Mine is not nearly as good as this. I had to build a facts section and then an argument section and then apply the facts to the argument section. It was very hard. This is very good. I am learning a lot from this. This is like an active exercise. I should have done this a long time ago. I did do this a long time ago. Sometimes I realize things midstream, and I'm like, oh, this is really useful for me. All right. Reed additionally argued that she was entitled to a post-verdict judicial inquiry to substantiate the facts of the acquittals. The trial court denied Reed's motion. The court accepted the jurors' statements reflected in the affidavits as true and accurate, as did, yes, but that's for the purposes of your pleading, as did each other court that reviewed the legal issues, and for purposes of ruling on the motion, but held that because there was no open, exactly, Lawrence v. Stearns, because there was no open public verdict because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted on any of the charges. Every single lower court held that to be true. The court also held that Reed was not entitled to post-verdict inquiry because her arguments did not implicate racial bias, which is the only exception to Tanner v. U.S. pursuant to Pena-Rodriguez v. Colorado from 2017, or her right to receive an impartial trial, and because her request would necessarily require inquiry into the back and forth among the jurors during deliberations. Do you notice how, was that the trial judge or the lower courts? All of the courts ended up finding this same exact thing. Judge Cannoni, the SJC, the lower court, the lower federal court, the district court, and the First Circuit Court of Appeals. And what's so interesting is because the Supreme Court has very specific rules, Weinberg can't get around having to say that he lost. So he has to tell the Supreme Court, without being manipulative at all, this is why I lost at the lower court, and here's why they ruled against me. So this part you will enjoy if you appreciate lawyers having to describe their own horrible losses in court. Reed petitioned the Mass SJC pursuant to Mass General Laws 211.3 to review the Superior Court's ruling. A single justice referred the petition to the full court. The SJC ultimately affirmed the denial of Reed's motion to dismiss, concluding, like the trial court had, that because the jury did not publicly affirm that the defendant was not guilty of the charges, there was no acquittal barring retrial under the Double Jeopardy Clause. The SJC additionally held that the trial judge did not err or abuse her discretion in denying Reed's request for post-trial inquiry, where it would not change the outcome of the defendant's first trial. Yeah, the SJC dominated Reed. The jury chose to report a deadlock, not a verdict, and no basis for further investigation into private discussions or subjective beliefs they declined to announce publicly, and no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. D. Decision below. Oh, now Weinberg has to talk about how badly the federal court ruined his life. Yeah, I would not like having to do this. I would not like having to do this at all. Did someone just send me a donation? I said I don't need any donations. See, Pilgrim Shadow? This is why I was ranting the other day. I was like, if I leave this up, people are going to send Little Towel donations. And Little Towel's actually doing okay. And I wanted you to donate to homeless military veterans. You don't have to do that. I just think that's a very noble cause. Oh, God bless you all. For pizza and gas money. I promise you, I will buy some 7-Eleven pizza tomorrow. I actually had chicken for lunch today. It was very good chicken. I felt a little bad not getting my normal 7-Eleven pizza, but I think eating 7-Eleven pizza like 20 days in a row is, I mean, I'm sure you could make a movie like Super Size Me about why eating 7-Eleven pizza 20 days in a row is not ideal for one's health. But yes, I cannot wait to get more 7-Eleven pizza tomorrow. That's actually the very first thing I'm going to do in the morning before I go to class. But yes, God bless you. That means so much to me. Even though, as I said, Towel is not, I did leave the donations up on the screen, but Towel is just going through these documents. Towel's doing okay for now. If Towel needs help at some point during the month, I will let you know. And the best way you can support this stream right now is by apparently liking the video while you're watching it in real time, or subscribing to the channel while you're watching the video. I don't know why it is so helpful to actually do that while the video is live, but from what I understand and what I'm trying to learn about this YouTube platform, that is the best way to engage with the content, to actually like it or subscribe while it's playing. I don't know why, but that's how it is. If you're over on X, I appreciate you watching there as well. If you're just getting caught up, my name's GrantSmithEllis. We are in the middle of reading through Kierney and Reed's 25-page appeal to the petition for certiorari, so a permission to appeal to the Supreme Court of the United States. We don't get to see too many of these in criminal cases in Massachusetts, not to mention in such a high-profile case. Now, this is absolutely destined to fail. It's going nowhere. We're 13 pages in, and there's still Reed's lawyers taking up space on the facts section, which shows there's not a lot of legal argument to be had, because you would spend way more time on the legal argument, like 20 of the pages, rather than filling it up with this facts section. But that said, if you're just getting caught up, you're watching over on the X, glad to have you with us as well. A lot more people watch over there for whatever reason, but it's less interactive. The comments don't stay up on the screen. It's harder for me to follow along with what you all are saying. I appreciate that you're all engaging over there. Sometimes when I go watch the stream afterwards, I see some of the comments flash back on the screen. I feel bad not being able to read them. But if you want to engage, ask questions or comments, the YouTube's the best way to do that. Easier for me to keep track of what people are saying. If I do it the right way on the back end, I can actually pause the comments in real time, and they all stay loaded up for me to read, and there's a lot of them. I try to, although I don't guarantee it, I try to read every single comment on this stream, every question that I see, as long as it's not derogatory, discriminatory, or sea lioning or trolling. And on the whole, it's a wall of blue towel friends. And I realize I haven't been checking in with your comments or questions for a little bit, but that's because I realized if we were going to get through this Supreme Court petition for certiorari from Kierney and Reed to the Supreme Court that was just filed today, Thursday, April 3rd, 2025, then we needed to do that. And Towel cannot just read all of his Towel friends' comments, which are wonderful, because then it's 3 hours into the stream and we have not actually gotten through the petition for the writ of certiorari. Now, Towel could spend hours with you all. Towel feels wonderful chatting with you all and talking, and it is wonderful to do so, but I think in the interest of erudite and cogent public discussion, we must read the document. That said, there is a point here. I think once we get through the facts section, we're going to take a little pause. I'm going to catch up on your comments. We're going to play the video from court yesterday to watch just how much The on-the-ground situation has changed at the Karen Reed trial. Media being penned in by the state police after Karen leaves court. Not allowed to walk with Karen to her car. Very ominous vibes, very heavy vibes. All of Karen's supporters are gone. It is just a quiet, desolate, normal, well, other than all the state police, desolate, very, very barren area around that courthouse. And we're going to watch some of those videos. Reed subsequently filed a federal petition for a writ of habeas corpus pursuant to 28 U.S.C. 2241. If you're wondering what is that, Grant, that's where if you're in, quote, like pre-trial custody on some kind of release for a state criminal charge, you can bring a federal challenge, and that's what's happening here. Again, contending inter alia that the jury's conclusion that she is not guilty contributed, constituted an acquittal, and that she was entitled to post-verdict inquiry. The district court denied her petition and Reed appealed to the First Circuit. The district court also denied a stay, Mr. Weinberg. A panel of the First Circuit affirmed Judge Saylor's decision. The First Circuit began from the premise, long established in the court's case law, that in this is where Weinberg has to argue the First Circuit got it wrong, which is not going to happen. A panel of the First Circuit affirmed, 3-0. The First Circuit began from the premise, long established in the court's case law, that in deciding whether a defendant was acquitted, the court must focus on substance over labels and look to whether the ruling's substance relates to the ultimate question of guilt or innocence. Quoting McElrath, which is the right case to quote, despite the fact that the Bluford court expressly declined to find that the lack of a formal verdict was dispositive regarding the double jeopardy implications of a jury finding, the court found Bluford to be dispositive. The lack of a formal verdict is not dispositive. But you know what else isn't dispositive, Weinberg? A jury foreperson standing up in open court and saying that the person was acquitted. So then, of course, jurors coming out up after the fact would indicate that Bluford is dispositive. The First Circuit stated the post-trial juror statements here were far weaker. I knew it. I get so excited when I see stuff like this because I knew it was coming. I either remembered reading in the First Circuit decision or I intuitively would have made the argument. The First Circuit stated that my microphone's working. The First Circuit stated the post-trial juror statements here were far weaker than the foreperson's mid-deliberation statement in Bluford because the statements here do not describe when any votes were taken or whether such votes were preliminary or formal. Like Bluford, there is no sign that a final vote was taken, meaning that if any deliberations continued after a vote, jurors could have changed their minds. Exactly. Nor did the jury announce its verdict in open court, like in Bluford. I love how Marty Weinberg is forced to not only describe how badly he lost at the First Circuit, he has to really detail it. He has to really say, I didn't just lose, but the reasons I put forth in my argument were rejected, and here's why. And also, here's why the First Circuit asserted that its interpretation of Supreme Court precedent was correct. And then Weinberg's going to have to say, but here's why I think they're wrong. And that's not going to work for him. You know why? Because if Marty Weinberg could come up with those kind of arguments, he would be a federal judge. Which is not an insult to his intelligence. It's very hard to become a fucking federal judge. But if Marty Weinberg actually had the ability to see something that the First Circuit didn't, Marty Weinberg would be a federal judge. Ultimately, the First Circuit concluded, even if we assume that the jury unanimously voted in private, that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view, which is even more devastating for Karen, because they're saying, even if you were right about this, which we don't think you are, because Bluford was much stronger, the jury never acted on any of these things that the jurors came forward, quote unquote, to say after the trial, and therefore there was no verdict. And there was simply no act here that could be considered a ruling or characterized as an acquittal. And a ruling is quoted there because it means a verdict, because it's really a ruling on the whether the prosecution had met its burden, but it really is the word verdict. The First Circuit also concluded that the post-trial hearing requested by Reed would not be appropriate. Yeah, Judge Saylor said it was illegal, potentially illegal, because the content of jury deliberations is typically kept secret to enable jurors to discuss their views freely and frankly, and to protect them from harassment. Yeah, that's the part that is very, very important, and why the Supreme Court's never going to look at this. It's not just that Reed wanted jury deliberations reopened. It's that part of her argument was that there'd need to be a post-trial voir dire to do that, and no court anywhere is ever going to allow that, except for if you make an allegation of invidious racial discrimination by jurors towards the defendant or a witness or something. Then maybe you can get there, but Reed did not make that argument. Reed is facing re-prosecution, starting with jury selection on April 1st, 2025. Yeah, that's going on right now. By the same prosecutor for the very same offenses. Yeah, that's what a retrial is. Murder, OUI manslaughter, did you forget that? And leaving the scene. Despite powerful evidence that the jury in her prior trial found her not guilty. No, there is no powerful evidence of that, because they never affirmed such a thing in open court or even said such a thing in open court at any point in time. An application for stay of state court proceedings pending disposition of this petition for certiorari has been filed contemporaneously herewith. No, what? You already, when did you file this, Marty Weinberg? Hold on, we're going down to, we're almost done. Well, we're like halfway done, but my point is, when did you file this? Where's the certificate of service? Where's the date? Do you put the date up at the top in a Supreme Court pleading? Oh, okay. So was that when you petitioned for stay? Did you try another petition for stay? Because you already petitioned the lower court for stay, and that was denied. The First Circuit Court of Appeals. Did you file another petition for stay with the Supreme Court? They are not going to stay your state court proceedings, Mr. Weinberg. So we were right at the end of the... Hold on. Did you actually try to stay the state court proceedings with SCOTUS? Hold on. We're going to look at this. We're going to check the docket. SCOTUS docket. Now you might be wondering, Grant, how do you even check the Supreme Court docket? Well, unlike other dockets, but on the federal docket, the Supreme Court docket is actually somewhat accessible. So here I'll show you all what to do. Hold on one second. So you grab the Supreme Court website there. This is how I got this document actually. So I'll empower you all and show you how to do things like this in the future. So you bring the Supreme Court docket up, and here we're just going to search for Kierney Reed. And look at that, right up at the top, right? We get this 24-1048. Now we're going to go ahead and open that up. And what do we see when we do that? We see the full docket. Now, what do we see on the docket? It looks like there's no... petition for stay at the Supreme Court that I'm seeing, maybe because there was petitions for stay at the lower court, both were denied. I'm not seeing anything here that looks like a petition for stay of the lower court. I'm not saying that it's impossible that it's not here, but this could be when did the First Circuit ruled a while ago. I want to say it was last week. So what is Weinberg talking about? Very interesting. Maybe it's separate? Well, I'm going to do some more research into that. Whether there's a stay submitted to the Supreme Court, it's not going to be granted because obviously neither of the lower court stays were granted. But what I want to do right now is let's pause before we do the argument section to, one, take a look at what the atmosphere at court was like yesterday, because I promised you all we would review that. And I realized I didn't even spend any time with you all yesterday when we were after I was down at the courthouse. So I didn't get a chance to talk to you all about what it was like to see Hank Brennan leaving the court, what it was like to see Kierney Reed leaving the court. Karen Reed actually stuck her tongue out at one point walking down the stairs and looked over at me. It was a little weird. I was like, why are you sticking your tongue out at me, strange woman? And stop looking in my soul. But very weird look, actually. She gives me weird looks sometimes. Like, I can't tell if she's, like, intrigued by my intelligence or, like, perplexed, like she can't figure me out or what. But I'm not, that road is never being explored. I will talk to her and do an interview with her, but I have no desire to know Karen Reed. SD can hang out with Karen Reed. I don't want to hang out with Karen Reed. I like SD, actually. This is one of the folks who sits with Karen in court, one of Karen's friends. I think SD's very nice. Some people are like, Grant, why are you so nice to SD? SD's, says things that I don't agree with. And I'm like, SD can say whatever she wants. I personally have no reason to dislike her. I think she's just fine. We disagree strongly on the Karen Reed case, but I have no reason to dislike SD. If anything, SD's very nice to me. Sometimes I wonder, though, if the Karen Reed fans is just like, this towel is both endearing, but also, like, why does he have to believe what he believes? Like, why can't he just believe what we believe? Like, then we'd like him even more. Like, we don't have to agree on the case for you to, listen to what I'm, for you to like me as a person. Like, all right, so let's take a look at this right here. Let's take a look at Hank Brennan leaving the court. We're taking a little pause from reading the Karen Reed petition for a writ of certiorari. Let's take a look at this. I think I might even be able to give you a full screen view. Yeah, that's all right.
Morning, how are you? Good afternoon. How are you today? The weather hasn't warmed up at all since you were out. Yeah.
Good luck, Miss Brennan.
What about those Red Sox?
Opening day.
Quite confident there for Mr. Brennan. You can see the troopers kind of following him. No one was going to follow Hank Brennan. Now, if you're wondering, Grant, how many Karen Reed fans were there yesterday when you were at court? Why did 25,000 of you watch this video of two of the Karen Reed fans? There were two of them. You can see, nice guy there, actually, in the pink sweatshirt with the fan. I like him, with the flag. He didn't have his dog with him, though. He normally does. I hope his dog's okay. He's a nice guy, though. He always shakes my hand. I didn't know the guy in black, but that was it. And that was at about 3 p.m. yesterday, folks. You're looking at yesterday's Karen Reed hearing right as the day was ending and Karen was about ready to leave. That was it. And they were kind of inside the buffer zone, too. But they were basically at the edge. They were hanging out. They weren't bothering anyone. What I did hear, though, I talked to some people who were around yesterday. And what I heard was there were a few Karen Reed fans, only about 10 of them or so, 5 to 10, that were around at one point, and they were kind of trying to, like, jump up and down or whatnot, like, to get the attention of jurors and whatnot. That behavior was put a stop to quickly. Now, let's take a look, if you want to see why the atmosphere is so kind of tense and hostile. Before we take a look at Karen walking out of court yesterday, let's take a look at what it was like to for the buffer, in terms of the buffer zone, how the Karen Reed fans were treated. And then I want to show you how some streamers were treated when they would try to stop in the buffer zone. And then I want to explain to you why I think those streamers were treated that way after having spent some time on the ground yesterday. And I think I put it all together, because those of us who were allowed to stand around at the base of the stairs were definitely credentialed media who were subject to the rule that we cannot film jurors, whereas the people who were not allowed to stand around were non-credentialed media who definitely were trying to film jurors. Like, and those of us who were standing around, you could tell, like, as MSP and whatnot knew that we were the type of people who would not at any point in time film jurors, talk to jurors, bother jurors, and that's why we were allowed to be in the buffer zone. But let's take a look at what happened when Tommy CPU, who, again, we don't agree on the Karen Reed case, but I think Tommy's fine. You know, he's never done anything to me, never, in terms of, he sometimes, like, will critique me and be like, why does Grant hold this view or whatever, but I like Tommy. I always shake his hand. I think he's fine. As far as I'm concerned, Tommy is an agreeable human when I speak to him. But you can see how Tom CPU, one of the Karen Reed streamers who followed Karen to her car every day during the trial, who has been there for years, who would normally stand around even in the first trial in the buffer zone without any of his insignia on, just standing there filming. Look what happened when he tried to go stand at the base of the stairs on the first day or second day maybe of jury trial, of jury impanelment for Karen Reed's retrial. Hold on 1 second. Hold on. Live video editing. Just Towel. Towel actually has an editor, but Towel's editor does not like doing video streaming. All right, let's watch.
I'm gonna hang around with these other guys here.
Yeah, hit that smash and like button today, guys. Helps a lot.
Please.
Yeah.
Yes, sir.
You don't have media credentials, you gotta go behind the buffer zone, okay, or you're gonna be subject to arrest. Go follow them.
Okay.
You're being told right now, and you're live, and you're being recorded.
Yeah.
Go ahead.
So, I'm not media.
No, you're not. Go back there, you're being subject to being arrested.
Can I come when she comes into court? Can I follow her?
No, you can't.
Not even, I can't, I have to go outside the buffer forever.
No, you can't. You, go.
Have a good day, sir. It is. Okay.
Jesus Christ.
I'm not allowed to walk through this buffer zone during the trial. Actually, when trial's in session, it's what it says on the paper. I can't even go to the registry of deeds. Nope. I'm not even, I have nothing, you have nothing, like that's Boston Red Sox, that's not offensive. Wow.
They told them to leave too?
Yep.
Oh, he's not playing around today, bro.
Pretty interesting. So this is the registry of deeds building across it here. Again, this is where most.
All right, we're going to a second clip now. Now, let me just tell you, this situation was a little more concerning because so Scott is not the problem. The guy in front, Scott he knows what to do. Like, he just goes about his business. But the guy behind him, he does a few trips through the buffer zone that had got him in trouble. But this first one, I don't know if it's the cameraman or the guy behind him. We're going to see a state cop actually rip the button the guy was wearing off and tell them they had walked through 5 times and they were clearly trying to circumvent the intent of the buffer zone. This is where it started to get a little intense. This was 2 days ago.
So the jurors queue up, we think.
Actually, this may have been yesterday morning, Wednesday morning.
Yeah. Okay. All right.
We're gonna check out with the other lines.
That's gotta go.
Which trooper is that? Hold on 1 second. Is that the trooper? Is that trooper? I can't tell if that's Sergeant Hardman. But yeah, no, I mean that's. You can tell the state police were not going to put up with any attempts to skirt the intent. You want to talk about substance versus form, Marty Weinberg? The state police were not going to put up with any efforts to undermine the form of the buffer zone. And this is what you're seeing. This is how it was enforced. And the context here is we're going to take you back to my clip from yesterday. This was actually 2 days ago. We're going to take you back from my clip to yesterday in a few minutes here. But just if you want to know why it's so eerie to be around the Reed trial, it's very ominous. It's very strange. It's because right away on day one, the state police were enforcing the buffer zone. So it is a whole different world out there right now. Also, by the way, if you're just joining, my name's GrantSmithEllis. We're about halfway through Karen Reed's petition for a writ of certiorari to the U.S. Supreme Court. It's not a very good argument. We're learning a lot about how to write well-formatted petitions for writs of certiorari to the Supreme Court. I don't know if we're ever going to need to deploy that knowledge collectively as towels. or washcloths, or soap dispensers, or flannels, or paper towels, or hemp towels, or whatever type of towel or fabric you are. We've expanded the towel universe to include basically anything that's made of any kind of fabric. If it can function as a towel, washcloths included, you are welcome into the towel fold. In fact, you can probably become an anthropomorphic soap dispenser, as someone did, and still be included as a towel. I think we're going to cause some kind of intra-textile war here if we just decide that every single thing in the entire world is a towel. But, that's a debate for another day. It's like, is a hot dog a sandwich, but on a whole nother level. All right, but my point is, you're watching us read through the Kierney and Reed petition for a writ of certiorari to the Supreme Court, and we are taking a slight break to talk about the very new, very interesting, very ominous dynamics of the Kierney and Reed trial buffer zone as things stand right now. And then we're going to watch Towel's clip of Kierney and Reed leaving court yesterday and talk about how, even for the media, those of us who are allowed to stand around in the buffer zone, which you will see Towel doing so yesterday in these next clips, it is not pleasant to be there. It is scary. You can't really walk anywhere when Karen's leaving. You have to stand in one spot. When trial's in session, there is no one around. There's no Kierney and Reed people. It's just empty. So it's a very different dynamic, and we're going to see why it's a different dynamic as a result of these buffer zone backoffs that occurred on the first day. So we're just getting caught up, giving Towel a little bit of a chance to stop reading Supreme Court petitions as we watch these videos, and then I'm going to read some of your comments and questions.
You don't walk into it. I don't want to see you walking by here against a good time. Okay?
Karen, how are you feeling this morning?
All right, that was Karen walking in. No supporters. Very ominous. Very ominous. So with that in mind, right, let's take a look at what happened so we saw, let's watch the pickle chip clip. By the way, let me just tell you, this pickle chip clip say that 20 times fast, pickle chip clip. This pickle chip clip of Kierney and Reed walking in from lunch on that first day while eating pickle chips and spewing them over the Inside Edition camera or microphone. Let me just tell you, I was being my towel self and just walking around talking to people. That was the talk of the whole area. All people wanted to talk about that on Wednesday was the pickle chip clip. The people were saying, I was sent here today by my boss to cover this because of the pickle chip clip. I just can't believe that is what was of interest to the powers that be in the media establishment. The fact that Kierney and Reed ate pickle chips and spewed it over the media while walking into court from lunch. By the way, Wednesday, Karen didn't take lunch. She took lunch inside the court. She didn't leave or walk out. That was weird. This was Tuesday. Let's watch the now infamous pickle chip clip. Credit to David Bienick from WCVB.
Karen, how does it feel to be back? It doesn't feel great to be back, but I'm here. We're fighting. We'll keep fighting. I feel strong, so I feel good.
How do you feel about the former juror who's actually on your team now?
I'm sorry that I have these pickle chips in my mouth, but I feel just another resource. How did this land? How did even jury selection go for the jurors, the prospective jurors? So just another resource that we're utilizing.
Yeah. What does it mean to you to have her a part of your team?
I just feel lucky. I'm not paying any of these people. They're not asking for anything. They're spending time away from their children, and my lawyers are mentioning for me to come back into the...
What feels different this time around?
Sorry.
Very telling indeed. Very telling indeed. Also, wow, just realizing I was just checking out social media and scrolling, the number of violations of active court orders that are flying around right now, it's absolutely mind-blowing. There's some stuff coming I don't think people are even really ready for. Just blows my mind. Not just the buffer zone order, the contempt for that, but the contempt for other active court orders. It's almost like people think there are no consequences for such blatant violations. And I think with the buffer zone in particular, we're starting to see those consequences, but there could be far more. This is a very intense situation now that I think about it, with Aidan Kierney potentially on the verge of being offered compelled immunity or being forced to accept compelled immunity to testify against Kierney and Reed. There are so many factors at play here right now. I'm scrolling through, obviously, and catching up on all my own updates. But let's take a look at what it was like when Kierney and Reed walked out of court in light of this new buffer zone, which is just, I mean, absolutely overwhelming. It's almost impossible to explain what this was like yesterday.
What's the statement?
I mean, there have been some moments like this in previous hearings when things would get very intense, but from the very outset being told, it was not just, oh, please don't follow Karen. It was an explicit instruction that we were not to, and then it was not an option, as you watch when I pan to the left. I didn't intend on going anywhere. But those other people in the media, they wanted to track Karen. They were not necessarily happy to go along with that request, and they were not given an option because we got absolutely penned in.
Ms. Reed, they've asked us not the cases. Can you just give us a statement?
Are you happy with the progress?
With you today.
Oh, wow. Unrelated to this video, I just put together, I think, what's going on. I was like, why are people why are there open violations of court orders going on social media? I'm not going to get into the context right now, but I was like, the only reason that Aidan Kierney could be openly violating a no contact order, the only reason he could potentially be doing that, according to what people are saying, wow, I mean, that's explosive. If that's what's coming, I mean, wow. All right, hold on. Tal's got to process some of that. Let's watch this clip again, though. Look at the intensity of this scene. We were not allowed. I want to just say, that is the Dateline producer, okay, right there. She thought she was going to be sly and I think try to walk. I don't know if she actually was trying to, but watch what happens. And these are national media.
Progress with you today.
Watch what happens when that Dateline producer tries to walk. Nope. I mean, we weren't going anywhere. And then you can see, I knew where the line was because those two, the cops did not have to tell me I couldn't go past them. I knew that they were telling me they were telling us that was the line. So I then paused. And then I zoom in. I didn't even have to test it because I knew. And the guys next to me, the much better professional photographers and cameras, they realized too, as we're over my shoulder.
I think that means you guys don't even have to be here tomorrow.
Where's Hardman?
But yeah, that was not. It was very gentle. They didn't scream at us, but it was a message that we were not going down there with them.
He's in the helicopter.
So, I mean, you can see them just kind of standing around, but the point is that was very ominous. The whole thing was ominous. And then later I was able to report per towel sources, it was Alan Jackson himself who requested the entire media apparatus be penned in at the base of the court stairs for the duration of the Kierney and Reed and John O'Keefe trial. So we can't, no media, whether national or local, will be following Kierney and Reed to the car. All right, but let's get back to this petition for writ of certiorari. We had a very interesting time. I corrected someone. Someone was like, Hank Brennan, why are you calling Hank Brennan a good person? He tell that to Whitey's victims and their families. Let's listen, by the way, while Tel's taking his short break from the petition for the writ of certiorari. What do you think Whitey's victims thought about Hank Brennan, who, during, as a little preview, during the Whitey Bulger trial, crossed Frank Cadillac Salemi and got basically Salemi to answer questions that were very incriminating towards Bulger, but exposed the FBI, basically enabling Bulger and his cronies for years, at Bulger's expense. And then this was the response from the victim's family.
One of the oddities of this was to see Stephen Davis and other members of families of victims embracing you and Jay Carney today, and yet here you were representing the man who killed their loved ones. What was that like for you to have them almost siding with you in a sense? Not that they didn't want to see the government, convict them, prosecute them, and convict them, but they really credit you with bringing out the government part of the corruption.
Well, we expect our criminals to commit crimes. That's what criminals do. We don't expect that from our law enforcement. And so having a very unique opportunity, Jake Carney and I had the ability and the invitation to do anything we could to try to help find the truth and expose what the government had done. And the government had done a number of things that we don't expect from our government. They not only created victims, but they continued to victimize the victims by denying their responsibility. When we started this case, the effort was at the most important part to help show the role the government played in this entire conspiracy. It was a very liberating experience as a defense attorney to be able to ask questions of witnesses, which in times could implicate our own client, and we did at many points, but also help other people. And I felt the presence of Patricia Donahue and the Donahue family and the Davises behind me every day. I didn't always see them when my back was to them, but I felt their presence, and I knew that what Jay and I, Carney, were doing had some import, not just for our client, but for the community, for particular victims, and also for the public.
Folks, that's the kind of man who, it almost inspires me. That is the kind of man who, regardless of what side of a case he's on, is not going to look the other way as to misconduct. Innocent victims thrown into the middle inadvertently of a proxy war between the Boston DOJ and the Norfolk DA, just thrown to the wolves. And in that context, folks, let's talk a little bit about why Hank Brennan has a statutory right to offer Aidan Kierney, against Aidan Kierney's will, immunity. And you know what happens if Mr. Aidan Kierney is compelled to take immunity in the Kierney and Reed case? Well, a few things are going to happen. One, the victims in Kierney's cases are going to be completely forsaken. And two, I don't know if you're seeing this, but I'll read it for you. Aidan Kierney has submitted a court document on the record that I don't think he wants a lot of people to know about, because he did post it, but he hid this part. I wouldn't say he hid it. He didn't lead with this. It was in the very bottom of the document. Can you folks tell me what type of person ahead of a trial, before they get called to the stand, announces their intention that they're going to assert the fifth and then not answer any questions if called as a witness? Isn't it a little weird that the immunity statute in Massachusetts, the compelled grant of immunity statute, allows a prosecutor who has evidence or reason to believe that a witness is going to invoke such a Fifth Amendment privilege and refuse to answer questions, can preemptively give that witness what's called compelled immunity, where a judge issues an order stripping that witness of their ability to invoke the fifth if the prosecutor gives them immunity from charges related to those crimes? Are folks starting to think that maybe Aidan Kierney can make all of his criminal charges go away by cooperating against Kierney and Reed? That's Occam's razor. And I don't think Aidan Kierney wants people to know this. In my opinion, there's something building here where Aidan Kierney is going to be given this compelled immunity in such a way where he can present it to his fans as, oh, I was forced to testify. The state gave me immunity. I had to testify. I had to say what I told Karen because they gave me no way to take the fifth, and they gave me a good deal. Do you understand that? I think what's coming? I'm horrified. And I think Hank Brennan, as confident as this man is, and it kind of sucks because it shouldn't be this way. Well, it should be this way. Hank Brennan should be making this decision independent of the interest of any given faction, and Hank Brennan should be making this decision in the interest of the justice system. But there is so much. If Hank Brennan really cares about the justice system, if Hank Brennan believes what he said when representing Whitey Bulger about the importance of, even when representing your client, being willing to go to bat for the most vulnerable, even if it's damaging to one's case, if Hank Brennan really believes that, then I can only imagine that this man is tormented at night by the decision he is probably having to make right now over the next few weeks about what to do with Aidan Kierney. Because are people like Colin Albert and Lindsay Gattani, as intelligent and special as they are in their own ways, are at the end of the day, they're just regular human beings going about their life? In some sense, yes, regardless of their skills. Lindsay with her reporting, Colin with his sort of, I think Colin's just a great person. He's young and still growing, but Colin with his sort of love for life and just, they're each special in their own ways. But are they political figures? No. Do they command a lot of sort of influence among the powers that be? No. They're just humans. And those voices and those stories and that suffering, I don't think necessarily will be able to be honored in the tactical posture of the current approach to Karen Reed's retrial. Because I think what will really seal it is Aidan Kierney testifying against Karen Reed, whether through cooperation or the compelled grant of immunity. But there's only one way that happens, folks. And that's if everything facing Aidan Kierney goes away. That's the price that I think the state of Massachusetts is going to have to pay for Karen Reed's conviction. And you can say all you want, the evidence is so strong against Karen Reed. It is. It is very strong. But it only takes a turtle rider or two. And I think that's why Aidan Kierney is really using Karen as leverage here. It only takes a turtle rider or two to tank that juror. Not a Karen Reed fan or two to tank that jury, a turtle rider. So what happens if you got Turtle Boy himself up there as the person testifying against Karen Reed? Well, you got a very bad situation for Karen Reed. All right, towel's going back to the Karen Reed federal petition for cert. We are going to finish reading this. I'm not going to forsake you. I cannot believe so many of you towel friends are still hanging around. I would like to think that you towel friends are interested in this petition for cert, but I know that most of you just wanted to find out from the initial overview if I thought Karen stood a chance, and very quickly we all came to find out that Karen does not stand a chance. All right, but as promised, let me get caught up, because we went on a digression about Boston accents, we went on a digression about the overall vibe of the Karen Reed trial, and now I'm going to follow up with some of your comments. And I am so far behind on comments, there's no guarantee at all that I'm going to be caught up. Let's see. Someone said that's not going to last on the video. Jack65, can you give me a little context? What specifically? Oh my goodness. You all have so much to say. In fact, I'm going to try to just caught up. Linguistic experts say the South Boston accent is dying out. Sad. Yeah, a lot of the different accents are dying out from around Boston. I'm glad Lally called so many witnesses. There were many different Boston accents. Love the boyfriend from South Boston, Tristan, or Tristan Thomas or something. He had a good accent. Yeah, there are, and don't get me wrong, I was talking earlier about how the origin of the Boston accent is a little bit more like interpolated aristocratic British. The actual working class Boston accent is an even more interesting interpolation on that. It's definitely like, it's a form of mockery, but also like a way for the working class to participate in that kind of world. It's definitely a refined style of speaking, even though it's very lazy. And it's not lazy gratuitously. I think it's lazy as a way to make a point. Bill Bryson has an amazing book about accents in England called The Mother Tongue. Massively recommend it. I'm going to get the audiobook, Murder by Maestro. Thank you for that recommendation. Yeah, that's the Kennedy type accent. Yeah, for sure, Jack D65. That was the Mayor Quimby in Simpsons. Definitely that style. What accent does Tom CPU have? Tommy? Like South Shore? Yeah, South Shore-ish. I think Brennan sounds like a Kennedy, but I'm from the Midwest. Hank Brennan, where is he from? I didn't actually look up where he's from. He has like an Ivy League kind of accent. It's very posh, but it's also erudite. So it definitely is from around this area, but more like Cambridge. I love the way Judge Canoni says department. Does she say it department? Down the department store? Gotta go down Jordan Marsh. Tom CPU's accent is some... Okay, Chippo. Good to see you. Kerry Gold, that's right. My accent is close to Cockney, says Murder by Maestro. Does anyone know who's playing lodging, flights, and food for the defense? The defense fund of $800K? Well, I don't know. Yeah, they have to pay their experts out of that. I don't even know if Karen has money left in that fund. We folks from Wichita have accents. Oh, Worcester. Good old Worcester. Go to Peabody, Scituate, Leicester. We have a Leicester, actually. I think they call it Leicester. I call it Leicester. Sound like my parents' accents. Yeah, even old school Boston. My granddad was full on Cockney. Everyone calling everyone chief or darling. Angela, we have Irish in my family. My auntie, I'm English, half Italian, crazy. Yeah, my family's half Jewish and half Italian. So I have this interesting sort of mix of different sides of the family, and very, very interesting. I think that's why I don't really have an accent. I think I would have had closer to a maybe Newton-style Italian accent, but I was also raised by a Jewish family, and so that accent, I wouldn't even say that side of the family had an accent. It was more highbrow intellectual conversations, so I think that's really where my speaking style comes from, a little bit of both. The hardest accent to properly mimic for actors is Philly. Oh, I didn't know that. Are you going to cover TB pleading the fifth, Pilgrim Shadow? Wow, how prescient you were, sir, Pilgrim Shadow. We certainly got to cover TB pleading the fifth, and I think very likely that is going to be a big, big component of the Karen Reed trial. Wait, the dismissed juror, today, 3:30. I have to drive home. Please someone ask if he doesn't address it later. Oh, I'm going to try to find out what's going on with the dismissed juror. Enjoy your ride home. A lot of people are rude to me. That's okay, Lazy Susan. I try to rise above. Yes, it will be good for the families and witnesses to walk in court. Yeah, that true in particular, because even though the witnesses didn't have to deal with the Karen Reed protesters, they definitely were dealing with sort of like the mob of people recording around the court. Now listen, I will also explain, I think what was going on with the buffer zone is it's not just the Reed fans were taking advantage of it. It's that I think some people were trying to film jurors who weren't, like, obviously people who weren't credentialed media, who either don't know the rules or don't care about the rules. That's what I think this big issue is. It's not just the Reed fans being in the buffer zone. It's easy enough for the state police to deal with that. It's that you had these streamers, and I'm not going to fully go into it, but I have reason to believe there were these streamers walking around, and what they were really trying to do was actually film the juror pool going in and out of the court. They weren't saying it that way. They were framing it as coverage of the Reed case, but they were clearly trying to film jurors. And it is certainly interesting to think about. Let's see. The first trial was shady all around. Yeah, I agree, Maui Swift. I don't believe that is true about count one. I agree, B. Chance. I don't think anything that the jurors were, or the ostensible informants were trying to report about Reed's first trial were true. I think at best there was some kind of compromise that the foreperson was trying to figure out where, okay, if we feel that she's guilty on OUI manslaughter, maybe we'll agree to only vote guilty on that count. But again, that is very normal. That's called a compromise verdict. It doesn't actually mean that every juror was voting that Karen Reed was not guilty on count 1 and 3. It means there may have been some kind of agreement where jurors said, okay, well, I feel comfortable voting yes on count 2, and then other jurors saying, oh, okay, so if we're going to convict her on that, does that mean you'd be okay with just agreeing to not guilty on count 1 as a way to just, compromise and get this get a verdict, some kind of verdict that's not hung jury all around? That's most likely what happened, but none of the jurors who, quote, came forward were actually saying that. They were taking out of context one sliver, one very quick snapshot in time of what the jury was talking about and presenting it as some kind of conclusion. That's why this federal appeal is so weak and so pointless, because it's not just that it's anonymous hearsay reports. It's that it doesn't matter if the jury had reached some kind of compromise verdict. The whole reason the jurors have to come out and affirm a verdict of any kind, even if it's a hung jury via a note, is it has to be read in court, the decision, this is a mistrial, okay, then all the jurors stand there, they can object, they can say something in those moments. None of them did. They all left. That's why it's such a weak federal appeal. Oh, so many towel friends. Macy, great to see you again. I think the defense is charging up the optics in an attempt to make her seem less joyful as she enters and exits the courtroom. Yeah, I mean, I don't know exactly what the defense is trying to do here with their plan. Like, obviously the lawyers are gagged, Yannetti and Jackson, but why keep her away? Why keep them away? It's just a very interesting sort of situation. Let's see. Karen is no longer walking the red carpet as a celebrity. That's true. Yannetti knows she's guilty, says Pilgrim Shadow. I have some sense that David Yannetti may have culpability. I think David Yannetti has reason to know Karen Reed struck John O'Keefe with her car. And listen, you can't put a client on the stand to lie, but as long as he didn't ask her directly, like, are you guilty? And as long as she didn't say that, like, he can represent her even if he has inklings. Let's see. Someone is apparently laughing. I forget what I was talking about at that point. I wonder if it was Chewbacca. 6 degrees. Oh, yep, there we go. 6 degrees of Chewbacca. I knew this Chewbacca motif was going to come up over and over and over again. All right. Yesterday was nipple cult. Oh, and today is Chewbacca gate. Yes, I will never forget yesterday morning when we were watching the beginning of the Karen Reed jury impanelment, and all of a sudden, out of nowhere, one of the Karen Reed streams, a very jolly man in a green sweatshirt, had a nipple on his stream under his head. And so we spent a good 20 minutes trying to figure out if this nipple had some kind of esoteric meaning to the Free Karen Reed fans. We've decided that they are in a cult that worships the nipple, and then also now we've decided that Karen Reed's entire defense is going to be based around Chewbacca. Happy 420, Grant, says Electric City Audits. Thanks very much for being here. Appreciate you wishing me a happy 420. I'm a fan of people celebrate. I don't know if it's actually 420. It's closer to 720 where I am, but that's okay. 710 is also its own thing. None of them have ever said these things under oath. That's true. A lot of Karen's witnesses or Karen's own statements to the media, she doesn't say them under oath. She's never actually testified. She never will testify, and that's for a reason. Hopefully Hank makes a montage of Karen's interviews, inconsistencies in closing. Good suggestion. I think Hank Brennan is going to enjoy presenting this evidence against Karen. I've lost confidence in the average person, and that's who the jury is made up of. Yeah, Jack D, but also if you want to regain your confidence, watch the movie 12 Angry Men. All right. Let's see. I'm not. Where are these docs? Ed Jobs. This is the petition for writ of certiorari that Kierney and Reed literally just filed. So we are taking a look at it now. Hank will hire a team to go through all jurors' socials. He's on it. We must have faith. Hank knows. Oh, right. And so that's the other thing. The defense can do all the research they want, but the state has to do their research too. And if the state, after jurors are seated, finds out any information that indicates jurors might not have been fully forthcoming, I can assure you that juror potentially will be removed. And that's what we could have heard reported today, although I didn't actually get to see what John DePetro has reported. There might have been a juror who was seated that after a subsequent criminal records check or something along those lines was removed for not disclosing that. So, as a result, let's take a look at a little bit more of this federal appeal. Oh, actually, I was catching up on comments. It's so funny. I say to myself, these comments are going to distract me, and then I go down the comment rabbit hole, and it's an hour later, and we have not made any progress on the documents. But I appreciate you indulging me. Still waiting for the 7-Eleven sponsorship. All right, back to the federal habeas appeal. Come on now, folks. As much as Towell loves talking to you all, I think it is somewhat important that we read through the federal habeas appeal. It is actually a federal habeas appeal because Karen's petition for a writ of habeas got denied at both the lower federal court in Boston and the Federal Circuit Court of Appeal. If you're just joining, we're about 13 pages into Karen's petition for a writ of certiorari to the Supreme Court, appealing her mistrial, and we are taking a look at why these arguments are so weak. And then this is also interspersed with Towell reading hundreds and hundreds and hundreds of comments on YouTube, which is a little bit, Towell is mentioning it leads to Towell going on random rabbit holes and tangents, but also we end up covering all sorts of information about the case, and you pry information from Towell's brain somehow that I'm sure is relevant to either some percentage of you or all of you in some way, and for that reason I'm very happy to answer your questions and read your comments. Also, Towell is extremely grateful for those of you who've been keeping Towell's family member in their thoughts. Towell, I know you hear a lot about me and my struggles that I've gone through health-wise, but this is the first time that I've sort of, throughout the coverage of this with you all, that something has happened to a family member of mine who is very sick, and I have them in my thoughts, and as I read through the comments, I notice some of you have been leaving prayers for them and kind thoughts, and I appreciate that. And this stream is definitely in honor of them tonight. I think that's why I'm a little bit, although I'm getting through the document, I'm a little bit more just talking to you all. It's hard for me to cope with the news that I got. It was actually a little bit earlier this week. But with you all and talking it through, and I don't want to just lose myself in my work and distract my brain from what's going on. But being here with you all and being able to talk with you all, I appreciate it. And I hope you'll give me some grace. It's taken us a little bit longer than normal. Although I will say sometimes we go for 6 hours reading 50-page documents. So 3 hours to get through a 25-page document isn't necessarily the worst thing in the entire world. But yes, it means a lot to me to be able to talk through with you all. And I don't want to use it as a distraction. That was my point there. I don't want to just come on here and pretend like my family member being very sick doesn't bother me. It is very traumatizing. But I also, and so I don't want to just come on here and talk about these documents and completely ignore that. But I also don't want to continue to distract, and I won't use it as a distraction. I will focus on what we're here to talk about. I'll probably like, I've never seen Towell so discombobulated. Well, Towell's a human too. Towell is a human too. The First Circuit's ruling conflicts. So now we're looking at reasons why the writ should be granted. Oh, this is helping me understand my own assignment a little bit more. I appreciate this, Marty Weinberg. You know, one thing about this is reading these briefs, you're not actually getting it taught to you. Obviously, I'm trying to help, but I'm not a lawyer. I'm just a Towell. But reading Marty Weinberg's construction of this brief is actually extremely helpful for Towell. it teaches me a lot about how to convince the Supreme Court you have a good argument. I never intend on arguing in front of the Supreme Court or writing a motion to or brief or petition to the Supreme Court, but I really appreciate how Marty Weinberg structures this document. It has to be structured this way. Reasons why the writ should be granted. The First Circuit's ruling conflicts with this court's double jeopardy case law, including its consistent emphasis on substance over form in determining what constitutes an acquittal. So that's Marty Weinberg's thing. The Supreme Court, he has to, unlike the lower courts where he had an automatic right of appeal, here he doesn't have an automatic right of appeal. He's got to catch 4 justices' attention. One of the best ways, he doesn't have a split in the circuit. So normally the way you'd do this is you'd say, this is a novel question of law because circuit, like the Fifth Circuit has ruled one way, the Ninth Circuit has ruled another. This is the most common way a case gets up to the Supreme Court. There's a split in the circuits on the issue, and then the lawyer presents to the Supreme Court, here's a case where one circuit would decide it one way, another circuit would decide it another. You, Supreme Court, should resolve the circuit split by using this case as the vehicle to do it. Weinberg doesn't have that option here. There's no split in the circuits. The Bluford and Tanner v. U.S., it's all very clear. There's no split in the circuits. It's all SCOTUS holdings. So what Weinberg has to do is say, instead, it's not that the First Circuit is split with another circuit interpreting Bluford. Weinberg has to make the argument that the First Circuit misinterpreted Bluford, because that is another hook for Supreme Court review, saying that you, Supreme Court, wrote a decision that instructed the lower courts to act a certain way, and in this specific case, the First Circuit did not apply the standard correctly. Now, that is just wrong. Marty Weinberg is wrong about that, but we'll read it. As this court recently affirmed, the ancient right to... Oh, no. If you go back to the Stuart Kings and Arizona v. Washington again, Mr. Weinberg. As this court recently affirmed, the ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. Erlinger v. United States. All right. Well, we didn't go back to the Stuart Kings, so we're starting off on a good foot. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct. Prominent among the reasons colonialists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. Oh, God, we're doing a history lesson. As John Adams puts it, well, that one came out of left field. Marty Weinberg was like, Grant appreciated my Stuart Kings reference. Now I shall cite John Adams. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. You actually quoted a letter from John Adams. Marty Weinberg. That's a new one. I am shocked that the Supreme Court rules allow for quoting of letters from John Adams. Is there a specific rule in the citation book? If you want to quote a letter from John Adams, you shall style the citation as such. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Yeah, that's true, but Karen wasn't acquitted. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence, according to Martin Linen Supply Co., has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. The jury's overriding responsibility is to stand between the accused and a potentially arbitrary or abusive government that is in command of the criminal sanction. The jury is a necessary check on governmental power and a tangible implementation of the principle that the law comes from the people. One of the central benefits of a right to a trial before an impartial jury is that if the jury acquits, the sovereign cannot re-prosecute. Well, yeah, but there was no acquittal here. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb, citing Bluford. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state with all of its resources and power should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Green v. U.S. At heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Bluford. What constitutes an acquittal is not to be controlled by the form of the action in question. This is this is Weinberg's only argument. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the charge offense. So he found it in Martin Linden Supply Co., which is quoted in McElrath. Labels, including those provided by state law, do not control the analysis. Here, yeah, but this was already examined by the First Circuit, and it's not about the labels. It's about the fact that they didn't announce in open court a verdict. Here, the affidavits by attorneys Jackson and Unetti reflect post-trial statements by 4 deliberating jurors that the jury had reached a final unanimous conclusion that Reed is not guilty of counts 1 and 3, and that indirect statements by a 5th juror that they had agreed with respect to count 1. A call by one juror to the prosecutor himself corroborated the trustworthiness of these representations. Both the trial court and the SJC, for purposes of ruling on the double jeopardy issue, proceeded from the assumption that the affidavits were accurate. Neither the Commonwealth nor respondents ever challenged the authenticity or accuracy of the juror statements, despite many opportunities to do so. And we know why, and it's because the ruling was over and over and over again, that it doesn't matter what the jurors say after the fact. If there was no verdict in open court, then there was no acquittal, there was no verdict. There was nothing tentative about the juror statements. Everything about anonymous hearsay statements is per se tentative. To the contrary, who is they? These anonymous people were definitive in describing the result of the jury's deliberation. Juror A was emphatic that count 1 was off the table, and then all 12 of the jurors were in agreement that he was not guilty of such a crime. Reflecting text message from Juror B, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. Without Juror D, without hesitation, said in substance, every one of us agreed, etc. So now Weinberg here, he's pulling the facts that are best for his argument, but the reality is there was a lot of inconsistencies in the juror statements, and he's just going to completely ignore that. Especially about what the vote count was on count 2, 8-4 versus 6-6, 6-6 evolving to 8-4 to 9-3. Directly undermines his argument. And remember, there's no response here. A petition for a writ of certiorari, we won't read a response from the state. This is it. This is the culmination of every part of Karen's appeal. This is the last document that we will see submitted, and then there will be a denial of the petition for cert. So, in some sense, the Supreme Court won't even get to read a rebuttal unless they order arguments, which they will not. But the Supreme Court's going to see through this, in my opinion. That right up earlier in the pleading, Weinberg he wasn't pointing it out, but he was demonstrating there were inconsistencies in these juror statements. And now he's saying, but look at the consistency. Doesn't that go to my argument? And I mean, we're trying to read this, by the way. This is Karen Reed's petition for a writ of cert. We're doing our best to read this from the perspective of a Supreme Court justice or a clerk who knows nothing about the Reed case and is just reading Marty Weinberg. Yeah, the justices are going to read the appellate pleadings. They're going to read the Judge Saylor's decision and the First Circuit panel's decision. So they're going to know a little bit ahead of time that Marty Weinberg is full of shit here. But in some sense, we're trying to read this from the perspective of a Supreme Court justice who doesn't really know what the Reed case is about, knows the law very well and the cases very well that are being mentioned, but doesn't really know the facts. So when Marty Weinberg is saying these things, he's representing things to the court, and we're asking as an informed reader, is this the kind of sentence where a Supreme Court justice is going to say, Marty Weinberg, you're full of shit? And that whole paragraph is exactly what I would have said in response to that, which is, even if I don't know this case well, you're misleading me here. The First Circuit's rejection of Reed's claim of acquittal is rooted in a formalism that has been consistently rejected by this court in a string of precedents spanning more than 100 years. This is your whole legal argument. You did not need 25 pages for this, Marty Weinberg. Your whole argument is just about whether the First Circuit Court of Appeals correctly applied, determined whether this was the substance versus the form of the quote, non-acquittal, whether that was analyzed correctly. This is the one. The court isn't going to take this. I get the hook under Bluford to get the liberals to look at it, but this isn't. This is a terrible argument. You brought this to the Supreme Court. This tells me that this wasn't really about the legal substance of this. This is meritless. This was about a headline saying Kierney and Reed has appealed to the Supreme Court. And Marty Weinberg's like, well, pay me, I'll write the fucking thing. But, and yeah, he gets his name in lights a little bit. But to me, it's just, no. However, it may be in England. Well, hold on. Oh God, we're going back to the Stuart Kings. Balby, United States. However, it may be in England. In this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Okay, we don't have an acquittal here. Hudson v. Louisiana, holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize the trial judges to enter judgments of acquittal in jury trials. This emphasis on substance over form, okay, that's a completely different concept. It's saying that in a case where a judge had granted a new trial, prohibited judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal conduct, it prohibited. So that's saying in a state where a judge was allowed to, so why does it matter if it was not authorized? Why would it be notwithstanding that the state code of criminal procedure did not authorize to enter judgments of acquittal? Oh, I see. Oh, okay, I understand now. So this is saying that in a situation where a state law didn't allow a trial judge to enter a judgment of acquittal in a jury trial, where a trial judge did so, even though it wasn't explicitly allowed in state law, that's the kind of thing that can bar a retrial. That's substance over form, okay? That is an actual example of it, not what we have in the Reed case. That's a very convoluted way of expressing that, though. But the key, if this is the main crux of Marty Weinberg's petition to the Supreme Court, this is a very futile argument, because that is just a completely different circumstance. A judgment of acquittal that is not expressly enabled by state law, barring retrial, makes perfect sense because it was a judgment of acquittal. Here, we have no verdict in open court of any kind. So there is no substance over form issue. But in the first example Weinberg brings up, that is a substance over form issue, but it's very different than what happened here. This emphasis of substance over form applies in the context of both jury acquittals and judicial acquittals. This court has, for example, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether that acquittal is expressed or implied by a conviction on a lesser included offense. Okay, also not the same situation we have here, because no verdicts were rendered. It was a hung jury. We in Price v. Georgia and see also Green, we believe this case where a defendant was charged with first and second degree murder and the jury returned a verdict finding him guilty of the lesser offense can be treated no differently for purposes of form of jeopardy than if the jury had returned a verdict which had expressly read, we find the defendant not guilty of murder in the first degree but guilty of murder in the second degree. Okay, right. But that explicitly implies that there was a verdict rendered in that case, Mr. Weinberg, which is completely different from what we're talking about here. So please explain to me why I should not distinguish the case you just cited from the facts at hand. The acquittal here was the jury's unanimous and final decision, reflected in the post-trial affidavits. Okay, if our system of law worked like that, then no jury decision in court would ever be final, and we would be reviewing them all the time. That Reed is not guilty. The court has instructed that an acquittal has occurred if the fact finder acted on its view that the prosecution had failed to prove its case. Yes, acted on. And sending affidavits, 5 of them, which is not 12, is not acting on anything. In fact, the only way to act on a decision of a jury, the only way for a jury to act on a verdict is to actually render the verdict in open court. Mick Elrath. It is not dispositive whether a fact finder incanted the word acquit. Justice Sotomayor, I knew it. I told you all. This was a play to the 3 liberals to go fishing for a 4th to revisit Bluford. That's all it is. It's not happening because Chief Justice Roberts wrote it in 2011 and the court leans harder right now. Tower's right. Saw that shit coming a mile away. This is just a weak play to get a 4th justice to join the liberals and overturn Bluford, and that's not happening. That's how you sum up this petition for a writ of cert. And what's so fascinating is Weinberg actually says it directly here. I didn't think he'd actually say it so directly. Justice Sotomayor joined by Justice Ginsburg and Kagan. So I for some reason I think I got it right, actually. I knew it was Sotomayor, but RBG was still alive. And Justice Kagan in dissent in Bluford. Now remember, when justices are writing in dissent, that means they fucking lost, okay? So what Weinberg is saying here is, but look, Supreme Court, these liberals in Bluford, they agree with us. You know, don't you want to change your mind, Chief Justice Roberts? That's what this is really about. So I think Weinberg probably sold this to the Reed defense as Bluford's dissent was extraordinary. And what I mean by that is Bluford's dissent was previewing where the court might go in like 40 years. Let's test the waters a little bit early and see if any of the conservative justices are sympathetic. And I'm thinking Weinberg had to be thinking about Coney Barrett, Kavanaugh, Gorsuch, one of those 3. Can you peel one of those 3 off on this specific argument and get them to overturn Bluford, which Chief Justice Roberts, by the way, as I mentioned, wrote the majority opinion for? That's not going to happen. If you know anything about the inner politicking of the Supreme Court, the Chief Justice right now leads the way. And even on cases where the Chief Justice won't join the conservative bloc, like Dobbs, Alito's Dobbs opinion, Coney Barrett and Kavanaugh and Gorsuch sometimes won't even listen to the Chief Justice then. So this is a case where there's no way the Chief Justice is going to waver on his own opinion from the majority in Bluford, but Reed's attorneys are basically saying, hey, some of you conservative judges, don't you want to reconsider Bluford? I got the Reed right. I don't think we needed 25 pages to say this. I think a lot of that fact section being so long was a tip-off for me that this was a very weak legal argument, but it's much shorter than I thought. Justice Sotomayor, joined by Justices Ginsburg and Kagan in dissent in Bluford, reaffirmed that in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. Rather, the court asked whether the fact finder has made a substantive determination that the prosecution has failed to carry its burden. Jeopardy terminates upon a determination, however characterized, that the evidence is insufficient to prove a defendant's factual guilt. So, again, this is in dissent in Bluford. The liberals lost in that case. I think it was 6-3, clearly. Justice Sotomayor defined a verdict in substance as a final collective decision reached after full deliberation, consideration, and composure among the individual jurors. So this was Weinberg's hook. He was like, well, Justice Sotomayor kind of gives this opening that maybe what jurors deliberate and agree upon could be a verdict in substance. But that was the dissent. They lost. Consistent with these principles, it is not unprecedented for a jury's unanimous and final decision to supersede even verdict slips that fail to accurately reflect such collective juror decisions. Reed cited 2 cases in which a jury's unrecorded vote for acquittal was given effect, notwithstanding the jury's failure to formally announce such a verdict. Dotson, which was a Fifth Circuit decision affirming correction of verdict on 1 count after receiving a telephone call from 2 of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit. Yes, but there was a verdict read in court. It was vacated on other grounds. And then a Stauffer decision affirming changing verdict on count where post-verdict interviews of several jurors determined that the jury had intended to acquit. And I think we find out that in both of those cases, the jury had actually rendered a verdict in open court after that happened. The Bluford majority opinion is not to the contrary. Oh, all right, Marty Weinberg, let's see your appeal to Chief Justice Roberts here. What are you going to try to tell Chief Justice Roberts about why this case, for some reason, is not if anything, not less convincing than Bluford, where a juror foreperson in Bluford stood in open court and announced that there was a mid-deliberation acquittal, only for deliberations to continue, the verdict to be guilty, and the Supreme Court to uphold the guilty verdict, despite the fact that the foreperson said in open court that there was an acquittal, which did not happen in the Reed case. There, the foreperson had reported. Thanks, Marty Weinberg. There, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on a lesser-included charge of manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The court rejected the defendant's arguments that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. Yes, because they went back to continue deliberating. The jury, which is exactly what we have here in the Reed case. It's exactly analogous. In fact, it's even worse for Reed, because not only do we have these anonymous reports, but we have no idea if they were in the middle of deliberations or otherwise, and therefore there was definitely more deliberations after these strange reports, even if we take them at face value. The foreperson's report in Bluford was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Accordingly, the foreperson's mid-deliberation report lacked the finality necessary to amount to an acquittal, quite apart from any requirement that a formal verdict be returned or judgment entered. Additionally, in Bluford, the jury was deliberating on lesser-included offenses within a single charge, and this is just a weird quirk, such that under Arkansas law, the jury options were limited to either convict on one of the 2 offenses or acquit on all. Massachusetts law has this different kind of partial verdict thing where you don't actually have to make decisions on everything to flow down the chart. You don't have to make a decision on the top count of top indictment of count 2 to actually flow to the lesser included offenses. You can literally just go to one of the lesser included offenses, make your decision on that, and that is a partial verdict. Arkansas had it slightly differently, which introduced a quirk in the Bluford case, but it's not material to our analysis. So this is it. This is Weinberg's whole prayer for relief here to the Supreme Court. The First Circuit erred in finding Bluford dispositive. Exactly. This is his only argument he can make. He's wrong, but this is the only argument he can make, because Bluford is controlling, and it's really Tanner and Pena Rodriguez, but Bluford is controlling. Unlike the foreperson statement in Bluford, the affidavits reflecting juror statements in this case were all executed post-trial. That cuts against you, Mr. Weinberg. The fact that, just before I keep reading, in Bluford, Mr. Weinberg, the fact that the jury foreperson said something in open court, that is more weighty, and it still didn't attach double jeopardy such as to prevent a retrial. The fact that, so in this case, the fact that the juror contacts occurred after is worse for Kierney Reed. The fact that, in this context, the affidavits do not so much as hint that the decision to acquit was non-final or revisited at any time is a powerful indicator of finality. That's a lot of spin, Mr. Weinberg, because there's nothing that indicates that it wasn't in the middle of deliberations. In fact, that the ambiguity implies that it was in the middle of deliberations, because there were further notes from the jury saying they were deadlocked that run contrary to the indications of the post-trial contacts. The jurors' references to the result of deliberation and to not guilty verdicts reinforce that conclusion. Yes, but those are in their random anonymous letters, not in the actual letters submitted in court regarding the mistrial. Unlike in Bluford, the jury's decision was communicated after the conclusion of deliberations, such that there was no possibility that it was reconsidered. Okay, Marty Weinberg, you're talking about jurors referencing back to their deliberations. The letter was after deliberations, but they were talking about what they were saying during deliberations. That doesn't imply finality. In these circumstances, the First Circuit's conclusion that even if Reed's jury unanimously voted in private that the prosecution had failed to prove its case on counts 1 and 3, there would still be no acquittal for double jeopardy purposes, exalts form over substance in a manner contrary to this court's precedent, and Reed contends violates the core principle of double jeopardy, the prohibition on successive trials. I disagree entirely, Mr. Weinberg. The whole point of Bluford is that if deliberations continue in any way, and you have a situation where a juror announced in open court there was an acquittal, that's not enough to prevent a retrial. And here, there is no doubt that deliberations continued after these agreements, if they even occurred, were reached. That's really what it comes down to. And then now just the last part of the ruling. The First Circuit, the last part of the petition, which is Weinberg's most difficult reach because Judge Saylor said that the request was inappropriate and potentially illegal. The First Circuit also relatedly affirmed the district court's conclusion that even assuming that a post-trial voir dire elicited evidence strongly favorable to petitioner, such an attestation from each juror that the jury voted unanimously to acquit petitioner on counts 1 and 3 before being discharged, her claim would still fail. Under this reasoning, sworn and credible statements by all 12 jurors attesting to a final unanimous decision to acquit, which we don't have here, by the way, would not be sufficient to mount a successful double jeopardy challenge. The result is not required by logic or precedent, and it's inconsistent with this court's precedent arising from other contexts. Additionally, the First Circuit cited concerns about maintaining the secrecy of jury deliberations and denying the request for post-trial voir dire. Yes, Tanner v. U.S. makes that very clear. In the analogous context of juror bias, okay, yes, but that's the only exception, invidious racial discrimination under Pena-Rodriguez. The law is clear that the defendant's Sixth Amendment right to an impartial jury also guarantees the opportunity to prove a claim of bias. Yes, okay, but that's very different than what you're arguing here, Karen. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. Yes, but that's bias. Post-verdict inquiry is similarly required to investigate claims of external influence. That's the Remmer case. After the jury had returned its verdict, the petitioner learned for the first time that during the trial a person unnamed had communicated with a certain juror who afterwards became the jury foreperson and remarked to him that he could profit by bringing in a verdict favorable to the petitioner. Okay, so that's literally bribery. We did not have that here. Although I'm not sure Karen's lawyers didn't try to talk to the jury or someone else didn't try to talk to the jury, but we did not have bribery no reports of bribery. The trial court, without the defense's knowledge, then enlisted the FBI to investigate. This court held that the defendant was entitled to a post-verdict inquiry regarding the FBI's unauthorized contact with jurors. Okay, so under this case, it's good to know the FBI cannot have unauthorized ex parte contact at the direction of a judge with jurors. Reed submits that there is no legal or constitutional basis to afford less rights to a defendant seeking the ultimate benefit of a right to a jury trial. Well, yes, but you didn't cite extraneous influence. So, an acquittal as found by a unanimous jury of her peers than those regularly granted to defendants raising process-related challenges. contending that their jury was not impartial. Yeah, but no, that's a very narrow scope. That exception is very narrow under the undue external influence like bribery or racial discrimination by jurors. Very narrow. So that you can't just argue it's analogous because the exception is narrow for a reason. A good faith Fifth Amendment double jeopardy claim where Reed has met her burden of production, she has not, should be entitled to no less procedural protections as a good faith claim of juror bias. Yeah, no, that's a bad argument, but that's where I saw Reed was going here. Reed was basically trying to extend the precedent under Pena-Rodriguez to allow post-trial review of jury deliberations beyond just allegations of bribery, like external influence like bribery or invidious racial discrimination. That was not happening. Reed acknowledges that there is little precedent involving situations factually similar to that at issue here. This case is unique. It is not often that after trial one juror, much less four jurors, directly contact defense counsel, stating in no uncertain terms that the jury had acquitted the defendant. But the unique strength of the evidence underlying Reed's motion to dismiss clearly demonstrates that she has met her burden of production and fully supports rather than undermines her claim for relief. Yeah, she has not met her burden of production. And it's not a strong evidentiary record, and there's no allegation of external influence or bias. Ordering a post-trial voir dire would answer the First Circuit's concern that the not guilty determinations were not final, but weighed against every other concern they have about penetrating the veil of the inviolability of jury deliberations. The simple outline of 2241, this is the habeas statute, makes clear that the Congress envisioned the habeas petitioners would have some opportunity to present and rebut facts. Hamdi versus Rumsfeld. That's a very famous case. In fact, this court has held that a federal habeas court, I think that was because it was giving habeas review to like a Guantanamo Bay prisoner or something who the government was trying to claim was an enemy combatant and deny them due process. In fact, this court has held that a federal habeas court must grant an evidentiary hearing, whereas here the merits of the factual dispute were not resolved in the state hearing. You're talking about jury voir dire. That's very different than declaring someone an enemy combatant. This is a necessary colloquy of the straightforward proposition that where specific allegations before the habeas court show reason to believe that the petitioner may, if the facts are fully developed, be able to demonstrate that she is in custody illegally and is therefore entitled to relief, is the duty of the court to provide the necessary facilities and procedures for an adequate inquiry. No, maybe in a regular habeas petition, but not when you're trying to ask jurors questions. It is the typical, not the rare case in which the constitutional claims turn upon the resolution of contested factual issues. Thus, a narrow view of the hearing power would totally subvert Congress's specific aim of affording state prisoners a forum in the federal trial courts for the determination of claims of detention in violation of the Constitution. Okay, but that's really a stretch. Really a stretch to then say, because there's a wide breadth to the habeas power of the court, the federal court should be able to pull in state court jurors for a voir dire or order a state court judge to do a voir dire of those jurors from a mistrial. Just because there's a general rule in 2246 that on a writ of habeas, on an application for such a writ, there's a rule that says evidence can be taken orally or by deposition. That's a stretch, Mr. Weinberg. The First Circuit was also wrong to deny the request for post-trial hearing to maintain confidentiality of the content of jury deliberations. The results of a jury's deliberation are not secret. Yes, but the content of them are. They are, in fact, routinely announced in open court. Mr. Weinberg, do you realize you're hurting your argument here? They were not announced in open court. And nothing about these deliberations, other than the fact that the jury was hopelessly deadlocked, was announced in open court. The inquiry requested by Reed could be accomplished by a single or at most a small number of yes or no questions posed to jurors. Did you unanimously acquit on count one? Was your decision, or did your finalist each count, or similar questions that do not intrude into the heart of jury deliberations? Wow, I didn't know you can do that. So you can write a series of questions. You can put a question mark, put a comma, and then start the next question without an uppercase letter. So I didn't know that. That's a very useful lesson in how to properly construct a sentence. You can do a series of questions that have a question mark and then a comma, and then you don't need to capitalize each new question. Very good to know. Or similar questions that do not intrude into the heart of jury deliberations. If all 12 jurors answer these questions affirmatively, no speculation regarding the basis for the unanimous conclusion could alter its constitutional significance. We simply cannot. Well, that's a huge stretch. Oh, well, the First Circuit said that these jurors were clearly indeterminate in their views because there was a mistrial. Well, that's enough to call them all in to ask them questions. No. And then Weinberg cites to McElrath, we simply cannot know why the jury in this case acted as it did, and the double jeopardy clause forbids us to guess. Yeah, well, it also forbids you to inquire. Prior to the enactment of Federal Rule of Evidence 606B, which the parties agreed was facially inapplicable here, this court held that the rule against jurors impeaching their verdicts applied only in a proceeding actually impeaching their verdict, which indisputably does not describe this case in which Reed is attempting to prove that the jury reached a verdict. Talking himself in circles. But there was no verdict, so therefore 606 doesn't apply. And this court has held that, at least in some circumstances, inquiry is required even when, unlike in the present case, it violates Rule 606B. Yes, but you didn't explain why Pena-Rodriguez is so unique, because that was literally invidious racial discrimination. Weinberg just completely ducks it. And it's just like, well, see, there's inquiry required, even if 606 applies, like Pena-Rodriguez, and Weinberg doesn't explain why that case is so different than the present case, other than he tries to duck it by saying it's different because 606 applied. It's not just different because 606 applied, because the verdict was actually rendered. It's different because that was an invidious racial discrimination, not what you're arguing. In sum, the defense learned post-trial that the jury reached a verdict that was not announced. That the most ridiculous novel legal theory of all time, that there is a concept of a non-announced verdict. It was at least entitled to the opportunity to substantiate that fact in order to ensure Reed is not unconstitutionally forced to stand trial for criminal offenses, including murder, of which she has already been acquitted. She has not been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury service, which the trial court described as extraordinary, rather than rendering irrelevant the efforts of at least 4 jurors to disclose that there was not an impasse on all 3 counts, as contrast to only 1 count, except for the fact that the note in open court said charges. Reed contends that the double jeopardy clause's guarantee against successive prosecutions is no less fundamental than the Sixth Amendment right to an impartial jury, and no less deserving of protection, including whereas here a defendant makes a persuasive and credible showing of an unannounced acquittal. That is not a concept. By post-trial hearing to substantiate such acquittal. Conclusions. For all the foregoing reasons, the court should grant Reed's petition for writ of certiorari. Michael Pavey and Martin G. Weinberg. They must have been very, very close to the word limit. All right, folks, we read a 25-page petition for writ of certiorari to the United States Supreme Court. Do you all feel like you want to now write petitions for writ of certiorari to the United States Supreme Court? I certainly, more and more of you turned in over time to listen to me read the petition for a writ of certiorari to the Supreme Court. It absolutely blows my mind that so many of you are interested in listening to me read petitions for a writ of certiorari in the Supreme Court. But more power to you. How did you do this again? How did you get me to stay for 4 hours and answer questions and talk about petitions for writ of certiorari and read federal decisions? I don't know how you all managed to do this. I think it's because you all make Towel feel like there are actually people out there engaged in informed, erudite, and cogent public discourse related to matters of the utmost concern, and that somehow invigorates me to continue relaying this information to you. Now, I want to do a few things. One is, despite Towel saying that Towel's doing his best and doing okay, and I left donations up because the Pilgrim Shadow made a very nice suggestion the other day, and I wanted to honor that suggestion. But some of you have been very, very kind and have sent some pizza money over and some money for gas tomorrow, and so I wanted to say God bless you for that. And then also, as a reminder, if you're just joining the channel, or if you've been watching the stream, a really helpful thing for the channel right now, although I don't understand why, is if you like the video and subscribe to the channel while watching it live. I keep getting reminded of this. I don't really understand why it's so important. However, if you want to help Towel out, that's a very nice way to do so, and I certainly will notice and appreciate it. I think we have like 86 likes on the video or something, so. Oh, there we go. Someone left a like on the video as I was saying that. God bless you to like number 87. Towel noticed that, and wherever you are out there, I appreciate it. And I earned this moment of levity after reading for the past hour or so. To me, it doesn't really feel like it's that much reading, because I would read something like this in my head in like 10 minutes if I were just reading it. So when I actually read it out loud to you, I'm like, oh, everything you're hearing is what I would just be saying to myself in a quicker period of time. But reading it to you all feels much more rewarding for some reason. And it's kind of a waste if I'm just reading these documents in private, I guess, and just interpolating them myself. If I can read them and tell you about them at the same time, I feel like it creates a historical record and people learn things. It's a symbiotic relationship. But I'm also not a lawyer. I'm a towel. None of this is legal advice. If you have questions about the law, you know what you should do. You should get a lawyer. If you have questions about an unconditional love or trying to demonstrate same to a world intent on undermining that fleeting concept, then you should get a towel. All right, now I'm going to go back. You all are going to not. You all are going to be a little bit behind, but I read some of your these comments I'm reading are going to be a little bit behind, but I'm going to try to catch up on some of the comments. There is a lot of them, and I appreciate, by the way, the people who have been helping with the moderating in the chat. We have some basic rules here, which is don't be discriminatory, don't be derogatory, and don't sea lion. And the moderators, it's like a blue wall in here sometimes, and they have a very good sense of what that means, which is don't act in bad faith. So you might be talking about something on the surface that looks innocuous, but if they get the sense you're engaging in bad faith, they're just going to move you along. Now, if you have different views on the issues that are coming up or the different things we're talking about or the case itself, you're entitled to your different views. You want to debate the merits, you want to debate the issue, that's fine. But getting past all of this giant blue wall of wonderful towel friends in bad faith is almost impossible. So as I'm reading through these comments, I'm seeing the moderators doing a wonderful job. They are honorary towels. We are all honorary towels. There are some washcloths in the fold. There's a soap dispenser among us. There's a flannel, I believe, from Sheffield in the UK. There's a paper towel. There's a hemp towel somewhere in there. There's a lot of washcloths. A lot of people have there's a beach towel. We have a lot of people in the towel fold. All right, so the pickle chip saga was Karen's attempt to not only create press, but to seem more likable. Good luck with the latter. Yeah, I mean, so the pickle chips were not received as making Karen likable. A lot of people just laughed at her. I'm told that a lot of the memes that were going around were just Karen doing this with the pickle chips. Karen hates not being on red carpet stairs. Yeah, I agree. If you have the time, would you mind just going over very briefly how you believe the feds got involved, or point me to something you wrote about it? If you're too busy, another time works. Oh, sure, Rehab. So I'm happy to link you to my most recent overview of that. And I think we don't have to watch. Well, maybe I have a video on it. Decent amount of my overviews of this have been video based. But let me see if I can pull you up, Rehab, a good overview of why the now confirmed federal closed. The now confirmed is closed federal probe into the death of John O'Keefe. The actual origin story of it. I do believe that I told it at one point recently. I want to see if I actually conveyed it on video, because that will give me a little bit of time to roll another tobacco cigar. Let's see. I apparently did a video where I said Team Docket Rocket stars are honorary towels. Oh, and by the way, to Dee Dee's credit, someone was just like, I was answering questions on one of Dee Dee's threads the other day, and some random person was like, F you, Grant. And Dee Dee was like, why are you saying that to Grant when he's just trying to be helpful and answer questions? And I was like, yes, see, Dee Dee disagrees with me about the Kierney and Reed case, but we both can encourage civility. I was going to say, except towards Kate Peter. All right, so can I get you an answer to this question? When was the last overview I did? You know, it's interesting because there's so many motions. I guess that's why I'm kind of so tired, because I look back at it. I think I tracked like 75 motions in limine over the past like 3 weeks. And my brain, when I realized they were finally, the pace was slowing down, I think my brain was like, okay, we can relax a little bit now. All right. Oh, I found my video about memorizing U.S. presidents. All right, I think I got it. Let's see. Yes, let's talk about how the feds got involved, and let's see if this is it.
Where there's a lot of hush-hush about...
All right, so let's talk about this. Should tell the whole tale. I'm a towel. And this should explain about how the federal probe started, why Kierney and Reed was able to connect with Josh Levy and Rachel Rollins in that old office. Basically, if you go on my Twitter feed, you can search Dustin Chow, D-U-S-T-I-N, last name Chow. That'll pull you up. Send me a message on Twitter, Rehab, and I'll send you all my research on this. I've written a number of posts on it. But basically, the old DOJ in Boston had a bifurcated history of tension with Michael Morrissey. Rachel Rollins, the then U.S. attorney, didn't like Michael Morrissey for 2 reasons. One, Rollins was kind of soft on crime, and that's putting it lightly. If you know about the broken window theory of prosecution, Rachel Rollins would do the antithesis of the broken window theory of prosecution. She would not charge any low-level offenses for any reason, basically. She would null-pros them. And it became a serious problem. Other DAs started to weigh in, including Michael Morrissey. That upset Rachel Rollins. I think she called him a meatball in public at one point. I don't think it's any coincidence, by the way, that Turtle Boy started calling Michael Morrissey that, because Turtle Boy and Rachel Rollins have their own history, and I think Turtle Boy actually helped Rachel Rollins get the position of U.S. attorney, whether he realized it or not, because Turtle Boy helped this Republican operative named Rayla Campbell undermine the Joe Kennedy Jr. primary against Ed Markey for the Democratic Senate seat in Massachusetts. And for whatever reason, Rachel Rollins and Turtle Boy back then were talking directly about sending this Rayla Campbell woman to Joe Kennedy Jr. events to help Ed Markey. And then all of a sudden, the Biden White House appoints Rachel Rollins, like right after that, to the position of U.S. attorney, which, by the way, a position she got fired from or forced out of almost right away, because within months of getting the job, Rollins launched a pretextual federal probe into Kevin Hayden, the current Suffolk County DA, because Kevin Hayden beat Ricardo Arroyo, who was Rollins' friend and political ally, in the primary for Suffolk County DA race. That was a brutal primary, by the way. I mean, Arroyo didn't have a spotless track record by any means. That was a brutal primary. And then after Hayden beat Arroyo, which, and, you know, say what you will about the stuff that came out about Arroyo, Hayden won the race, and Rollins texted Arroyo and said, we'll make Hayden pay, or I'll make Hayden pay. And what did Rollins do? She launched a pretextual federal probe into Kevin Hayden, recused herself, leaked the recusal letter to the Globe and the Herald, and tried to get this whole fake story spun up about Kevin Hayden being under federal investigation. Now, doesn't that sound eerily similar, then, to what happened to Michael Morrissey in the Norfolk DA when Kierney and Reed walked into Josh Levy's office in November of 2022 when Rollins was still U.S. attorney? Now, interestingly, Rollins and Morrissey also had another beef over the fact that in a separate case when Rollins was DA, Rollins had wanted to not seek the life sentences for... She wanted a ruling from the SJC or the Superior Court or something, saying that youthful offenders under 25 or 21 couldn't get life terms for murder because their brains were not developed. Now, interestingly, Rollins ended up being way ahead of her time on this, because the SJC did eventually rule in favor of that standard and removed life terms for youthful offenders who commit murder. But at the time, it was very controversial, and guess who was one of the DAs railing against Rachel Rollins for doing that, for trying to remove life terms for youthful offenders? Michael Morrissey. Rachel Rollins really didn't like Michael Morrissey, And then there was also a history of tension within the DOJ's public integrity section in Boston. So one of the people working for Rollins, dating back to 2015, had a history of tension with Michael Morrissey. This man's name was Dustin Chow. Now, during a 2015 trial around there related to a murder in Sharon that had to do with Whitey Bulger, Frank Cadillac Slemmy, and Stephen the Rifleman Flemmy, the state police and the Norfolk DA had to, or not had to, but they agreed to give up jurisdiction in that murder so that it could be prosecuted by the U.S. Attorney's Office. Now, the case was tried, etc., it went as normal. But during that case, Dustin Chow's wife was passed over for a promotion in the Norfolk DA's office, and then Dustin Chow, this now very powerful line prosecutor who looks into public corruption, was reported in 2015 to have gone around saying he would do whatever it takes, or he wanted to do whatever it takes, to burn down the Norfolk DA's reputation, etc., etc. So then, and you know, people have long memories in those positions. That's what power means, having a long memory, specifically because of shit like that. And so you get a situation where Karen Reed walks into the Rachel Rollins run DOJ with Rollins and Chow, who have grudges against Michael Morrissey, and Levy is kind of the cover, I think, for this. And then the pretextual probe launches into John O'Keefe's death. And there's another element to that as well, which is that old DOJ in Boston was very anti-cop, unrepentantly anti-cop. I think they were anti-cop to the point where they were like, all cops are bastards. Not all of the people in that office, but I think a lot of people. That was the ethos under the Biden White House and the Rollins DOJ. So what happened was, in my opinion, the federal probe into John O'Keefe's death starts up in November of 2022. By the summer of 2023, it's really getting going, but then it just suddenly really stops. It basically ends in the fall of 2023 and wraps up over those next few months, and then it's confirmed as closed by the end of 2024, beginning 2025. I think it's because that probe was cover, and the actual target of the investigation was the MSP unit, the same unit that investigated Karen, because of the cover-up of Sandra Birchmore's murder. Now, Sandra Birchmore was a young woman in Stoughton, Massachusetts, who was just absolutely victimized by a cop, but it was a ring of cops in Stoughton tied to this cop, Matthew Farwell, who's in federal prison right now, facing trial for murder of a cooperating witness for killing Sandra Birchmore. And what's scary is when Sandra Birchmore was killed, her death was investigated by the MSP, who ruled it a suicide and just quickly moved on. Now, the feds, in August of 2023, opened an investigation into Birchmore's murder. And within a year, Matthew Farwell is charged. Now, how can Matthew Farwell be charged when the state police said that Sandra Birchmore died as a result of self-harm? Well, how interesting, even more so, is that Stoughton, the police department where Matthew Farwell was a cop, some of those Stoughton cops went on to work other jobs. You know where some of them went? The very MSP unit that we're talking about. And maybe there was more than just one victim. Maybe Sandra Birchmore wasn't the only victim of that ring of cops. And you want to know something really interesting, you folks from around Canton? What if, may he rest his soul, former Chief Berkowitz called in the FBI on the Stoughton police due to the Sandra Birchmore situation? Something to consider, folks. Something to consider. Now let's take a watch of this video. I have it up on this screen because there's way more to this, because it's not just the federal investigation. Have you asked yourself, why did Aidan Kierney get invited by Alan Jackson in April or May of 2023 to this weird phone call? And why was Aidan Kierney, when he initially approached Karen Reed about her case, so worried about, quote, problems he may have been facing related to potential wiretapping charges as to a victim out of Rhode Island? And why did the FBI directly intervene in that case? Well, what if, little you help me, I help you happened between Karen and Aidan? And just what was Alan Jackson's connection and David Yanetti's connection up to the FBI and DOJ in Boston? And what, if any, help did Aiden give them? And what help, if any, did Aiden get in return? Now listen, you don't need to be employed by the federal government or on contract to provide this kind of information. You don't need to be employed or on contract necessarily to get help. But if you did get paid, there would certainly be a file with what are called voucher payments. And I think Aiden Kierney is no Whitey Bulger. But if the federal government paid Aiden Kierney to run a honeypot in the form of his Kierney and Reed trial coverage to generate tips about the Massachusetts State Police Unit that investigated Kierney and Reed, not for the purposes of investigating John's death, but instead for the purposes of investigating Sandra Birchmore's death, well, everything starts to make a little bit more sense. Throw in the dash of Josh Levy, Josh Levy's bosses, Rachel Rollins and Dustin Chow, hating Michael Morrissey. And not only do you got the perfect cover to investigate the MSP unit and Sandra Birchmore's murder, but you also got this very, very pernicious and very true to the Rollins playbook, leave the federal probe kind of leaking out there, just hanging out there to torment and smear Morrissey. The John O'Keefe federal probe, when the real damage is still coming. It's clearly the Farwell situation and the Birchmore situation. And I'll tell you, listen, I don't know Michael Morrissey, never talked to him, never ran into him, wouldn't know him from Adam. But I don't think Michael Morrissey is a bad person. I think Michael Morrissey is fighting a very difficult case, and his office is going to win the case. But I think the people around Michael Morrissey, and Tal's got friends. You all watched Little Towel for his Kierney and Reed coverage, but check out some of Towel's other coverage on his other feeds. Towel covers government a lot. Towel has a lot of friends. Everywhere, in every agency, state, whatever. I have people everywhere. And, Towel hears things. It's not that hard to hear things. And what I hear, generally, among Towel sources, is that it's not Michael Morrissey who's a bad person. And that it's not that there was anything wrong with the investigation of John O'Keefe's death, considering the circumstances and the blizzard and the difficult defendant, Kierney Reed. It's not that there was anything wrong there, but it's that the people around Michael Morrissey, related to potentially other cases or otherwise, might have some issues. Now listen, it's a little weird for me because I'm used to looking into corruption in government and high-level people doing bad things. But this is the first time I've really felt not just with the federal stuff, I always have in the back, my four principles in my mind, country, God, family, safety, with academics thrown in there somewhere, in that order, right? So it's very easy for me to say, okay, I will defer to what I think is in the national interest of the United States. If I'm covering something, even in the cannabis situation, when I was covering the leaked documents from Cyprus showing that Massachusetts cannabis companies had ties to sanctioned Russian oligarchs. When I fucking found out that the CEO of that company, Boris Jordan, was a U.S. intelligence asset dating back to 2007, helping the Russian ambassador to Moscow, who was then Bill Burns, that went on to become the head of the CIA, when I found out that that CEO was helping like the American government try to overthrow Putin by building closer economic ties between Russian oligarchs in the West to like use soft power to overthrow Putin, I was like, okay, I should not dive too deep into this. Not because I don't want to cover the corruption surrounding it, but because I felt the national security interests of the United States and whatever the fuck I was going to find diving down that path far outweighed Little Towel's, need to know or desire to figure that out, or the potential implications from this company being able to operate unchecked in the domestic and international space because of its intelligence community connections. I just said the powers that be have determined that is in the best interest of the United States, and I'm not going down that road. But this situation is much different. This is a state government situation where these agencies are supposed to be accountable to the polity they represent and serve, and it becomes very hard to actually engage in any kind of erudite oversight because of this sort of wall of silence. And it's a very insular community. I get why. The people who are involved in these cases and prosecutions and the police officers and all that, it needs to be insular. But it's also the kind of thing where when you really start looking into it, like the power structure of the FBI, the power structure of the Norfolk County DA, it's not like regular human beings. I mean, these are some scary people. Not scary in the sense that they would hurt you, but scary powerful, scary intelligent. Real power doesn't actually move in plain sight. When people are like, oh, look at those humans out there, they have so many views and impressions, it's like, that is not fucking power. Fame is a degraded form of power. Like, outside of being Little Towel and just random people coming up to me on the street and giving me hugs and wanting to take pictures with me, fame on the whole is a terrible fucking thing. The real power moves in plain sight, and in fact, the most valuable form of power is being able to influence and effectuate massive changes or dynamic shifts without anyone knowing that you're involved. Like, didn't you all listen to the Lil Wayne song about lasagna? The G moves in silence. Lil Wayne was making a point there, though, which is real power. Real power actually moves in silence, and it's very hard to find. On purpose, but I'm not as willing to defer unless I were directly told that somehow the national security interests of the United States were implicated in the work of the Norfolk County DA and the MSP, which maybe sometimes they are because they're on joint task forces. But unless I were directly told that looking into these situations threaten the national security interests of the United States, I don't believe I shouldn't be able to look into it. But there's definitely sort of these vibes of like, certain people are untouchable, certain people you can't talk about, and you don't really know why. And that is the kind of thing that really gets told when we look into this story of the federal probe into John O'Keefe's death and Aidan Kierney and Kierney and Reed and Lindsay Catani exposing that connection and how much she suffered as a result, and the proxy attacks and just how much is going on there. But I'll tell you, people don't understand what's coming. People think it's a joke. I mean, do you think I just magically apparate into these sort of circles related to the various powers that be and the different agencies around the federal and state oversight apparatus? No, I'm just a towel. I'm just a towel. People absolutely should continue to underestimate Little Towel, because that is a tactical advantage and I thrive on it. But that said, let's listen to a little bit more about that history as to the federal probe. Whoever asked that question, Rehab, wonderful question, perfectly timed. I'm going to continue reading some of your comments and questions, but we're going to watch a little bit more about this background as to this federal probe, Aidan Kierney, Kierney Reed, why Aidan Kierney's on Kierney Reed's witness list, and furthermore, since we're going back in time to listen to Towel, I think when I did a morning stream, you're going to enjoy the uplift in energy. At least Murder by Maestro does. I don't know if he's still with us. Towel's been going for a while now. We're heading into we're 4 hours and 20 minutes in. That's something to celebrate. Let's watch.
There's these webs of conflict of interest on both sides where there's a lot of hush-hush about this case.
not because of what happened to John O'Keefe at Karen Reed's hands that morning, but because of all of the webs of external factors that I'm now enumerating for you. And if you think for 1 second that this is not going to play into the retrial, you're completely wrong. There's Aidan Kierney's on the witness list. All of this subtext is bubbling to the surface. It's already implicit in the search warrant. By the way, I want to show you one more thing, folks. I want to blow your mind a little bit here. Let's bring up Karen's search warrant, shall we? Because there's a specific part before we look at what I was just going to show you. Do you want to see a really interesting part of the search warrant? By the way, Jane in this search warrant is Lindsay Gattani, the person that Aidan Kierney was telling about the federal, Karen's blabbing about the federal, her links to Josh Levy and the federal probe. Do you want to see something really interesting? So we see the complete enumeration. By the way, let's read a little bit more about why people might have been so intent on silencing Lindsay Gattani. Gattani stated that she met Aidan Kierney in September 2023 after exchanging messages on Facebook Messenger. Gattani stated she would communicate with two of Kierney's Facebook profiles, Clarence Woods Emerson and Aidan Kierney. Gattani states that she then began communicating with Kierney using the phone number that's been seized. So Kierney and Jane met in person following a Commonwealth v. Reed hearing. After that meeting, they had a romantic relationship. In the beginning of their relationship, Kierney stated he was close with Karen Reed's family. He would later start to date Gattani, state to Gattani that he speaks with Karen Reed every day. Gattani showed me a screenshot that Kierney allegedly sent her showing multiple calls on a certain day that showed Karen Reed, signal audio in the call log. Kierney told Jane that there was an intermediary between Kierney and Reed, a woman by the name of Natalie. Kierney stated Natalie and Reed were angry with each other. Kierney stated to Jane that he had begun talking to Gattani, that he had begun talking to Reed directly. Gattani stated Kierney and Reed communicate using the Signal app because it is encrypted. Gattani states that she does not communicate with Kierney using the Signal app. So that goes to show Kierney wasn't just communicating with her on Signal. For Karen, that was a unique thing that he was basically doing with Karen and wouldn't talk with other people, even though he was relaying sensitive information to them using Signal. Gattani stated Kierney runs everything by Karen, meaning all of the blog posts and social media content is approved by Reed prior to Kierney publishing. Starting to figure out why so many people have an incentive to silence Lindsay Gattani? I think Karen should apologize to Lindsay Gattani. Now that is a dinner I would go to. I would go to dinner with Lindsay Gattani and Karen Reed. That would be an interesting dinner. I feel like we would need like 27 bodyguards so that no one could get within like 100 yards of us. But my God, that would be an interesting. Imagine Towel, Lindsay, and Karen Reed at a table. Not allowed to happen until after the trial and after Karen serves her sentence. But yes, that's an interview I would do. Wow, must be about the case, but wow. Kierney described Reed as difficult, controlling, and someone who gets irritated with him. Gattani stated Kierney showed her material related to the investigation of the homicide of John O'Keefe, including the 911 call and cruiser footage before it was leaked on social media. On December... Tully got that wrong. It wasn't the cruiser footage. It was the 911 call. Brian Tully wrote this report. Got to get the facts right, Lieutenant Tully. And also, I don't understand why you have a friendship with Kate Peter. Lay down with dogs, wake up with fleas, I suppose. November 1st, 2023, Kierney posted a live YouTube video entitled Karen Reed Case Gen 1 McCabe 911 Tape Breakdown. The audio is in fact a voicemail recovered by investigators from John O'Keefe's phone that captures Jen McCabe calling 911 from a different phone, reporting finding O'Keefe unresponsive. I think what it means is someone was calling John's phone, they were leaving a voicemail, and at the time Jen was calling 911 on a different phone. O'Keefe's phone was recovered by first responders on 1/29/2022. It's reasonable to assume that only the Commonwealth and Reed's attorneys are in possession of the audio file. So that implies that Kierney got the audio file from Reed, and I wonder if Kierney did stupid things with the audio file, like trading it to people, and that's what led to the state police going to certain. Aiden, the fact that you don't know how to use social media to determine if someone has pictures is the funniest thing about this case, but it's also fucking ridiculous. And if it ever comes out at... wait, what? Okay. It's very possible that Aiden Kierney traded protected evidence in the Kierney and Reed case for pictures, not from Lindsay, but from someone else. Aiden had the evidence and then wanted pictures of someone and traded them for it. I wonder how Karen's going to feel if that comes out. I wonder how Karen's going to feel if that person is a witness. How does this crazy shit happen? People's homes, and then in turn that's what led to the... I'm trying to be respectful, by the way. I don't know this person. I don't know exactly what's going on there. I do know some crazy fucking shit has gone down there. You want to talk about the feds? Let me just say, anyone in their right mind who would wiretap the fucking FBI is out of their fucking mind. Okay? You are out of your mind if you think that you can wiretap the FBI. Like, you have to be an absolutely fucking crazy person. Towel needs to stop. See what happens when you get Towel going? Towel says things, Towel knows things. Towel's a towel. Interpret from that what you will. The FBI following up with people who were visited by the state police. You see where I'm going? Catani described one instance where Reed controlled what Kierney would publish. Kierney wanted to release the Canton police cruiser video footage he had obtained from Reed. Kierney asked Reed if he could publish the video on his Turtle Boy platform. Catani stated Reed said no to the request. Kierney, this is fucking explosive. Oh my God. Kierney was frustrated and contacted one of Reed's defense attorneys, Alan Jackson. Jackson approved the release of the video. Reed later found out about Kierney going to Jackson and was angry. And it was right around November 28, 2023, which is when Lindsay and Aiden were still talking. That's explosive. That's part of what the content of the conversations are going to be about. Oh my God. It wasn't just that Karen was controlling it. If Karen would exercise editorial control in a way Aiden didn't like, Aiden would go to her lawyers who would override her. Holy shit. Lindsay Catani is central to all of this. I hope Hank Brennan realizes this. I don't think there's any option to appropriately contextualize the extent of the relationship between Aiden Kierney and Karen Reed, which, by the way, continued not only between April and June of 2023. June is when Natalie and Karen have the falling out, and then Karen and Aiden start talking directly. Not only, I think it was because Natalie called Karen late at night or something and it upset Karen. Not only did it continue after that, but the conversations continued after the scope of the current production to Brennan on Kierney's phone through October 5th. And the only person who has any insight other than Aiden Kierney, who will be called as a witness, the only person who has any fucking insight into what Aiden Kierney and Karen Reed were talking about between October and December of 2023, perhaps the most crucial time of all of this, is Lindsay Catani. I don't think even I put this all together because it's just a lot and a lot of timelines and information. And this is explosive. This material that's being discussed right here is outside the scope of the dates in Brennan's request under Rule 17, which means Lindsay Catani and her phone. That's the only way to get any of this in. And this is the exact thing that is the evidence that Brennan needs. It's way more than just direct contacts. It's prima facie evidence of a controlling publisher relationship where Reed wasn't just asking Kierney to do things. She was checking what he was doing to make sure what he was publishing was in line with what she wanted him to accomplish. That means his actions were her actions. It is an inescapable conclusion, folks. There's no way out of it. There's no other way to understand this. This is everything. We're getting a preview by way of this search warrant, which, by the way, Hank Brennan, although it all predated him joining the case, if he ends up giving a soliloquy we'll listen to at the end of the hearing that we haven't finished, where he says, if there's stuff that shouldn't have been leaked in the Reed case, because that's his case, that is not going to happen. It will not be tolerated. This search warrant was originally uploaded on a flipbook kind of website. It's a weird sort of flipbook. Originally, that's where it came from. And it was quickly taken down. I have the original link somewhere because the investigatory value of uncovering who uploaded that document originally to that flipboard is incredibly valuable. That document gets uploaded, okay, to the flipboard and then quickly taken down, but it gets saved. This is not a public document, okay? This is a public document because someone uploaded it to that flipboard website. And you want to know something really fucking weird? So a document went up, which was on the public record. It was on the court docket, but it went up from Special Prosecutor Cosgrove, the one we read earlier, the opposition to a motion from Kierney that disclosed all that those bombshell contacts between Kierney's lawyer and Reed and Kierney and Reed and all of that on page 7 and 8. That was on that same Flipboard website. Now, yeah, that was a public motion, but inductively, if Hank Brennan's serious about not tolerating disclosures that are inappropriate, then I think there's someone, and it wasn't Lindsay Gattoni, obviously. I think there's someone who got this search warrant that might be close to the state police in the Reed and Kierney cases that released it that shouldn't have. Now, mind you, it is incredibly valuable and explosive information. We are getting literally, no one can have this. No one has this insight. No one, I don't think, has put this all together. People are still wondering what's in the Kierney and Reed communications. Well, first of all, we're not only seeing what's in the Kierney-Reed communications, we're finding out about stuff that I bet Hank Brennan hasn't even fully put together, because I don't know if he's seen this search warrant, as to what Kierney and Reed were talking about in the fall, after October, and before December. But here it is. It's right here. Now, I think there might be an intentional attempt to keep this from Hank Brennan because of how Tully, after the fact, handled the extraction, and I think that is itself a bombshell fucking situation. So I think Lindsay Gattoni's the third rail in some regard, but if Hank Brennan's fucking serious about his commitment to integrity and holding actors accountable, then it doesn't matter as to what Tully did after the fact or the underlying behavior of Tully's allies in this context. This is fucking valuable. Her testimony is incredibly fucking valuable. It is perhaps there's no other way to obtain it. It is the only way to give insight into the extent of the relationship between the Kierney and Reed that really draws crescendos and explains the apex of their ongoing collusion in the lead up to Kierney being indicted on December 20th and then going on the run and the fugitive status. You can't explain that. If you're going to call Kierney, you have to bring this in. There's no way not to. It is the only context that fully explicates the nature and dynamic of that relationship. And especially with Kierney going over Karen's head, like, think about what this means in terms of the evidentiary argument that Brennan's going to advance under consciousness of guilt. It quadruples, quintuples, whatever you want to say. It's weight. Oh dear God. I had read this the other day, but I wasn't fully appreciating, in light of the relevance now, the material relevance of communications between Kierney and Reed, what this document was really saying. Because what it's really saying is that the contents of Reed's and Kierney's communications went beyond discussions about material or leaks, which are bad enough. It was explicit instructions and editorial control, according to this. That is every element under Mahoney. Every element, every single element checked off under Mahoney's joint venture standard for introducing this kind of evidence in the context of a consciousness of guilt instruction against Karen. Catani stated different sources of financial benefit for Kierney and his partners. Catani stated Kierney is doing well with donations. Kierney had alluded to the fact that he did not pay for a Lexus SUV he recently acquired. Kierney made statements similar to, if my frugal mother ever found out, may she rest in peace, ever found out I paid for the Lexus, she would be mad. And, quote, even if I think that's a typo, even if I didn't pay for it, what's wrong with that? A check of RMV records revealed the Lexus was purchased in the end of June 2023. Further records revealed the vehicle was paid in full using a personal check. Now, what's weird is Kierney said he took a loan or something and published those documents like in public at one point, but this clearly indicates otherwise. Now, here's where the really interesting part starts. And the stuff you're really only going to see here because most people won't touch this because both sides of this case want to hush this up. But I will not allow innocent voices who became unwitting sort of pawns or ping pong balls in a intelligence community proxy war between the state police and the fucking federal government be silenced because it's inconvenient to the different fucking parties on each side. That's fucking outrageous. This is a justice system. We are fundamentally at the core of this system supposed to protect the voices of the most vulnerable. That's why we have an adjudicatory adversarial process. And when you have parties in that process who know that victims and witnesses don't fucking have standing or very many rights at all, fucking doing this kind of stuff, it just absolutely infuriates me. It infuriates me. It infuriates me. And only really Hank Brennan can right some of these wrongs, in the sense that just because in my opinion, Brian Tully did bad things with the cell phone extraction and whatever, and just because of what we're about to read, people want to just pretend Lindsay Catani doesn't exist? You want to make her a non-person? That's ridiculous. Mr. Brennan, where is the justice that you speak of so highly? Where is the integrity that you claim to undergird, that you claim undergirds your entire approach to this? If you don't know about this, okay, fine. If you do, what the fuck is going on, Mr. Brennan? Catani stated she was told by Kierney that Reed's attorneys were working with the U.S. Attorney's Office, specifically acting U.S. Attorney for the District of Massachusetts, Josh Levy. Kierney would talk a lot about the federal grand jury and Levy with Catani. Catani stated Karen Reed was interviewed by federal law enforcement. Catani also shared other comments Kierney learned from Reed that are corroborated by other information known to this affiant. Brian Tully wrote this affidavit. How much do you want to bet that redacted or withheld piece of information has to do with who the federal probe was looking into? And how much do you want to bet that the fact that the federal probe and who its scope may have related to in the fall of 2023, after the Birchmore probe started, would have been of interest to Mr. Tully, especially if Mr. Tully were, say, unprompted, asking questions about the scope of the federal probe? I don't even know if the DOJ realizes this. Now, by the way, you want to see what happened after Lindsay got served a subpoena for a future grand jury? Now, folks, by the way, if Aidan Kierney got indicted, right, on December 20th, 2022, and then Lindsay got a subpoena for a future grand jury after that grand jury indicted, do you think Aidan might have been freaking out because December 20th, 2023, not 2022?
He would have realized that there was another grand jury that might have then proceeded to look into him and Karen. And in fact, doesn't the fact that there was a no true bill on March 27, 2024, which is just 3 months after all this is going down in December of 2023, 3 to 4 months, doesn't that seem to indicate that Catani's summons that she got for a very real grand jury I think she eventually went to testify in front of, which has been attested to in public court documents, doesn't it mean that grand jury was indeed about Karen and Aidan? But Aidan wouldn't have known the scope, right? All he would have heard was Lindsay Catani, who has all this information about his fucking contacts with Karen, gets a subpoena 2 days after Kierney gets indicted, so it's got to be a new grand jury. Gattani was served a summons to appear before the grand jury on December 22nd, 2023. Kierney learned Gattani was served with a summons, and they agreed to meet at her apartment on the night of December 23rd. During this meeting, Kierney told Gattani to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire an attorney if she cooperated with him. Kierney later assaulted Jane, although those charges were no pros and the grand jury didn't indict, but the allegation in the police report was that Kierney pushed Gattani onto a couch because Kierney had written notes about what Gattani had been talking about with Kate Peter on a notepad. And there was Lindsay's notepad, and Lindsay took it. Kierney set it down at one point, and then Lindsay took it and put it in her shirt. And Gattani tried to take it back. She wouldn't let him, and he pushed her down, was the allegation. Now, that didn't get bound over by the grand jury, but 2 other charges from that night related to Gattani wiretapping Lindsay, where he recorded her without her consent. An original version of the file exists.
I said Gattani twice there, but I meant Kierney was the one who tried to get the notes back from Gattani. And Kierney was the one who alleged to have wiretapped Gattani.
That file got sent around allegedly, and then there was a second version edited into the record, which will be very easy to prove due to reconstructive audio analysis that can be done on the file as to splicing and source audio. It's a very rudimentary editing job that won't survive deep audio analysis and deep forensic scrutiny. There was a second edited copy of the video introduced where Gattani saying or consenting to the recording was apparently edited in, even in a way where a part where Kierney inserted himself saying something like, I'm recording, in a part where Gattani was saying, okay, to something else. But that's a matter for the evidentiary analysis pursuant to forensic examination during trial. The more relevant point is that this document is explaining how during that interaction it was aggressive, which led to Medfield police charging Kierney with A and B on family household member and witness intimidation. And then the wiretapping charge also comes later, and it's a wiretapping in WI from that night that get bound over by the grand jury. I remember clearly, if the grand jury is bounding over that charge on WI, they're seeing that record you just heard of about what Kierney actually went over and said to Lindsay that night in the context of their interaction. And then Kierney was arraigned on those charges on December 26th, and that's when his bail was revoked. And if you can see here, there is evidence, according to the search warrant affidavit, which was granted, of Karen engaging in witness intimidation and conspiracy. And I hope folks understand the relevance of what I'm pointing out here, which is there's a lot more coming regarding Karen Reed and Aidan Kierney's contacts. I've shown you it. This is not me speculating. This is me enumerating with specific references to the factual record and primary source documents, a full comprehensive explication and theory as to what's going on with Aidan Kierney and Karen Reed. But there's one more thing I want to do for you because I'm a towel.
Well, there you go. That's why I like playing these clips, because I do a good job of summarizing these situations from time to time, and I realize not everyone is watching every single minute of every single development. So I appreciate those of you who took the time to watch that. I do think the background of the federal probe, Aidan Kierney's potential testimony against Karen Reed, and what Karen Reed and Aidan Kierney were talking about the DOJ's involvement in this strange series of events as to the now confirmed as closed federal probe of John O'Keefe's death is crucially important. And you just saw a preview from Karen Reed's cell phone search warrant affidavit from January of 2024 as to just some of what could come out as to the communications between Kierney and Reed. Now, I spent a long time going over a lot of these details. I did not plan to go for 5 hours again today. I am so far back in the comments. Here's what we're going to do. I think what I'm going to do is I'm going to slowly read through the comments, because I do kind of make a promise to read through them all. I can't always read all. Sometimes you all leave so many comments that if I were to read through them all, reading the comments would last longer than the stream, and we would be here for 8 hours. And I think a lot of people would enjoy that, actually, because all the different friends and the towel friends in the different time zones of the fabric of the universe would start waking up, and they'd be like, this has been going for 6 hours. This is wonderful. But for Little Towel, I think I think I need to set aside at least a small portion of the day where I am not awake and processing court documents. Because even though I sit down and it's helpful, especially with all I have going on physically and emotionally, even though I sit down to do it, I do think it takes its toll on Little Towel. Please, let's see. Please take care of yourself, Little Towel. Towel tries. Prayers for Towel family member. Oh, thank you. That means a lot to Little Towel. Decades of case law conflict with what Karen Reed is arguing. Yes, I would say decades, perhaps hundreds. The defense. If we pretend there was a verdict, we can claim double jeopardy. Exactly. Jack D65. I'm going back through some of your comments from when we were analyzing the horrible petition for cert from Karen Reed. The defense's fundamental argument is let's just claim there was a verdict, and then therefore we're right. Hey, Murder by Maestro apparently left and came back. It's always good to see you, my friend. Yes, I can miraculously stream and talk for 5 hours. We're not really sure how the human larynx can function beyond what is apparently the upper 3-hour limit, but nonetheless, Towel continues. We're on a marathon stream. Yes, anytime there's some kind of federal court pleading, you can almost guarantee that we're going to go for at least 4 to 5 hours. As King George would say, you'll be back. Hey, have you all ever thought about something? There are 3 cities in the world that aren't actually subject to control of their relevant countries. They're technically sovereign city-states. The Federal District of Washington, D.C., the City of London, which is an actual sort of 1-mile enclave within London, and the Vatican. Very interesting, right? Maybe we never did leave. Have you also ever looked into something called the Brackenbridge dinner that's held in Yosemite or like Bohemian Grove? We definitely are just sort of an extension of the British Empire, masquerading under the ostensible veneer of an independent republic. So don't get it twisted. I understand your grief, Grant. I found out my big brother has lung cancer 2 weeks ago. It's devastating. Oh, Angela, my prayers to you and your family, and I'm so sorry to hear about that. Devastating news. It's, as I was talking about earlier, I think there's a very human element of not only our discussions about this case, but this case itself that so often gets lost. And if there's one thing I hope people take away from this stream or take out into the world with them after they finish watching when we're together from time to time, it's that these other people you're engaging with, whether it's online or in real life, they're real people with real lives. Whether you think they've done great things, done bad things, and centering, I think, that humanity in all of this is what is going to create some redeeming silver lining in this chaotic, crescendoing conflagration of chaos. So sorry to hear that. Jen D says to Angela, oh, you all are so kind and consoling to each other. Jack D says, Gears Garden sends condolences to, or compassion to Angela as well. Jack D introduces a moment of levity by saying, according to the Magna Carta, Karen should be free soon. You know, the Magna Carta is actually the first instrument. I think it was 1324. It was pre-Hobbes. It was the first instrument that really declared rights of citizenry. I want to say it occurred during like the War of the Roses or something. I think it had to do with Parliament fighting the king, and there was a very convoluted series of events there that led to the power that Parliament has today. But nonetheless, no, the Magna Carta actually does have some very interesting historical relevance when we're thinking about the emergence of the modern political state, although I would say its real emergence doesn't really come until after the Westphalian Peace of 1648. Nation states as we know them didn't actually emerge onto the world scene until 1648, but the Magna Carta in England, I mean, definitely set the tone. That's how slow history emerged, by the way. It took us 350 years to go from the Magna Carta to nation states. Nowadays, I feel like we live that in like an hour and then move on. Kat sends their compassion to Angela. Murder by Maestro sends hugs. Angela says, I use this case as a distraction. I will admit I do that from time to time too, but and I do think distractions are helpful, but even being able to chat about, as I mentioned, our own humanity within the case, I think is incredibly important. Can a juror report another juror who has an agenda? Well, interestingly, during the first trial, a pro-Kierney and Reed juror took out a juror that juror, the pro-Kierney and Reed juror, thought was anti-Kierney and Reed. And that caused all sorts of tension because the juror was having, the pro-Kierney and Reed juror was having extraneous conversations with other jurors, and it eventually came out that pro-Kierney and Reed juror was discussing the case at a bar during trial, saying things about wanting to acquit Reed. So that juror got thrown off as well. Angela says, time for a moment of levity. Yes, moment of levity. Let's see. Lots of prayers to Angela. Very much share those. Good to see you here. Kat says, my King of Kings. Great. Any friend of my King of Kings is a friend of the Towel universe. Kat, you are an honorary towel. I'm crying tears of gratefulness, Kat. Oh, that's so touching. I have a better chance of winning the lottery than Karen has of getting SCOTUS to even look at this case. I agree, Amber Am. Very nice to see you as well. Glad you're with us. Would you guys feel good while being on trial for murder? Because Karen does. I wouldn't. I think Karen probably has a lot of anxiety and is probably medicated. I think she feels good, but I think it's artificial. I don't think she actually feels good. I think she's nervous all the time. But if you use anything that impacts, so think about it. The GABA-1 receptor, right? If you use any GABAergic, like booze or benzos or whatever the fuck, any GABAergic is going to make you feel good, even if you're very anxious. That doesn't mean she actually feels good. That just means her, inhibitory reaction, or her inhibitory reflexes are just completely depressed. Literally, not depressed as in she's depressed, but their functioning is depressed. So she's not reacting the way that her brain would react if that medication were not suppressing her GABA-1 receptor. Grant's room is so smoky, I thought I had quality set to 240p. Yeah, I looked at that earlier. I was like, is something wrong with my camera? And then I realized I just have been smoking a lot. Yeah, let's just say when Towel gets stressed, I think it's a combination of the stomach issues or whatever, but Towel smokes a lot of his medication. And thank God it's very cheap here. I think I paid $50 or something for a week's worth of medication with no tax. So I wouldn't say that's good for the market in Massachusetts, but it's good for Towel. Kat left a Bible verse for Angela, 32:17. Good Lord, behold, thou hast made the heaven and earth by thy great power and stretched out arm, and there is nothing too hard for thee. I have a thing where no matter where I come across a Bible verse, whether it's on the highway, like on one of the overpasses, or when I subscribe to all these YouTube channels that post Bible verses all the time because I find them inspiring. No matter where I come across a Bible verse or in the Bible, I just immediately do the sign of the cross. It takes me a very long time to read through Scripture because every single paragraph I do the sign of the cross. I feel compelled to do it. I think I feel comfortable with it. I wonder what KR's thoughts are, says B Rabbit, when she's alone in the middle of the night. I wonder if she's haunted by fear and guilt. No, I think she's knocked out. Not physical. I think she takes medication and is just knocked out. I don't think Karen Reed remembers between 11 and 7 most nights. Now, I'm not saying that laugh with pejoratively. I'm saying if you were that overwhelmed, you would black it out. And you can absolutely knock yourself out with medication. She's void of emotions. Yeah, I mean, also, a lot of you are analyzing this woman correctly. I think she does come across this way, but I think a lot of it is medication induced. I don't know if any of us actually know Kierney and Reed. And by the way, if you take medication prescribed by a doctor for anxiety, you know, that's her right. I don't know why, says Amber Ann, but this case gets under my skin. I need to watch Vallow next weekend instead. Well, I don't know what Vallow is, but we talked about this the other day. I haven't watched any movies since after the 1980s. And the last TV show I saw, I think I watched the first episode of Game of Thrones. I think that was like in 2014, maybe 2013 or something. I watched one season of True Detective. I watched a little bit of Elementary, but for the most part, I try not to consume any modern media. So maybe there's good stuff out there. Somebody showed me a clip of a TV show in class the other day. I have no idea what the fuck the show was about. And I was fucking baffled. The quality of the fucking TV show, it was like being in person with the people. My brain, I could not handle it. I was like, I don't know what's going on here. I don't understand. I don't want to watch this. And it was also very short, like 3-second segments where it was like watching like Instagram reels where the characters would talk and then it wouldn't just cut to a different character. The scene would just fucking end and they'd go to a different scene. And I was like, this is like living in a fever dream. Is all TV like this? I hope not. Angela Whittick says, I feel the Lord is near me, Kat, and the world is a strength and comfort. I'm so glad that there's so many people who find solace and comfort in religion here. I don't compel everyone to be religious. You want to be atheistic? That's fine for you. Fine, I think that's wonderful. You're more than welcome to believe in that or not believe in that, however atheism is defined. But at the same time, I also don't really appreciate people who say things like attacking religion or attacking atheists. You're free to believe whatever you want. But I also do appreciate there are so many religious people here. One time I remember someone on Twitter said, Grant, you're a reporter and you're religious? And I was so taken aback by that because I didn't realize that there was this perception that there's like this trend of atheism, I guess, in reporting or in the modern world. To me, it's like, why wouldn't everyone? I mean, how can you not read the Holy Scripture and say, wow, there's some really profound moral lessons here? Now, maybe you'd read different religions to get those lessons, but I can't imagine I just can't imagine the headspace of thinking most people are atheistic, you know, like it. And so the idea of the question to me being posed, Grant, I can't believe you're a reporter who's religious. I was like, I can't believe there's reporters who aren't religious. Let's see. Karen, Donna Adelson, Wendy, I don't know the person's last name, Lori Daybell, and Karen all have the same eyes. I think it says I'm reading too much true crime Twitter when I know who Donald Adelson is. I somewhat know who this Wendy person is. I know who Lori Daybell is, and I know who Kierney and Reed is. I don't know what that says about Towel, other than Towel needs to stop reading so much true crime Twitter. I want to see this trial, but I'm worried, says Lackadaisical. The chaos does not happen in the western states, except for Jackson's L.A. Yeah, I feel like even, the southern, I kind of want to cover criminal trials in the south or the western states. I just want to see what it's like when there's just no tolerance for bullshit at all. It's kind of like the federal courts. There's just no tolerance for bullshit. But I want to see what it's like in the federal and western states. I hear Massachusetts is very defendant-friendly, but this is all I know in terms of coverage. I cover the Massachusetts courts, mostly. I cover some other states' legislatures and regulatory bodies, some national stuff. But on the whole, the Massachusetts criminal system is what I live and breathe in terms of my coverage. So it's very odd to me to even, like, I watch a little bit of Nevada, I guess. Oh, actually, I should say this. So I know a little bit about the Nevada system because I watched the entire Kim Blandino trial on our Nevada judges, which I thought was a fascinating trial. I know a little bit about the Texas system because I used to watch the 323rd Judicial District down there because they used to YouTube stream. Judge Alex Kim is an excellent jurist, and he used to broadcast his court. I don't know why they don't anymore. Maybe there's a new judge there. And then I also really enjoy watching Three Rivers county, I think it's the circuit court, just the county court, Judge Middleton. That is probably one of the most edifying courts you can watch. So I guess I should say I have a little bit of knowledge about like the Nevada criminal system. I have a little bit of knowledge of the Michigan system, and then I have a little bit of knowledge of the Texas juvenile court system. But on the whole, Massachusetts is my wheelhouse, and to me, it's very odd to think that other states would do things differently, but then I realized, like, of course other states do things differently. Massachusetts has this reputation as being this very strange outlier. I think the way that people of Massachusetts think about Cambridge, we kind of see it as like a standalone republic. I think that's how the rest of the country thinks about Massachusetts. Karen blinks a lot when she's denying she killed him. Yeah, Karen, when she lies on camera in intimate settings, especially like long interviews, is very obvious when she's lying. Yeah, I mean, so people are saying, "Oh, but Karen drinks soda and eats with her stomach issues." I mean, listen, my family has very serious stomach issues. One of my siblings had their colons removed when they were 4 years old. Completely one of the most just horrifying procedures any child should go through. It was just horrific. No one should ever have to go through it. And then another sibling had their colon removed at age 14. I have very serious stomach issues. That part of the reason I use this medication and prednisone when it gets really bad is that there's a very, very high risk of that kind of stomach condition developing into more serious metastasized conditions. Now, people say, well, okay, Karen was eating chips and drinking soda. I mean, yes, it's not ideal, but I eat ramen and 7-Eleven pizza. And yes, the pizza's inert. Like anything that's just plain bread, cheese is ideal for not activating those kind of conditions and making the inflammation worse. But on the whole, I mean, we eat like you all. I think mostly we don't eat as much. So I don't know. I'm bigger than Karen. I'm like 6'2", probably like 170 or something, 175. But Karen's like, I don't know, 4'10", like maybe 5 feet. She's like 90 pounds, so she probably lives off like, excluding liquid calories, she probably lives off like 500 to 1,000 calories a day. So what you saw her eating there was literally a meal. By the way, did you know when candy bars were invented, they were originally meals? We got a lot of comments to read through. I'm going to keep doing it. I made you all a promise. I said that this is a stream where you don't have to send super chats. You never will, in order to have your comments and donations read. Although, I will do a pause because someone did remind me earlier. It is apparently really helpful if you're watching and you've been enjoying Towel Talking for 5 hours. I don't know how I have been doing that. If you subscribe to the channel right now or like the channel, pardon me, it actually would be very helpful to Towel if you do that, because apparently it helps the channel when you like the video or subscribe while the video is live. You can, of course, though, also take the chance to share the channel or the video at some point. That also would apparently help the channel. I don't really understand this YouTube algorithm. I don't really get what it means to sort of have watch hours or engage with streams or like things, but I'm working on it. I'm clicking around. I'm figuring out what this YouTube platform entails, and I really like that it allows me to read all of your comments. I probably would have just stuck over on just X if I could have found a way to read the comments, but YouTube turned into such an interesting discussion forum, and you all seem to like talking to each other so much. We're now over here. So the more you want to help this channel, the more I guess we'll find towel friends to add to the fold. And then you have to get through a blue wall. And by the way, we will add more and more towel friends to the blue wall as I scroll through all your comments. So please forgive me. I think basically I wait for someone to make a comment that makes me either giggle, or I say, wow, that's a profound legal insight, and I would appoint you to the federal bench or the state bench, and then I make you an honorary towel. Amber Am, my king, I don't even have funny tummy issues and can't drink soda and pickle chips now. Grant has a great voice. Oh, thank you, B Rabbit. That complimenting Towel's voice is such a nice thing. Welcome to the fold of honorary towels. Amber M says SCOTUS just ignores most cases. They take less than, 6%? That's absolutely true, Amber M. And you have now made a wonderful insight and have joined the ranks of Towelfold. This case is weak. There you go, Beachness. You made an insightful legal contribution as well. Towel just gets in a mood and makes everyone part of the Towelfold so that we just have an absolute blue wall. Welcome, Kat. You have also been promoted. I suppose there's no hierarchies, so it's more just everybody's an honorary towel or washcloth or some type of member of the Towelfold, unless you're some kind of towel outsider, and then you're going to get looked at with a lot of suspicion, especially if you have opposing views, but we welcome them until you start trolling, sea lioning, being derogatory or discriminatory, and then you will very quickly meet a giant blue wall of towels. Let's see. And they'll just replace jurors if they find something. They are watching the socials. I'm positive. B and Chance, I think you're 100% right about that. I think you've already been promoted, B and Chance, but I'm still scrolling down the chat, so give me a second. All right, now I have to refresh like at least 20 minutes of chat, so give me like 2 seconds here. I sometimes feel that as the chat gets caught up, it loads so much information that it slows things down a little bit, which is exactly what happened. Hold on, I'm going to get there. All right, I got there. All right, here we go. You all were having quite the conversation. Let's see. Such a lovely community. Oh, I'm learning so much. Thank you from a baby towelette. Well, since you have now helped me add towelettes to the Towelfold, you are promoted to a full, well, it's not a promotion, but you are now an honorary baby towelette. Monty, so good to see you. It is adorable that there's a baby towelette. I really liked Lori says murder by says Deb Martell, but can't watch him cover this case. Totally biased on the Kool-Aid. Yeah, I've never watched Lori, but he's apparently biased about this case. I'll take a look. My King of Kings agrees that lawyer is biased. I guess I'll have to look into this. Murder by Maestro says lawyer proves the theory that there is a direct correlation between a man's trustworthiness and the amount of product he puts in his hair. Murder by Maestro, why do you say ridiculous things? The other day I was scolding someone for mocking Bob Alessi's hair. I was like, leave Bob Alessi alone. I made up that theory and I stand by it, says Murder by Maestro. Well, at least you own that you just made up your theory. Amber M says, Lawyer's dad should have a channel. Every time his dad tries to tell the facts, Lawyer stops him and he's disrespectful to his dad. Oh, he has his oh, that's the guy who has his dad on his streams. I haven't actually watched the stream, but I definitely saw like a picture or something of the Lawyer guy and his dad on a stream, and I was like, oh, that's kind of cool. So true, Amber Ann. Law tubers include oh, I don't know who those are. Stopped watching Lawyer when he wouldn't discuss TB's actions, says Monty. Oh well, yeah, that's normally a tip off that someone I like Brandy Churchinwell. I think she is a nice person. We don't agree on this case at all, but even with Brandy, it's like I feel like she tiptoes around the Turtle Boy issue because she doesn't want to. I wouldn't even call it the wrath. She just doesn't want to deal with the fact that there's a smaller audience if you talk about, for example, if I cared about my audience or platform or whatever, I couldn't imagine doing this work or engaging with you all. Like I don't. If the price of speaking truth is that you alienate Kate Peters' friends or Turtle Boy's friends or Karen's friends, then you shouldn't be doing this. You're doing this for the complete wrong reasons, and you're compromising something very sacred in the pursuit of very profane social bonds that you can make anywhere. Don't do it in the context of high-stakes criminal cases that revolve around the integrity of the justice system. It's like a very simple insight, I think, but people lose that in the search for meaning or friend groups or whatever it may be. But they definitely lose sight of the fact that they're pursuing very vacuous human endeavors in the context of very sacred spaces. And that's what frustrates me. I'll never get frustrated with Brandy as a person or with any of these content creators as people. But I do get frustrated sometimes with what I feel their tactical decisions as to what they talk about, what they don't talk about. But that's their right. Listen, I was thinking about this in class today. I'm reading this very good book right now, actually. I'm going to recommend it to you all because I think it is edifying in some regard. Oh, no, did I leave it I might have left it in the car. So it's a book by Cheminsky. And it has to do with why the Constitution is not doing a good job protecting democracy. Richard Cheminsky, maybe? And the part of the book in particular I was looking at, examining, is somewhere, I think, between pages like 106 through 133. And it has to do with the influence of social media culture on our democracy. And as we were kind of mulling this over, what I was thinking about was, oh my dear God, I bet I am one of the few people with a platform. I mean, I don't have the largest platform. I think my impressions over the past 18 months is 120 million or something. So I mean, it's bigger than some small countries, and it's not huge, but it's a big platform. And I think to myself sometimes, I ruminate on this all the time. The size of this platform, the obligation I have to the public, the way I'm thinking about information, how I'm presenting the information, how I'm interpreting the information, how I'm packaging the PDFs so that people can access them, how I'm promulgating them, how I'm compiling the docket, how I'm speaking about issues, how I'm leading by example if it comes to how we should treat each other, how I'm trying to set a tone as to disagreeing without being disagreeable. That's all that's cycling through my head all the time. Just 24 hours a day, 7 days a week. And then I realized I don't think most content creators, first of all, give a fuck about any of that. And second of all, even you have a priority list that is centered around engendering cogent discourse. I think or a duty to the public. I think the primary thing most people are thinking about is clout and money. And so it becomes this really weird Faustian bargain where you have these content creators who are saying, well, if I take a certain position, that'll impact my reach or my bottom line or whatever. That is very dangerous for our democracy. I don't mean to quote that old Sinclair broadcasting clip, but which itself was dangerous to democracy. But that is the very behavior that is so dangerous to our democracy. Taking a position, not because one believes it necessarily, but because it will drive a certain segment of engagement among a very active internet sort of subgroup. That is extremely dangerous. And I think that's the direction we're heading, so... and then I went on that whole rant because we were talking about, some content creators, I think, they abscond from their duty to stay informed and instead are very vacuous with how they go about presenting information because they're making a cost-benefit analysis based on their ability to retain an audience, expand an audience, or otherwise that is based just on that opinion, rather than who they are as people. Now, that's also why I love all my towel friends so much, because you all know there are many times where I may say something, and I know there are some of you who feel this way, where I may say something where you're like, wow, Grant is pointing out something about someone I really like. And this is a very critical thing Grant is pointing out. That makes me uncomfortable. But I know that Grant is not being malicious. I know Grant is trying to look into something here, and I like who Grant is. So I'll listen to what Grant's saying. That's all I really want. You don't have to believe. I don't want you to take what I'm saying and then you have that as some creed for your life. I want you to take the form of how I'm analyzing things, take into consideration my perspective as one of many, and then apply it as you're consuming information in your real life. I'm trying to empower you. But I don't know if that necessarily is the core ethos of a lot of creators who don't necessarily view their interaction with their audience as symbiotic, but instead more of the audience is in control of the creator, in that the audience dictates what the creator can talk about by simply just not engaging. that is dangerous. If the creator starts to feel that they must speak a certain way or must talk about a certain thing in a certain way with a certain perspective, regardless as to how they feel authentically, then they've completely lost the plot. They may have found a living, but they've lost the plot. All right. Towel is going on his rants. Are you going to review Kierney's motion to be exempted from sequestration? It states Hank has exploited a witness list. I did review Aidan Kierney's motion to be exempt from sequestration. We went in depth on, in particular, MGL 233, paragraphs 20, subsection D, and paragraphs 20, subsection E, related to Kierney on page 8 of 9. It might actually go over from page 8 to page 9 of his motion to be exempt from sequestration, which is not on the Kierney and Reed docket, so it's not actually formally filed. We don't know what's going on there. But his motion to be exempt from sequestration has in it a direct assertion that Kierney will take the Fifth and refuse to answer any questions if called as a witness by Hank Brennan. That is a very telling sign that Hank Brennan may be able to move under the compelled immunity statute to force Kierney to testify. In fact, it's a very odd thing for Mr. Kierney to include in his pleading a direct statement that he intends to take the Fifth and answer no questions. You can't know that you will answer no fucking questions. How can you fucking know that? How can you say you will answer no questions at all? The only reason you'd put a statement like that in an affidavit or a motion is if you're laying the groundwork for the prosecutor, teeing up the prosecutor, which is a weird thing for Kierney to do, but teeing up the prosecutor to do a compelled grant of immunity. Now, it's outside the box. It's weird. You don't need consent from every other DA in the state, but they have a chance to object under 233-20D. It's a weird outside the box move, but in this case, it's almost called for because Aidan Kierney needs plausible deniability. If Aidan Kierney's going to testify against Karen, the best way for him to do it and save face would be if Brennan did the compelled immunity thing, because then Kierney could say, the choice was I went to jail or I testified. I couldn't claim the Fifth, so I testified. So that's why that motion is explosive from Kierney, because it says he plans to claim the Fifth. Bodega Lady says that they like Melanie Little, LTL, and Nurse Kim. So, okay, here's what I'll say about that. Melanie Little, Towel has oscillated on Melanie Little. I think she's a fine person. I don't agree with a lot of her analysis or opinions, but I would have a cordial conversation with her, and I have apologized in the past to her when I think, unnecessarily polemicized something she had said about going to Mexico or something. And I say unnecessarily because it was a it was a very weird circumstance for her to mention Alan Jackson going to Mexico, and her wanting to go to Mexico and the Dave Matthews Band, whatever it was. But unnecessarily polemicized because Melanie Little in time actually said some things that were very, I thought, honorable and noble, especially as to people like targeting Lindsay's kids and stuff. And so from that moment on, I was like, listen, I don't agree with Melanie Little on this case, but Melanie Little is a noble, honorable person, at least on that level. Forget about her views on the case, setting those aside. On that level, she's noble and honorable. More power to her. I haven't even thought about it since. Kind of filed her away in my brain after that moment as noble and honorable and went about my business. LTL, I like LTL not due to his views on the Reed case or anything, or the Turtle Boy case, but because of his coverage of the Trooper Eduardo Garcia. I think I'm getting that right. The trooper who was who mysteriously died in the MSP Academy, and LTL even does things like translates his posts into Spanish for the family, and entiendo español y hablo español también, y creo que es una. It's a very beautiful thing for LTL to be able to translate that for the family and to make the family feel heard. And he has no incentive to do that. No, there are people who mock him, even within the Free Kierney and Reed group, for covering that and just degrade that whole story. But LTL just sticks on it, keeps covering it. It matters to him. He really cares. He's engaging with trying to get more audits or insight into what happened with that, outside investigations as to the troopers or the trooper cadets passing. I think Eduardo Garcia, I think I'm getting the name right, was made an honorary trooper after he passed away, so he is a trooper. But the point, though, is that LTL does his own series of good work, so more power to him. Nurse Kim, don't know anything about her. Haven't good, bad, or otherwise, don't know. If I see something good, I'll say it. If I see something bad, I'll say it. But as of now, Nurse Kim firmly morally neutral. But again, they may have opinions on the Kierney and Reed case that are very, very distinctly different from mine. We're setting that aside. I'm just talking about what I think about them generally outside of our opinions on this case. All right. I don't know. Lawyer, Deb Martell said, lawyer, is not going to say goodbye to all those subs. His numbers grew exponentially over the first trial. I like these chats and channels much better. Yeah, I appreciate these chats. I like these channels. I think they're very welcoming. They tend to be a little bit more civil. I don't really love the type of discussion that occurs on the other channels. It also isn't as engaging. There tends to be a lot of fighting going on in the comments. Hi, Eva. Yep, we got through most of the substance of the stream, but of course, as always, Tal made a promise to read all your comments. I'm very, very far behind in the comments, but I'm reading them through. All right. Let's see. Grant knows the inner workings of Boston politics. Yeah, I think I live it. I mean, listen, I don't know. I tried to explain it a little bit earlier, but if you read my Facebook and Instagram and LinkedIn feeds, it is just all coverage of regulatory agencies in Massachusetts. So, like, whether it's at the state house, whether it's at, like, the legislature up on Beacon Hill, or whether it's, like, the OIG or the auditor or this whatever, like, I am covering a lot of stuff. And that means that Towel is in a lot of circles and moves very easily in those circles. And Towel has a lot of friends who know a lot of things. And you won't. It's very easy for Towel to move in those circles because Towel is a Towel. And everyone's like, Graham, would you please tell me more about this specific niche area of my interest that you happen to know everything about? And Towel will then be like, I would be happy to do that for you. Sometimes the amorphous thing that is the regulatory or governmental apparatus in that sector will ask me things, and I'll be like, I'm concerned that you have come to me to ask me this. Is the fail point in our government Towel? I say that to them sometimes. I'm just like, am I the fail point? They can remake the 1964 movie Failsafe, which is basically a more serious version of Dr. Strangelove. They could just make it Towel Safe. The story of Massachusetts politics and the collapse of the Cannabis Control Commission. But yes, I do know all the players, and I feel like I'm looked at as a bit of a traitor. I wouldn't call it I think that establishment looks at me with bemused curiosity. They're like, why is he so intent on telling the members of the public how political power works? Like, that is not how it's supposed to work, Towel. Like, they're not supposed, I think their view is it's very paternalistic, and they're like, those unwashed masses, why must you kiss their feet, Towel? Like, they're just supposed to put us into our positions, and then we make the decisions for them. Stop telling them how to actually engage with the democracy. And I look back, and I'm like, well, a lot of them I have a bigger platform than them, than like entire government agencies. I'm like, well, fuck you. I say it in a loving way. One time the Kierney and Reed fans were like, the reason why we respect Towel is he goes after Democrats too. And I was like, I'll go after anyone in terms of coverage, political party or otherwise. You're a Democrat. That does not mean that you are somehow insulated from accountability if you do things that are problematic. You're a Justice for John O'Keefe supporter. That does not mean you are somehow insulated from all moral accountability if you do something problematic. Imagine if we lived in a world where everyone who you liked could just do horrible, terrible things, and you would say, well, I like them, so I'm not going to talk about that. That is how politics goes very astray. This was definitely interesting. It was wonderful connection with the DOJ and also Suffolk and Norfolk counties. Yes, Deb Martell, it's a very intertwined, overlapping web. And if you've ever wondered, why do Harvard finals clubs function the way they do? Harvard doesn't have frats. Well, they do, but they mostly have finals clubs, Porcellian, Hasty Pudding. But the reason they have those finals clubs, one, they're very pompous. They like to brag about rejecting presidents and all that. But two, there's 8 finals clubs, okay? They each have 24 members, okay? 8 rising sophomores join each year, then there's 8 juniors, 8 seniors, okay? So 24 across 8 different houses, so 8 times 4, 32, 184 or so people in these 8 clubs. It's very exclusive. Now, it's not that matters, though. That's the bullshit part. What matters is the form of how these clubs function. Okay, there's 8 of them, and then there's one inner circle club, which is called Delta Kappa Epsilon, I think, DKE. And then that club is made up of the presidents of each of the other clubs. All right, so do you see how that form is? It's 8 clubs and then one inner circle club with one president from each club. That is how soft power functions in the real world. Now, I would argue if you were just looking at it in the American socio-political context, like the emergence of Porcellian in 1654, etc., you would say, okay, this might be a symbiotic relationship between the way in which Harvard's finals clubs function and soft power functions in the American political sphere, but that is to misunderstand the history. Harvard was just I think it was like a land grant, like it was like a chartered university originally. That might have been Dartmouth, actually. But the institutions of higher education in the New World were directly tied to the crown. All right. Now, John Harvard, that may have been a slightly different situation, but the point is the same. And so what really was coming over was English aristocratic soft power traditions. And what you really see thus manifest, and why I was saying earlier, maybe we never really, we didn't have to return to King George because we never really left. What America actually is in its manifestations of political power, and what Harvard finals clubs were actually bringing into the American political system, was entrenched structures of soft power diplomacy, and that aristocratic diplomacy. And that is why everything that I'm talking about with Norfolk County, Boston DOJ, the intricacies of the different political players, the history, the timeline, it all kind of comes together in a historical mosaic that is necessarily a reflection of those kind of overlapping concentric social circles. And furthermore, that power structure is very interesting when you understand it on that level, because you'll notice that those 8 inner circle members, right, the 8 presidents of each club, what they're really doing is they're thought leaders. They are establishing trends within the 8 outer clubs. And how much do you want to fucking bet that all those 8 outer clubs, there are 24 members of each club, those are the most fucking powerful people at Harvard in all their different social circles. So the 8 inner circle people make the decisions for the other 24, who then go and promulgate it to society. That's how it functions, folks. And so in some sense, when people say, well, Grant, you really understand this, yes, but I'm also definitely looked at as a traitor. Like, they are like, fuck that kid. Why is he, like, it is not okay to, one, understand this and not want to be a part of it, but that would be bad enough. It would be sacrilegious if I understood it and then told them no. But it's even worse that I'm like, well, fuck it. I'll just tell people how you're operating so it makes it harder for you to engage in social control. They're like, fuck you, Grant. And I'm like, well, I'm a towel. Fuck you too. It's a very awkward dynamic when Towel engages with government. Okay. Let's see. Towel has connections. Towel's just a towel. Towel has fibers. Towel's fibrous being just exists and permeates throughout Massachusetts. TB has been quiet lately. What's up with that? Yeah, I think Turtle Boy's only going to be able to cover the trial for a few more days, and I think he knows that. Hey, because it doesn't matter whether you actually get called as a witness. What it really comes down to is whether you are on the witness list. Yeah, he's not going to get an exemption. Oh, that was funny. Amber Am, Turtle Boy started trying to cover another trial, but his audience is so brainwashed they didn't care for it. Murder by Maestro, I swear to God, I thought he just by accidentally walked into that courtroom, the Turek trial. Turtle Boy is too valuable to the prosecution, says Miss Lisa. He won't get an exemption. Miss Lisa, it's wonderful to see you. You have, due to your wonderful contribution, been promoted to an honorary towel. TB is too narcissistic to admit any wrongdoing. Yeah, but that's why I think the compelled grant of immunity is so interesting, because he doesn't actually have to. He could say that he was forced to do it. This is where the hip folks hang out, says Murder by Maestro. Yes, the hip folks and the people who, for some reason, find it fascinating that a towel can talk for 6 hours. TB should be behind bars, says Miss Lisa. He's dangerous. I'm glad he's not here on the North Shore. Murder by Maestro says, if Towel stares too far into the abyss, he becomes a scouring pad. Yeah, I think there is something to be said about it's very important when you're engaging with these cases or when fighting monsters, and Murder by Maestro, of course, is insightful and erudite as always. Don't stare too long into those souls. It's not worth it. One, if you're naive and get taken advantage of, it's incredibly, it'll break your soul. So you're better off just living in your artificially blissful world and never getting involved. But then the other thing, and the point that really Murder by Maestro is making, is if you know what you're doing and you actually understand you're looking into the soul of pure evil, it's fascinating. Okay, there is a moth to flame component to it, but please be careful and please protect yourself, because you are not more powerful. Like Medusa is an analogy. Okay, she didn't actually have snakes that turned people into stone. It's an analogy, I think, for staring too long into the abyss, which is that it will just draw you in to the point where you will become hardened. You will lose your humanity because you'll become enmeshed in this evil. So towels and otherwise, towel friends, washcloths, soap dispensers, beach towels, paper towels, towelettes, all the flannel-based towels, all should consider that whenever paying attention to these cases or engaging with this material, just don't allow yourself to be consumed by it. You are still people. You have lives. Your lives matter. This all matters too, yes, but it is not your every moment. You have an existence, and you should not jump into that black hole, because it will swallow you, and you will come out. Yes, you will still be a human. You will still walk around on this earth and still be you, but you will be completely hardened to all of your emotional experiences. And is that what you want? Is a very fucking high price to pay. TB knows, Amber M says, TB knows Karen Reed will throw him under the bus, but he has no reason to not throw her under the bus first. Yeah, it's a race to plea. It was a race to plea last time, and the only reason it didn't happen was because I think the prosecution wasn't as well suited to handle the complexities in both the Turtle Boy and Karen Reed cases. I think both of the prosecution both Ken Mello, Adam Lally did yeoman jobs for what they were up against, but they were under-resourced, in my opinion, just watching how they deployed their various arguments, and great lawyers up against just unimaginable odds, a Sisyphean task, and they both rose to the occasion. Adam Lally almost got 9 out of 8 or 9, maybe 10 guilty votes on count 2, and Ken Mello got a number of court victories against Aidan Kierney, bail revocations, etc. So I think that is all important to keep in mind as well. This difference in the prosecution. Hank Brennan is a genius. There's I don't know if people appreciate this. People say all the time, even people who don't really like me, they're like, Towel, you're a savant. I don't understand how you know all this, or just recite this stuff from memory, or keep all these cases in line, or can track all these facts, or do all this for so long. That is how I think about Hank Brennan. Okay, I don't know Hank Brennan, never talked to Hank Brennan. I now can say I have seen Hank Brennan walk down the stairs of a courthouse and say something to another reporter about how it was a nice day outside and the weather was pleasant. That is the only time I have ever engaged with Hank Brennan. But that is how I look at Hank Brennan. I look at that man. If you think Powell has some kind of savant acumen, I look at that man as just brilliance on another level. And this is not a discounting Adam Lally or Laura McLaughlin or anyone else. It is just there are some people who are so beyond the bell curve. It's kind of like reading Caleb Schillinger's appellate brief. There are some people that are just so good at what they do that even other people who are really smart are just like, oh my God, that human being is on another level. I don't understand how a brain can function like that. Now, Hank Brennan is on that level, and I think a lot of people get lost in the polemics of it, but Towell is able to appreciate what Hank Brennan is pulling off, specifically because Hank Brennan has, I think, postured Kierney and Reed and Turtle Boy into a mutually hostile position where they both have an incentive to cooperate against each other. Now, guess who's facing more prison time? I know Karen's facing 20 to life, but realistically, I think Karen's more likely to get convicted on OUI manslaughter or involuntary manslaughter or motor vehicle homicide while OUI. So, in light of that, guess who's facing more prison time? Aidan Kierney or Kierney and Reed? Actually, that's a good towel poll. We have a little bit of time left, so let me do a towel poll. Who will do more prison time? Your first choice is Aidan Kierney. Your second choice is Kierney and Reed. Your third choice is Chewbacca. I'm not sure if I know how to spell Chewbacca. This is not something that comes up very often in my life. I would have got that right. No, I would not have got that right. I would have definitely put an A where there... I would have got that right. Chewbacca. I don't know why Google thinks it's spelled Chewbacca. I don't know what Chewbacca is. All right. So we have a very important towel poll. Who do you think, who will do more prison time? Aidan Kierney, Kierney and Reed, or Chewbacca? All right, Kierney and Reed. I'm interested to see if anyone thinks Chewbacca's going to prison. None of you think Chewbacca did it. All right, there we go. Someone said they don't think either will serve prison time, but I'm not there yet in the comments. I'm sorry. We have a little bit more to go because I am committed to reading these comments. All right, so we're somewhat getting close to the end. I wouldn't say that. My King of Kings says, Turtle Boy wishes he could be half as intelligent as Grant is. Well, I wish I could be half as intelligent as Hank Brennan is. So there's always, the grass is always greener, I suppose. There's always somebody out there that somebody else is looking to. I envy lots of people. I try not to envy them, but I am in awe of lots of people's intelligences. I don't understand why people take so much pleasure from being the smartest person in the room or the most well-known person in the room. How the fuck are you ever supposed to get better at your life or improve or challenge yourself if you are constantly the smartest, most well-known, most popular, whatever the fuck person in the room? That is how you fucking plateau. If you really want to fucking improve, go be around and watch and engage with people and material that is far more intelligent than you will ever be. That's why it's a challenge for me to constantly have to look at documents for new words. If I can learn a new word from a document or from a YouTube chat, Oh my God, that is the best moment of my day, because it means I'm engaging with material or a mind that is more intelligent than my own. It is expanding one's lexicon at any cost, and finding a new word is just the best way to measure whether you're engaging with material that is challenging you. Speaking of which, while I'm rolling this blunt, I was thinking about whether I should do my list of the presidents. I felt a little bad the other day because I was doing my list of the presidents, and I actually got one of them wrong, and I insulted inadvertently Rutherford B. Hayes. And I feel terribly guilty about that. I'm not really sure why. I just thought a lot about it. So, in honor of Rutherford B. Hayes, I'd like to recite the list of the presidents, starting a little bit before Lincoln. I'm going to do it relatively quickly. We won't go on a digression this time about Woodrow Wilson, but I just want to redeem the honor of Rutherford B. Hayes. So let's start with, what is it? Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Chester A. Arthur, Garfield, Cleveland Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. What do you think? I think I did it. I think that was spot on. I got to work a little bit better. I'm trying to get back to Martin Van Buren and Andrew Jackson. It gets a little bit complicated during the bank wars. I can do the first 4 presidents, obviously, Washington, Adams, Jefferson, Madison, and then there's another Adams in there. But it gets a little convoluted between number 5 and number 11 for me in there. But I can get number 7 and 8. I think Polk was in there. James Polk had a very boring presidency, so it's really hard to remember what he was doing or why. And then somebody died after, that might have been later on. Somebody died very shortly after coming to office. And of course, McKinley was assassinated, which is the only reason Teddy Roosevelt became president, which really upset the American power structure. And probably that was the only reason the Sherman Antitrust Act of 1897 was enforced in the way it was. Are you all enjoying this random historical trip through American history? Sometimes you just have to list out all the American presidents in order as part of your project to memorize every Supreme Court justice ever and who appointed them and the political constellation of the Senate at the time. So you can understand Supreme Court opinions just by looking at the justice who wrote them. Let's see how our poll is doing. Who will do more time in jail? Right now, Kierney and Reed is leading the poll at 48% to 40%. Chewbacca is trailing at a deep third. This is not a good sign for Kierney and Reed's third-party culprit defense. We've determined that Kierney and Reed is left only with the Chewbacca defense. She has no one she can raise as a third-party culprit. But Chewbacca is not really a third-party culprit. Chewbacca is more of an Ewok from some strange planet whose name I can't remember right now. And if Karen gets up there and has David Yannetti say it was Chewbacca, then I think that will get Karen around Judge Cannoni's ruling related to not raising a third-party culprit defense. And if you're just joining, my name's GrantSmithEllis, and we're 6 hours into a stream where we started reading Kierney Reed's petition for a writ of certiorari to the Supreme Court, and then we somehow ended up on a number of tangents involving Chewbacca. That part I'm never going to get over. And now I'm reading through the rest of the comments. I also just did a list of the U.S. presidents in order because for some reason I'm awake a little bit past my bedtime, and I must have got some kind of second wind. Although I didn't have a coffee after, 4 or 5 p.m., so. Some people are saying the Turtle Boy fans wouldn't understand a word Grant said. I think they would understand some of the presidents. There were at least some names in there they would understand. Grant, you got the scoop. Yes. Oh, I do my best, Amber M. I don't know exactly what scoop it was. It wasn't me, though. No scoops really come from a reporter. We're just a reflection of ideally a reflection of the downtrodden or the voiceless who are otherwise silenced in these larger historical conflagrations of Joycean proportions that embody the Hegelian dialectic in very strange ways. But in other regards, it's more the people who experience it. We're just a medium. I like doing these streams to engage with you towel friends. That's why I center it so much around your comments and questions. But reporters aren't supposed to be the story. Now, Hunter S. Thompson would probably challenge that. If you read Fear and Loathing on the Campaign Trail in 72, fascinating campaign in hindsight. Imagine if Hunter S. Thompson were like standing outside the Watergate. What was that, June 6, 1972? Maybe June 12th, June 13th, somewhere in there. But anyway, other than new journalism, which Hunter S. Thompson pioneered with Fear and Loathing in that series, you really, as a journalist, aren't the story. I mean, maybe you become a voice in the story if strange things happen, but ideally you are not the story. So it's not really me. If anything, I think my only role here is kind of to amalgamate different perspectives and find kernels of truth within them in order to present the larger narrative in an authentic way. It's not me, though. I haven't done anything. I'm just a towel. It's the people who are actually living and experiencing this it's their authentic lived experiences that we should be heralding, even if they're very tormenting and tough to focus on. Like their ability to persevere, to go each day, to wake up each day, to live. That is the miracle here. And some of these people are just completely ignored in silence, but that is the real human sort of resilience on display. And I think a lot of people miss it. And I mean, I guess that's why I'm so grateful. Not to be able to tell the story, but to be able to see what others are missing and to appreciate the level of resilience that I see among, and it's not just in the context of this case and this reporting, but so many stories. The resilience of some of these individuals is just mind-blowing. It will change your world for the better. Let's see. Grant was the first I heard saying TB may be a CI, which makes so much sense. Yeah, you know, I think Turtle Boy gives information to state police, local police, maybe not so much state police anymore, but local police, feds maybe. I think Turtle Boy's information has, helped lots of people. Listen, Turtle Boy has bragged about getting January 6th rioters convicted due to his coverage. So, I don't think Turtle Boy's a Republican. And even you hear Turtle Boy saying things like, I'm not a bigot against gay and bi people. Well, he didn't actually say it directly that way. He was like, but I'm cool with people who are into that. Like he meant gay and bi people. But then he was like, but trans people. He didn't say it this way, but he was like, trans people, I don't know about them. And I was like, all right, no conservative would say it like that. And a liberal pretending to be a conservative, I guess, would say it that way. So I don't know. I think Turtle Boy's kind of like a moderate liberal. Like a moderate liberal. And for Massachusetts, he might look like a Republican, but I think that's why he's able to move in those circles. And I think he might have provided some really valuable information about some of those right-wing circles. That's my real theory. That, Turtle Boy, Rayla Campbell, Rachel Rollins, whatever, they were talking about the Markey Kennedy race, Joe Kennedy Jr. race, and that was important. But I think really Turtle Boy's value is just info on these, because, Mark Randazza, right, who's one of these lawyers for the buffer zone folks, if you look into Randazza, he used to represent, or I think it was him, yeah, I'm pretty sure, he was involved with this Boston Free Speech, Resist Marxism kind of group. And if you looked into some of them, right, and this right-wing or the group, they were Marx-a-handy or whatever the fuck. They were the ones who organized some of the buses down January 6th. So how fucking weird is it, right, that this group, Turtle Boy adjacent, I would say I actually have some information that that Turtle Boy and this group these January 6 people may have been in the same place at one time. I think it was in the lead up to January 6th, maybe a little bit after. It was right around that time. I want to say it was out in fucking. You see, you want to hear me talk with a Massachusetts accent. It was out in fucking Framingham or something, on a town green or something, and yeah, just Turtle Boy and these groups in the same place at the same time. This weird kind of right-wing circle, and then Turtle Boy like being pleased about getting the January 6th rioter convicted when that group, Shahandy and them, sent buses down to fucking D.C. on January 6th. No, too many coincidences. That world doesn't have coincidences, you know, and NSC 131 being adjacent to those fucking whatever the fuck rallies that the right-wing, I wouldn't even call them right-wing, but that resist Marxism, Boston free speech, whatever, they were the ones who threw the fucking straight pride parade. You don't think it's just a little bit weird that group was so adjacent to those very dangerous militant groups, and Turtle Boy's just kind of like hanging around? No, I don't think it's a coincidence. It's always the bullies and the arrogant that are the most scared. Oh, we're not going to. Remember when Turtle Boy showed his For You page on screen and it was all schlong? I remember Turtle Boy being like, that's what comes up when you click the, oh no, it wasn't a For You page. He clicked the For You hashtag from a Michael Phelps post, and when he clicked the hashtag, it was all porn. I remember that now. Towel is a sponge. He knows a lot about everything. Yeah, one time I was like, I took one of these transcripts and I put it in some kind of like interpreter, like one of the better AI interpreters, and I was like, can you take this transcript and tell me what you think of the person like speaking? You know, it's a YouTube transcript and they read questions because you have to give it some context. And I was like, can you tell me what you think of the person speaking? And the AI was like, this is a 6-hour transcript and humans should only be able to speak for 3 hours. And then it said, this is a polymathic individual who has expansive knowledge of history and seems to possess a photographic memory. Then I got a little bit scared, and I have this theme of Towel should not be allowed to talk to robots, and that's exactly why, because it starts saying things to me that just make Towel very uncomfortable. I feel like we're officially going to get to the point now where Towel friends on the other side of the world are either going to be awake past their bedtime themselves, or they're going to start waking up and be like, Grant, are you still going? It's 6 hours later. Grant, you connect the dots brilliantly. Oh, thank you. I try to paint historical mosaics with my syntactical precision, and I think I kind of am getting to the point where I'm speaking in iambic pentameter. So I'm going to combine the rhetorical flourish with the strokes of my towel blunt, painting that historical mosaic layered with citations and references and names, and it becomes almost like engaging with a James Joyce novel live. I suppose that's why some of you enjoy it, although it is an intellectual exercise. Oh, Mona Lisa Arizona says, I sent you $5, Grant. Get more pizza. I appreciate your time and KR coverage. Well, I would never promote anyone for donations or anything, but I'm promoting you because you have an appreciation for pizza. And anyone who has appreciation for pizza is an honorary towel. Amber Am says, can Hank get the evidence in? Yes, I don't know which evidence you're referring to, but I'll follow back on that. Aiden in Hebrew means little fire, not big fire that's difficult to put out. Little fire that goes out with one gentle little puff. I like Hebrew. I wish I spoke more Hebrew. I know like Shim and Gibble and Bet from Dreidel when I was playing Dreidel when I was growing up, but that's all I know. Holy crap! I went to a high school baseball game, had dinner, and you are still going. Tom Grist, it's so good to see you. I thoroughly enjoy your participation, and I'm so glad that you're back with us. Yeah, I mean, we spent a lot of time talking about Kierney and Reed's petition for a writ of certiorari to the U.S. Supreme Court. Then we went on a bit of a tangent about the Chewbacca defense. Then I started answering questions. Then I listed all the U.S. presidents. And, yeah, we've just had a great time. I think it's been about 6 hours now. But, you know, Towel is a dedicated Towel, and he does his best to help out and inform the wider polity and engender the standing of the layperson in the democratic process. And although not all of you are lay people, we are all lay towels here. And I'm not a lawyer, and none of this is legal advice. And I'm doing this just because I feel like it is important to inform you about goings-ons. And also because answering your questions makes me feel like a fulfilled towel. Hardest working towel on the internet. I'm the hardest working towel in America. That's a Mac Miller line. Let's see. Amazing, fertile mind. I suppose there is a lot in Towel's brain, and apparently I'm like the Energizer Bunny. I just get excited. Apparently people like sometimes when I giggle. Someone is a very big fan of the fact that I just randomly giggle sometimes. When do I think the trial will start, asked my King of Kings. I'm thinking end of next week. Probably more likely not this coming Monday, but the Monday after. So 4/14. I'd say between 4/11 and 4/14. If we start earlier than that, that would be impressive. But it also is dependent. There's a variable in there, an unknown how many jurors we actually need. We have 10. Judge Kierney might want 18. Judge Kierney might want 16 like that last time. Maybe she wants 20. I don't know. Let's see. She's been and will be silenced, Grant. Frustrating. Yeah, it is frustrating. But no voice is silenced forever, and human beings are resilient, and they will rise to the occasion. But Grant, will Hank want to sully Tully more than he is? Well, Hank Brennan is the type of person who I think weighs cost-benefit not from the perspective of what will be to the benefit of or detriment of a specific person, but what is in the interest of justice. So I don't think it's more, did Brian Tully do things that offend Hank Brennan's sense of justice? That's what I think will make the call on that. Maybe this falls under Mello. Some of the mistakes do intertwine. No, I don't think it was a mistake. I will tell you for a fact that Brian Tully handed over Lindsay Gattani's cell phone extraction, manipulated while in state police custody to remove only messages from Tully to Lindsay and from K. Peter to Lindsay to Aiden's lawyer. And it was unredacted, had 15 years of information, privileged family moments, etc., etc., etc. It was Brian Tully who did that. My King of Kings, Judge Kierney late next week or following week, but she's acting differently, so maybe Monday. Natalie is on the witness list. Natalie can be called and probably is being called. I hope attorney Elizabeth Little does opening and the new juror lawyer does all the testimony, and FKR are all like, girl power. And FKR are all like, girl power, but then they completely screw it up. Yeah, I feel like, okay, so Elizabeth Little is going to do some of the crosses. Probably like Katie McLaughlin. She'll do like 5 to 10 crosses. Jackson will do like 30, and Yannetti will do like 30. And I don't know what Alessi's going to fucking do. If I were them, I would not have Bob Alessi asking witnesses questions. Bob Alessi's a great motion lawyer. Bob Alessi's a great oral arguer. But I don't really understand the point of having Bob Alessi on that team ask any questions. Maybe like there are a few witnesses he wants to just flex on if he really thinks he has something to say. But on the whole, maybe they're going to use Alessi for opening. I wouldn't. Not because he's not a good lawyer, but because he doesn't have rhetorical flourish. And if you're going to go into an opening, especially because they're not going to use Yannetti, if you're going to go into a Kierney and Reed trial opening, it better be something like, as for the defense, it better be something like Alan Jackson. That's really your only option because you're very limited in what you can do. So let me give you an example. of a closing. I was doing a closing today, and I was channeling Jerry Spence a little bit. So let me give you an example of how you want to do, and I am a lay towel, and I'm not a lawyer, but let me give you an example of the kind of rhetorical flourish you want in an opening or a closing. You would want someone who could get up there, stand at the podium, and do something like this. Ladies and gentlemen of the jury, well, you'd say members of the jury, when we saw each other last during opening arguments, the defense laid out that the prosecution would not be able to do X, Y, and Z. And now, coming back full circle, I would say like a commodious vicus of recirculation, but I would get rhetorically slapped by my co-counsel and told not to do that. And now, coming back full circle, we stand here before you in the same place that we began. You, the jury, myself, co-counsel, and the defendant, asking, what has the state proven? Nothing. Not one single element of the charges. And here's why. That is how I would start it. And then you need someone who can close with something like this. Members of the jury, in very important cases, this is directly from Jerry Spence, but I love it. Members of the jury, in very important cases, my most important cases, I like to tell a story. Story about a smart aleck boy walking through the woods, and a bird lands gently in the palm of his hand. And the young boy looks off in the distance, and he sees the hut of an old man that he's walked by many times before. And the smart aleck boy says to himself, "Ha! I know. I'll play a trick on that old man. I'll walk up to the man's house with the bird in my hand." And the boy thinks to himself, I'll say to that man, the old man, "Hey, old man, the bird in my hand, is it alive or is it dead?" And the young man thinks to himself, if the old man says the bird is dead, I'll simply open my hand and the bird will fly away. But if the old man, if he says the bird is alive, then I'll take that bird and I'll crush it in my hand. And so the boy, he walks up to the old man and he says, "Hey, old man, I have in my hand this bird. Is it alive or is it dead?" And the old man took a second, looked back at the boy, and said, "My son, the bird is in your hands." And members of the jury, the fate of this defendant I place into your hands. A sacred trust. A trust that you can vindicate by way of a finding, the only finding that the evidence in this case demands. Not guilty on all charges. That's what you need for this case. You don't need an analytical mind. You need a rhetorical flourish for the opening and closing. Now, I just did an example closing, but that's the style you need for this case. You need to pull those jurors into this case. I didn't use any of the facts on purpose because I'm not giving anyone any ideas. I used a very broad. That was more about the intonation. But that's what you need for this case. That's what this case calls for, and Bob Alessi is not going to deliver that. Alan Jackson is going to deliver that. Hank Brennan is going to deliver that. Bob Alessi, I don't know where they're going to deploy him. Maybe on some crosses. Maybe he'll direct. I guess I could see him directing. So he would actually probably do good on direct, like a very methodical direct. Maybe there's some of these experts Alessi's going to direct. All right. I can't wait to get to the comments when I was doing my closing. I didn't realize this was Grant Squared. I'm a towel. Let's see. There are a number of open cases involving Aiden Kierney. There is, someone asked, what's the status of Aiden's cases with Lindsay or otherwise? Aiden has 18 felonies across 2 cases in the Superior Court for witness intimidation, wiretapping, conspiracy, picketing, and otherwise. Two of those indictments involve Lindsay. 16 of those indictments involve Karen Reed trial witnesses. Then there's 1 open case for Aiden in Dedham District Court related to an RO violation. And that case is open as well. Let's see. Was just thinking the same thing for opening. Little for opening and Alessi for closing. The Pilgrim Shadow, good job. I don't know. It must have been somebody catching somebody. But either way, there's no patience for whatever the mods caught. Good job. I'm dreading Alessi and Russell. Oh, yeah, I could see Alessi directing Dr. Russell. Logins. No, okay, we don't say mean things about people here, Logins. That's unnecessary. I hate to... how often have people made mistakes in their lives over who they either think they like or fall in love with or whatever? What the fuck? That's literally 90% of human existence, unless you're a towel. I hate to see her smirking and I hate to see Karen smirking and smiling in court when John's family is grieving, says South Philly. Yeah, that part I agree with. There are moments of levity in this case, of course, but the overwhelming tone is sadness, and Karen doesn't always reflect that in court. My King of Kings, Pilgrim Shadow says, my King of Kings, you're welcome. We need to keep this space pristine, let them go elsewhere. Yes, as I mentioned, there is a blue wall here, so we welcome all perspectives of all kinds, but you'll find that most people here are very tolerant. A lot of people are religious, so no discrimination, no derogatory language, no sea lioning. You can have your different perspectives all you want, but you disagree without being disagreeable, or one of the wall of towel friends or someone else is going to inevitably make sure you cannot engage in that subversive behavior. It's such poetic justice when the bad players turn on each other and eventually bring the others down. It is a form of catharsis. I agree with you, Kat. My King of Kings, if Karen tears up during trial on cue, I think we'll lose it, says Eva. Loggins says, when Alessi talks, I'm going to skip that part. Bob Alessi argues motions just fine. Action Jackson will be running the show like last time, and Little to use the female card. That's interesting, Amber M. I didn't think... So, Elizabeth Little, to me, it's not... I mean, I didn't think of it that way. Elizabeth Little is training as a lawyer. There's no doubt in my mind. I mean, this is not pejorative, but she is not as old as any of the people in that on that team. I'm not trying to insult her, but at first I was like, is she like 28, like 27? I'm not going to look up her age. I don't want to know her age. I don't care. I wouldn't ask a lady her age. I just, whatever. But I was like, she is the youngest person on that team. And she's learning how to be a lawyer. So I didn't think of it as much as, are they using her for the female aspect? I thought about it more if they're going to deploy her to help her learn and get trial experience. You cannot get that kind of fucking trial experience anywhere in the world. Maybe if you're in ADA somewhere randomly, but you can't get that trial experience. So they're putting her out there so she can learn, and she is learning. I think Elizabeth Little has grown as a lawyer over this trial. There's no doubt about that in my mind. Let's see. Love to hear Grant talk more about the Bohemian Grove another time. Yeah, we can do that. You should take a look at my Bohemian Grove reporting. Did you know I actually have one of the only clips inside the Bohemian Grove? I'm going to keep reading your comments, but I will take just 1 second to play this for you because I actually think this is quite rare. I don't know why it isn't more commonly shown, but I can show you inside a Bohemian Grove camp, and I can show you kind of how the other side lives, I guess. It's weird to think of it this way, but I think of it as just very kind of normal journalism to see this. But a lot of people have never seen inside the Bohemian Grove at all. So yeah, let me show you all this video, and I don't know, it's a little bit of a break from our regular material, but I'll get through the rest of your comments. But just let me know what you think of this video inside the Bohemian Grove. This is a video inside a camp called Sahara, which is tied to some quite powerful people. And I'm going to bring the full video up on the screen for you. I did not go into Bohemian Grove. I found this on another site, and I'm going to protect the source. But let's take a watch.
What does that say? I just want to get the fuck out of here.
There's just naked women pictured on the background. Like, I'm not sure why they have that naked woman pictured on the background. And then what's weird is I don't think they realize it, but see that black piece of writing right there? I analyze it in my picture to the left and right of the video. That's the fucking member list of the fucking club. And this is one of the camps within Bohemian Grove, but that has never seen the light of day before that fucking video. I emailed some very high profile reporters, and they were like, "Oh my God, Grant, how did you get this?" And I was like, I didn't put it up. I found it on social media. But that wasn't the impressive part. They were like, "Grant, how did you realize what that black board was?" And I was like, because it's clearly a fucking member list. I mean, it has like doctors. Oh, actually, I know how I figured it out. So do you see how it says LD on the side all the way to the left there on your screen? Some of the abbreviations are like LD, DR, whatever. LD, it means Lord, British Lord. So it's Lord Michael Dobbs who created the British version of House of Cards. And I was able to be like, what the fuck? Why is there a guy named Lord whatever in this? And then I was like, oh, that's the member list. And so that's how I was able to put it all together.
Look at all the owls. Holy shit. It's locked. It's locked.
They worship owls, by the way, if you're wondering why there's so many owls. Cool is that though? Do you see where they built? It's built in harmony with nature. So like we were just at the base floor of their clubhouse. Now look what happens. You walk around the corner. He's going to turn night vision on when he takes a right. But look, the whole camp. It's like a 5-story, 10-story edifice built in harmony with the fucking trees. They're walking up all of the different parts of it. The showers, the rooms. They're all just built into the trees. It's like a playground for the rich. get spooked. But yeah, so someone asked, what's the Bohemian Grove like? Well, that's probably the only footage you will ever see in your entire life inside the Bohemian Grove. All right, let me go back to the questions. I'm sure folks were like, wait, why is Grant 6 hours into a stream, and why are we watching footage from inside the Bohemian Grove, and why does Grant have footage from inside the Bohemian Grove? I sometimes think, actually, Murder by Maestro, that is how I found out about Dr. Donald Vinson, because his name was on that fucking list, and there can only be so many people who are in a fucking club like that. And Dr. Donald Vinson was in the Sahara Club. So there you go. This is a very special chat. Someone says, thank you, Grant. Love to hear your heartfelt thoughts. Oh, all of you are wonderful. It is a very special chat. Eva, I hope you have a great rest of your night. I know I'm way back in the chat, so I'm just getting caught up. I always am glad to provide thought-provoking content. My King of Kings says, Alessi is the old guy who talks about the dinosaurs in Miss Doubtfire. He puts the crew to sleep when he talks. Yeah, he still wins some motions. Yeah, no live stream from TB. Very interesting. Alessi is the geek in school who got stuffed. Oh, I don't know about that. Let's see. How much time do I think Karen will serve? 3 to 5. We'll do that. Actually, that's a good towel poll. Hold on. What's a good towel poll for this? How much time will Karen Reed serve in prison? Yeah. And let's see, 0 to, let's say 0, so we'll say 0 years, because that's got to be an option. 1 to 5, and then what's going to be, actually, let's start at 10. 1 to 5, 0 years. Actually, let's do 10 plus years. 1 to 5 years, 0 years. Okay. How much time will Karen Reed serve in prison? There you go. Whoever suggested that chat, you have been, you have put your options have been put up. We seem to be split between 10 years and 1 to 5 years. 10 years has taken a very strong early lead. You all can figure that out amongst yourself. All right. I got to scroll back up because I lost my place in the chat. Let's see. I'm not that far back in the chat, actually. That's good. Someone said, thank you, Monty. So thoughtful. Thank you, Monty. Whatever you said was very thoughtful. Let's see. How much time? Oh, right. I asked how much time will Karen serve? We need to get Towel a fan of fresh air to keep up the stamina. I think fresh air is fine, but Towel prefers burned flowers. If I could just breathe this all the time, I think that would be fine. I don't think Towel's lungs would like that. But Towel definitely is like 50% oxygen, 50% weed smoke. In fact, Towel was talking to a state cop the other day, and he was like, Grant, we are outside, and you still smell like weed. I was like, I'm a medical patient, Trooper. I needed to eat. And Trooper said, that's okay. We can accept that. And then the other troopers just started laughing. They were like, I think Grant's the first person in the world to defend his weed use to the sergeant. KR deleted the Ring camera footage. I agree. Someone else says, with all the donations, Karen's staying at the Omni and drinking top shelf liquor with Alan. Yeah, well, they're probably more likely to party tomorrow night than tonight. But I bet she does drink before bed. Karen probably doesn't know the difference between her lies and what really happened at this point. Well, yeah, if you're really good at what you do like that for someone like her, then you convince, the way you pass a lie detector or whatever the fuck, you just convince yourself of it. Like, you don't have to lie if you convince yourself of it. It's a lie, but you don't know what the truth is anymore. Logan says Karen's prancing around like a movie star. Yep. Murder by Maestro said the only good show in the past 20 years is Black Mirror. GrantSmithEllis fan says, Grant, you would love The Wire. Oh, yeah, I've watched every... Sorry, I need to rephrase this. I've watched every episode of The Wire. I've watched every episode of The Sopranos. I've watched some 24. But, yeah, of course I've watched every episode of The Wire. That is... It fell off a little bit, I think. After, like, the Brother Moves On storyline. After Prop Joe and Marlo Stanfield. Like, it got a little weird at the end. I like the Greek subplot. I thought that was a very good retelling. I listened to audiobooks about, like, the mafia, like, everything about the mafia. I really want to learn about how the FBI broke up this structure. So I know everything about, like, the fucking Philly mob and Nicky Scarfo, and I know a lot about, like, the Angelos and what happened around here, and I'm trying to understand just a little bit more, in particular, about The Wire, because The Wire had this great section about the Greek influence, the Greek mob influence near the ports, and that's a real story. There really was Greek competition with the Philly mob, and it caused a fucking war. It got really intense, and I think it's what it was kind of in the lead up to the Chicken Man's house getting, like, attacked or blown up or whatever the fuck, but that was the culmination of that whole crazy situation. So yeah, The Wire is a very interesting show. I know a lot about it, and the problem is I have a photographic memory, so everything that I watch, everything that I listen to, everything that I consume, everything that I hear, everything that I read, I retain forever. So I have to be careful, and that's also why I don't consume a lot of content. I know what I'm consuming is being imprinted in my brain forever. So I tactically only consume information that I think has a lot of probative value to the work that I'm doing. And yes, 10 years ago or whatever it was when I watched The Wire, I was watching it kind of just as a, recreational exercise. I would never do that now. But even the consequence of watching it as a recreational exercise is that I now have this whole segment of my brain that does not need to know about Marlo fucking Stanfield and Prop Joe and Method Man being cheese and all this other fucking extraneous information. And I never should have put it up there in the first place, but it's there. Logan says GrantSmithEllis is too funny. Oh, I do my best. Let's see. Amber Ann says Lori Vallow, Daybell, Trial, Grant, you're funny. Lori representing herself. Yeah, I followed a little bit. That woman is had some intense interactions with the judges. I try to consume as much content as possible. Like, I just can't stop. So, and I remember it all. So all I need to do is see one 30-second clip, and I'll forever have a face associated. I'll start to know the facts, and then it builds from there. Murder by Maestro said he'd love to know more about federal courts. Well, Murder by Maestro, it really all goes back to, Article 5 or Article 8, I think it's Article 8 of the U.S. Constitution. And we really need to talk about how Congress controlled the creation of all federal courts except for the Supreme Court. The Supreme Court's really the only court that's created, and its subsidiary courts, that's created in the Constitution. All of the other federal courts are created by statute. However, it is very interesting because the Judiciary Act of 1789 is actually what was interpreted by Mabry v. Madison by the court itself in 1802 or 1804, which had to do with a dispute between Thomas Jefferson and Adams, although it was actually by virtue of the appointment of James Madison as Secretary of, or Justice of the Peace or something. It had to do with the commission and whether the commission was valid under the Judiciary Act, or et cetera, et cetera. But it really, the federal courts are more than just their inherent constitutional powers and their legislative powers. The federal courts are actually a manifestation of the way in which the Supreme Court interpreted the Judiciary Act of 1789 by way of the case Marbury v. Madison to create a third independent, basically co-equal branch of the federal government. So, yeah, if you want to learn about the federal courts, I highly recommend a great book called The People's History of the Supreme Court by Peter Irons. If you listen to that book like 75 times and memorize it all, you'll never be one for discussion when talking with a constitutional law professor or a towel. Because then you can randomly be like, Towel, tell me about this case from the book. And I'll be like, oh, yes, I remember every single word of that page. I think it was page 13. It was like the other day when I wanted to look up the origin of the name of the state of Virginia, and I was like, I think it's on page like 12 of this 5,000 page book, and there it was on page 12. The Pilgrim Shadow, what shall I render unto the Lord of all the Lord has rendered unto me? Psalm 115:12, Dewey Reams translation. Thank you for that. That's a very nice quote. I appreciate you sharing that, the Pilgrim Shadow. Judge Middleton is great, says Murder by Maestro. You're a Judge Middleton fan? Why am I not surprised? Is that LV Judge Murder by Maestro? No, Judge Middleton is in Three Rivers County, Michigan. Las Vegas. LV means Vegas. Who's the... Oh, they were talking Lori Vallow, but LV more stereotypically means Vegas. Who's that other lower court guy all over YouTube who wears the bow tie? Oh, that's a guy out of Texas. He's a bit of a hard ass, but he's also really nice. Like, if you want, he's very big on the kind of thing where, like, if he sees a defendant, one time there was a defendant in front of him. The guy was, like, walking across the street or something, and the cops pat-frisked him and found weed in Texas, which is pretty serious. It was like an ounce, not packaged for sale. He would have been pissed at that. But it was just like an ounce of weed. And the guy didn't even say anything at the probable cause hearing. The fucking judge gets up and is like, cuts off the prosecutor and is like, wait a minute. This guy was walking across the street. He got like jaywalking as the underlying offense. This guy was walking across the street, and you went up to him and you searched his pockets and found weed. Weed? That the judge literally was like, just weed. And then you charged him. And then the cop was like, the prosecutor was like, yes, that's what the facts say. Then the judge was like, nope, this is walking while black, dismissed. Immediately. Didn't even debate it. Just scolded the prosecutor and was like, the police did this because this guy was walking across the street and he's black. Dismissed. And I was like, this judge is a fucking boss. The bow tie guy. But he's also a very hard-ass judge. Judge Flesher, yeah. When you touch a vulnerable person, you do anything while you're out on bail, you do anything stupid at all, like do not pass go, do not collect $200, you are going to jail. And I'm pretty sure he's in Texas because there's not too much due process in Texas, and a lot of people get really, really, really railed. And I don't know, that's justice in the frontier. I guess it's not really the frontier anymore. I don't think there are any frontiers, maybe in space. Either way, I wouldn't want to live in Texas. You can say all you want about no income tax or whatever. No, I don't want to live in Texas because the justice system, although I respect and have reverence for it, is fucking intense. Far more intense than... People complain about Massachusetts. I think people in the South are like, you guys have it good up there. Amber M says, thank you, Grant. Thank you, Amber M. Francis Fertel says, I watch way too much YouTube. Yeah, I can tell a lot of you watch a lot of YouTube because it shows me like the view duration and everything, and I'm like, wow, people really enjoy this content. Amber M says, I like watching YouTube. I also feel like it's hard. Like, it is actually hard. A lot of the streams that go this long are just like court hearings. Most YouTubers don't actually talk for 7 hours. Actually, you know what? We might actually break our record. I think this might be our first 7-hour stream. Well, that shows you what happened. I only needed one good night of rest, and I think I've been up since, I don't know, 3 a.m. this morning or so. So I only needed 1 or 2 good nights of rest or 18 hours off, and I was ready to do a 7-hour stream with you all. We're going to be doing 10-hour streams by the end of this trial because apparently my vocal cords are only getting stronger and stronger. We're going to have to start keeping track to see if there are actually YouTubers who do solo 7-hour streams that consist of reading court motions, talking, analyzing videos, and reading comments. I know there are some that get up there, but we're definitely getting to a point where I feel like we might be able to study this as some kind of example of the upper limits of the human vocal cords, in which case, that's wonderful. Maybe we could figure out how other people can adapt these tactics to be able to help engender cogent public discourse. Oh, Christina says I always eat trigger foods and I have stomach issues and I'm the same age, same size as Karen. You can't help what you like. Yep, that's very true, Christina. I also think sometimes I'm just so medicated that I'm like, oh, like I have to eat the same food all the time, or I would just eat what's around me, you know, and they are not good for my stomach. So yeah, like I eat cheese and bread all the time. One, because it's cheap and I don't want to spend a lot of money on food and I think it's gratuitous, but also because I know that's safe. Like I know I can eat cheese and bread 24 hours a day with some rice because I need a little sustenance in there. But I know I can eat that 24 hours a day. I will have energy. It is not going to bother my stomach. Now, what gets me in trouble is if I have like $20 in my pocket and I'm in a CVS and I'm like, oh, I should get that candy bar or something like that. That's what gets me in trouble. So I try to just eat my pizza in the morning before my day gets going, and then I'm normally fine. I don't eat a lot myself. I need to eat more. I eat maybe 1,200 to 1,500 calories a day. It's not good, but it's because I don't really enjoy eating. You know, I eat to live, and it's, I don't know. Some people like eating. I don't. I did when I was younger, not anymore. The Pilgrim Shadow, thanks for sharing the, Cat says, the Pilgrim Shadow, thanks for sharing the Bible verse. It's from Psalms 116.12. Following verse reads, I will take up the cup of salvation and call upon the name of the Lord, food for the soul. This is nice. See, I think a lot of people don't feel comfortable expressing their religious views or quoting the Bible, but Dell loves quoting the Bible, and I actually make posts on Sunday sometimes that are just quotes of scripture. So I'm very pleased that you all want to share your Bible verses. Yeah, information is power, says Deb Martell. Yes, I agree. Murder by Maestro. Grant, you are very gifted. If there is ever a bigger issue or picture you want to set your mind to, we are here for it. What is my larger tactical aim for the world? Well, I think the only thing that I really want to accomplish beyond this is to find a way to inspire people to look for the good in others, regardless as to the view they may have on an issue. So however we can find a way to just bring about a more agreeable, respectful, civic style of engagement on a human, political, socio-historical level, whatever it may be, I think that would make me happy. So I think my overarching aim is to affect the historical synthesis such as to facilitate the rise of a more compassionate cultural epoch. And to do that, I think it requires like crafting a very strong antithesis to the current thesis. The current thesis is very sort of anti-human and sort of very combative and drama-based. But I think if there's an antithesis that is authentic and defined by sort of the use of these skills and gifts in a benevolent way, not for money, and in a way that shows people that just because you have the ability to process all this information and play on these levels, that doesn't mean you have to fucking sell out or compromise your beliefs or become bitter or jaded or evil or anything like that. We can just be regular people who care about each other and have these skills and deploy them in the service of a wider collective good. Yeah, so I think that's what I want to figure out. How to deploy the emerging gifts of a new generation, potentially subject to biological adaptation to allow them to break free from previous bonds of temporal manipulation, and then harness those emerging talents in a cohesive way, not necessarily through structure, but more through teaching the people a spirit of the law that they will then bring into their daily lives. Not just written law, but moral law too. I think that's my overarching goal. I'm not really sure how I should go about that. I'm going to have to think about that some more. I think this is a good start, the conveying of information in this way, packaging it within the larger rhetorical moral framework that I'm trying to establish. But if you're talking about actually systematizing it, Murder by Maestro, I don't know if that's, I think it's resistant to codification. It's kind of like the episode of The West Wing where Larry Lessig, who's played by Christopher Lloyd Christopher Lloyd, is trying to teach the Belarusians how to develop their constitution. And Lessig, through Christopher Lloyd, says, you're not necessarily teaching someone how to write a constitution. The words need to evolve with time. You're teaching someone the spirit of the law itself. And so that's my larger systemic project, Murder by Maestro. I'd like to systematize the moral teachings and legal teachings that I believe undergird an asymptotic relationship to human perfectibility, and then package that in a way that self-replicates in a sui generis manner throughout the polity. So I don't know if you have any insights about how we should do that, but that's what I'd like to do. Kimmy Lovin Stuff says, the newly recovered 8 gigs of data from the telematics system in Karen's Lexus should tell a very interesting story. I agree with that. Let's see. It will indeed. It will be overlaid on a little map. Oh, yes, Murder by Maestro. I can't wait to see your map. Francis Frutel says, I had severe constant migraines for 18 years, and I never drank any alcohol till one night. I ended up in ER. It was a trip. I don't do alcohol. Grant's Cure helped me. Yes. I'm so sorry to hear you suffered for so long with that, Francis. I think alternative medications can be very helpful for especially persistent conditions. I definitely, if I had to be on prednisone tapers like every 6 months, I would not like my life. Those are horrible. And not just because I look like a chipmunk. I don't mind looking like a chipmunk. Let's see. And I'm really enjoying the quoting of scripture. Salaciousness versus facts, says Deb Martell. That's why we have fiction and nonfiction in the library. Online, the designation is fuzzy. Yeah, and it does make me wonder how we can deal with that. I think some of it ties back to Section 230 C2A of the Digital Millennium Copyright Act. Websites can lose their safe harbor for civil lawsuits and become liable for content published on their platform by users if they fail to take steps to adequately address copyright violations. I don't think we can do that with like the veracity of information, but we do need to think about how we're regulating these online spaces. And I think stripping platforms of their liability shield if they facilitate the promulgation of, I don't know how we would compare this, but the promulgation of some kind of copyright-like violations in other sectors. We can't do it with truth, and we shouldn't, because truth is not universal, at least as humans understand it. But I do think that it would be beneficial to think about those liability shields and stripping them from platforms, because online discourse is very dangerous right now. The worst sort of creators on YouTube are the ones who promulgate misinformation, made false narratives just for more views. Yeah, I agree with that. Do we think Aiden Kierney will do jail time? Potentially. Depends on if he cooperates with Karen. Melanie Little is... Oh, well, I'm not going to read that. Let's see. Turtle Boy, question mark, says Amber Ann. He's definitely getting prison time. It's all on videos unless he makes a deal. B. Nanch says, I don't know who that is, making bank being FKR. Yeah, I do sometimes wonder if it's a bit of an industry, a cottage industry, to be pro-free Karen Reed. And obviously I would never do this. It's not my style, but someone could have run an experiment and it would need to be very well regulated because it could be easily exploited. But you could easily run an experiment where you pretend to be free Karen Reed just to run the metrics, and I'm sure someone's already doing this. And then when you, like, after a month, be like, I pretended to be free Karen Reed, and in a month I made, this amount of money and got this amount of donations, and I wouldn't be surprised if people are already doing that. But that goes to show you the kind of mind Towel has. Like, most people would be like, Grant, that's a gold mine idea. You should do that. Like, not for the purposes of raising the money, but to do the study. I would just donate all the money to some foundation for deceased police officers or their families or whatever the fuck. But the point is just to write the analysis of, by becoming free Karen Reed, couldn't be me, obviously, because they'd be like, Grant, you are never going to be free Karen Reed. Shut up, Grant. But if you put someone out there and they built a channel around being pro free Karen Reed, how much could that person generate? What is the free Karen Reed industry? That's the big secret, and someone is going to do that. I'm sure someone's already doing it. They're going to expose this cottage industry that's being built, which encourages creators to be pro free Karen Reed in exchange for access to this insular network. But remember, they can't spread it too thin. So there's got to be some territorial kind of, we already have too many creators. Don't add more. It'll thin the pool, so I'm sure it's a very delicate dance. All right, unpopular opinion, says Kerry Gold, but I don't think TB will get prison time. The state won't want the negative press over him getting locked up. I think they're going to find a way to get a deal for Turtle Boy so he testifies against Karen. I do think the state wants to get Turtle Boy, not the state, but the powers that be, because Turtle Boy has done multiple bad things, but I think it's more important that they get Karen. That's what I think that's what I would be thinking. I would be thinking Karen is the big fish. Angela Whittick says, stop toweling them. I don't know who we're toweling. I was just being a towel. Oh, maybe that was the part when I was saying how I would be talking to regulatory agencies, and although I wouldn't say fuck you, my general demeanor is just generally, how dare you, fuck you. That's a towel for you. Everyone has a plan until they get a towel in their face. We're all towels now. You're a towel, and you're a towel, and you're a towel. I always wanted a big towel family. This is the greatest thing of all time. I am so pleased that you all are so wonderful to each other. I'm continuing to go because, one, I want to keep reading these comments, and two, I want to see if it's actually possible for me to reach a 7-hour stream. I don't think it should. I mean, I know some streamers do like 24-hour marathon streams for charity and all those great things. But I don't think it should be possible to have a streamer a single streamer with no guests, who does not interview people, who just talks and reads comments and questions for 7 hours on a regular basis. If you look at my streams, they were, we'd go like 3 hours. Then we were hitting 4. Then we were hitting 5, 6. Now we're hitting 7. I'm a little bit concerned at this point. At some point, am I just going to be sitting here 24 hours a day, never sleeping, and just reading court motions to you? I don't think that is very healthy for Towel. I don't think the human brain can do that. Although I did read an interesting study that when a man locked himself underground in a cave for it was a very long amount of time, his sleep schedule without the sun shifted to 36 hours awake, 12 hours asleep. So maybe that's an insight. Not sure what that... I don't think I should stay up for 24 to 36 hours constantly reading you all court motions, but the human body can do it. Maybe it has to be trapped in a cave and deprived of sunlight to do it, but it can do it. It does make you wonder, though, is our entire conception of time in this day-to-night cycle just dependent on our perception of light? So time is just completely irrelevant as soon as we take light away? That's not really looking good for people's conception of the day-to-day flow of life. So don't look into that study if you want to maintain your grasp on what time means. It wasn't really a study. It was more just a man who put himself down in a cave for 4 months to see what it would do. I think they eventually used those studies as the basis for banning solitary confinement in most of the developed world, which is maybe why I was looking into it. Kerry, just my opinion, they want to get TB dead to rights big time, no 60-day BS. Years is what I'm thinking, says B in Chance. You might be right. Murder by Maestro, his and her towels, and a white picket fence. That was a rude typo. Yeah, I knew it. I was like, wait a minute, is he punning? And then, no, white picket fence. Yeah, there's nothing more ideal than his and her towels and a white picket fence. An ideal life. Isn't that what we all want, in some sense? To just find somewhere where we can go home at the end of the day and for it to feel like home. You found your person when no matter where you are or when you're around them, it's just home. Like, home is actually the people that you are around. And home can be a person. And if you ever find that, cherish it greatly. It may not work out, but cherish it. It is a very special thing. And you'll know it too, because you shouldn't be able to be in this weird random surrounding and be like, I feel like home. But if you ever feel that way, it's because of the person or people around you. With Hank Brennan tying Turtle Boy's hands, it's delightful. Witness list, cannot report. I see that as writing on the wall. Yeah, I agree. White is almost a naughty word. Hey, Grant. Hello, Jesse Moore. Welcome. Did you see Matt from Boundless Millennial says you were hot? More power to him. I appreciate the accomplishment. The accomplishment. I was like, I guess it's an accomplishment to be labeled as hot. I'm more of an anthropomorphic towel, so I don't really think of my physical appearance. I'm more just like, oh, I'm a towel. But yes, I'm flattered. I'm flattered. Matt from Boundless Millennial has a crush on Towel. Listen, more power to him. I personally, I'm a little bit of just overwhelmed and confused by why people think Towel is, informative and helpful. And then you tell Towel that he's attractive. Well, now I'm just utterly perplexed. I just walk around all day. I don't really know what I look like, think about what I look like, care about what I look like. I have things to do. I have people to help and other things going on. So I'm just like, fuck it. And sometimes I get a little confused because I do think people look at me and they either know who I am or they're, and then I'm just kind of, why are you looking at me? And then just go about my day. A fluffy towel can become a harsh pad with too many monsters. Oh, I'm really far back in chat. We may make it to 6 hours after all, or 7 hours after all. I think you've probably realized at this point that I am just intent on proving that I can do a 7-hour stream. So there is no doubt in my mind I'm going to read all of these comments. A fluffy towel can become a harsh pad with too many monsters. That's a great saying, Murder by Maestro. How apropos. The only channel on YouTube that constantly pins things about towels. Let's see. Aiden, Bailey, you are, listen, you are entitled to have your opinion, but Aiden was bound over on charges of witness intimidation by a grand jury. We are not grand jurors. They made that decision, and then another jury will decide, unless Aiden takes some kind of deal or gets immunity, whether Aiden is guilty of those crimes as charged. But so far, he has been indicted and bound over on those charges to Superior Court. Facts, says Amber Am. Staring too far into the abyss can cause issues. Yep. Murder by Maestro. Bailey, don't be ridiculous. The rolling rally stopped outside 34 Fairview. There was nobody to ask questions to. Yeah, the rolling rally was a big basis of his indictment. How could it have been approved? They didn't even announce the route ahead of time, Bailey. Do you know what you're talking about? Shouting through a megaphone at the scene of a murder is not asking questions. Yeah, that's right. John O'Keefe's phone and GPS was never in the house. Yep, that's very true. Listen, Bailey, if you get to the point where the moderators are mad at you and then there's like 50 of them, you've probably run into a problem. Kerry Gold says, I don't think either Karen or Aiden will serve time. Interesting. Let's see. Angela Wittick says, I agree. Unless they can add more time of witness intimidation to Karen Reed is found guilty. Yeah, I could see another set of charges coming as well for conspiracy and witness intimidation. There's a lot of evidence. Kerry Gold says, I'm hoping Hank Brennan puts on a once-in-a-lifetime trial. I think Hank Brennan's been walking and exuding with that kind of confidence. Murder by Maestro said that he was very tempted to pick Chewbacca. Listen. Chewbacca is the only viable third-party culprit Karen Reed has left. Alan Jackson must embody his inner Johnny Cochran and must stand up there and say, ladies and gentlemen of the jury, it was Chewbacca. Yes, this is the highbrow legal analysis you come to this channel for from this lay towel who is not a lawyer and does not give legal advice. It is to hear about why Alan Jackson should use the Chewbacca defense. Someone once said in chat, Hank Brennan is playing chess and AJ and Karen Reed are playing checkers. So true. Yes, I saw that. I think it was yesterday morning. That was a good comment. Love it when Grant is cracking up, says Monty. Yes, apparently when Towel giggles, some people really find that funny. I appreciate it. Be more specific, Bailey, says Murder by Maestro, or you will bore us. It's so funny because anyone who comes in here to debate, they're like, all right, well, I know I can voice my opinion respectfully, but if I start trolling, there's 50 people here I have to deal with. It's the funniest dynamic on a YouTube channel. It is kind of interesting. It's almost like a bunch of towel protectors. They're like, you come in here and mess with towel or any of the towel people in the towel fold at your peril. The washcloths, the soap dispensers, and the flannels are all going to assemble. I feel like they made a movie about this. That movie about the vacuum cleaner. What was that movie called? I have to look that up now. Movie about a vacuum cleaner. There's only one movie about a vacuum cleaner. That was a cartoon. The Brave Little Toaster. It wasn't about a vacuum. Grant. Oh my god, it was about a toaster. First of all, that's hilarious. All right, I have to show you all this, okay? This is they can make a cartoon movie about this YouTube channel. All right? And when they do, I found the perfect inspiration for it. Ready? They can call it the Brave Little Towel. I got this mental image of all of us in our different anthropomorphic towel forms. Oh, goodness. I can't. The reason why this came up is somebody came into the YouTube chat and was trying to make their points, but they were treading so lightly. They had a contrarian opinion on Aiden Kierney to the flow of the chat. And then I realized that coming into this chat is probably one of the most interesting YouTube dynamics because it's like, it is this very strange pack of people who call themselves various forms of towels. And you have to deal with all of them when trying to chat. And they all can remove your comment. Therefore, I have decided this is us. We need to adapt it a little bit. So for our purposes, there's going to have to be a towel and a washcloth and a soap dispenser and a flannel and a beach towel and a towelette. I think what I find even more funny is there are people who inevitably are going to see this and be like, what the fuck have I stumbled onto? Oh, goodness. Well, you're helping me accomplish my goal, friends. I wanted to do a 7-hour stream, and we're going to pull it off. Kerry Gold says, Christina, I doubt they'll get an unbiased jury, so no conviction for Karen. Unfortunately, the state seems unwilling to go hard after Turtle Boy. Yeah, and you got to think of the politics, by the way. Michael Morrissey's up for re-election in 2026, so this is big. I mean, conviction now, or this becomes an election year issue. Fuck it, I'll run for Norfolk District Attorney. God, can you imagine that? First of all, no. Second of all, I think somehow that would make this ridiculous situation even more ridiculous, because I think people would be like, Towel is the one person who can go in there and clean up Norfolk County. And I'd be like, oh dear God, no. No, I cannot have roles that involve me not being able to speak publicly, because I am the type of person who will be like, okay, we are all anthropomorphic towels now. I'm also the kind of person who will stand on courthouse steps and flip people off. Because I'm a towel. Oh, let's see. Adam Lally had a 9-3 guilty count on count 2. Hank Brennan's absolutely got better chances of getting conviction. Absolutely, I agree. Christina says Bailey likes to poke the bear and stir the pot, just a fly on the wall. I like Christina. Maybe one day eventually you will earn your towel stripes, but I love how you knew immediately in the moment you were like, oh no, I'm never going to be an honorary towel now. I did find that funny. What about President Calvin? That was Calvin Coolidge, Harding Coolidge Hoover. I said him in there. He was in the 20s. He was, I think it was Harding who died of like a cold or something after like 8 months. So Calvin Coolidge came in, and Hoover was afterwards. Hoover was the one that was the real problem with the Great Depression, leading up to the Great Depression, although we can really blame Wilson and Nelson Aldrich for that. But we're not going down another rabbit hole about how the Federal Reserve started after the Jekyll Island meeting in 1912. We don't need to go down that hole or talk about why Justice Brandeis was an apology from Wilson to the progressives. And by the way, I got something wrong the other day. The 1912 election was between William Howard Taft, Teddy Roosevelt, and Woodrow Wilson. Now, Williams Jennings Bryan did run in the election of 1908 and split the vote, I think, with Teddy Roosevelt, and then allowed William Howard Taft to run. But why 1912, the reason why the progressive vote was split in 1912 was that William Howard Taft ran against Teddy Roosevelt. Now, what's fascinating is Teddy Roosevelt, when he was president, Taft was his ambassador, I think, to the Philippines. And Taft eventually got recalled. It was a big fight, actually, between Roosevelt and Taft. Taft got recalled back to run the War Department, I want to say. It was the old Defense Department. It was called the War Department. Got called back to run the War Department, I want to say because Teddy Roosevelt wanted to invade Havana or something in 1906. But anyway, William Howard Taft gets called back from the Philippines, and he's kind of upset at Teddy Roosevelt. And William Howard Taft really wanted to be a Supreme Court justice, like the Chief Justice of the Supreme Court. And I think he eventually became did become the Chief Justice, the only person to ever to be President and Chief Justice of the Supreme Court. That was a guy who really liked titles. Very smart guy, though. But either way, William Howard Taft, Teddy Roosevelt won't select him for the open seat on the Supreme Court, and William Howard Taft gets really pissed off, and they end up having a falling out, and then William Howard Taft runs in 1908. Now remember, Teddy Roosevelt, McKinley got shot in 1901 up in Buffalo by an anarchist. So Teddy Roosevelt only actually got elected once in 1904. And so he was able to run again in 1908. He would have, and there was no amendment preventing 3 terms, but there was a custom. So he was saying at the time it was perfectly fine for him to run in 1908. He was saying it was perfectly fine for him to run for a 3rd term, but not in 1908. So he had William Howard Taft kind of run as his deputy, and the plan was that Roosevelt would come back in 1912 or something. So anyway, that they have the falling out. Roosevelt and Taft split the vote in 1912, and then Wilson wins, becomes a bit of a warmonger, starts the Federal Reserve with Nelson Aldrich's help, which was actually the 3rd central bank of the U.S. Wilson feels guilty about it and then appoints Justice Brandeis as a progressive to apologize. All right. I don't know how that started. Chewbacca was my dog's name. He was a Sheltie. Oh, Cat. God bless Chewbacca. It's personal for Hank Brennan is the vibe I get. Yeah, I think he really believes Karen Reed did this, and he really believes Karen Reed is responsible for the torment to the witnesses. Kat says 6 hours. Yep, we're about to get to 7 hours. I set myself to do it, and hopefully if the timing works out, I will be coming up on the end of the comments right as we get to the 7-hour mark. And I must say, I did not think a 7-hour stream was going to happen. I was tired when we started, but you all, Towel friends, so invigorate Towel and keep me discussing and chatting, and you have so many interesting questions, all of which lead to these fascinating rabbit holes that we sometimes explore. We've explored the Bohemian Grove tonight. We've gone all over the place. Someone said, so true. Oh, hold on, I skipped a little bit. No. Someone said, so true. I'd like to think Hank Brennan, knowing ahead of time that defense is willing to cross ethical boundaries to win, might be beneficial for him. Yeah, Hank Brennan really didn't like the ethical boundaries crossed in the Bolger trial by his client or by the federal government, and I don't think he liked them crossed here by the defense either. Monty says, great story, standing ovation. Oh, was this when I did the cross? Oh, I was so excited to read these comments. Angela Whittick says, clap, clap, clap. Oh, thank you. Macy says, well done. Kat really liked it. Deb Martell says, that was moving. Hold on, I'm going to scroll back up. Hold on. I was really enjoying those comments. Hold on. I'll be able to find them because they were just people clapping. Oh, here we go. That was moving for real, says Deb Martell. I'm so glad you all liked my speech. I can't wait to watch it back and read your comments in real time. I don't remember exactly what I said. It was something about a bird. Oh, yes, the old man and the bird. Really, I'm grateful you all liked it. Without the arc, I interpolated it from a great orator, Jerry Spence. He's a great teacher of how to give legal arguments, and not a lot of people have seen the videos. They're from like the 60s and 70s, but on a future stream we will definitely take the opportunity to watch Jerry Spence deliver that argument, because I think it is just absolutely beautiful to watch. And as we get closer to opening arguments, maybe that's what we'll do. We'll watch some really good examples of through history. They're very obscure, of what I think are really good opening and closing arguments, and how they're delivered and why they're so good. Let's see. So the who will do more prison time vote came out. Karen Reed 56%, Aiden Kierney 30%, Chewbacca 12%. Well, Chewbacca's gonna make it out all right. Second degree is a minimum of 15 years. I'm all on Hank Brennan to win this one, says Holy Ralph Amelie Empire. I like that name. The Pilgrim Shadow says, I think it will be another mistrial, unfortunately. We'll see. Alex says, oh, hi, Alex. Good to see you. Alex says, Holy Roman Empire, agree with you. The Pilgrim Shadow says, Alex, I also fear AJDY will have an FKR plant who will lie their way onto the jury. That's scary. Francis Fertel says, weed equals truth serum. Yes, and being a towel is a truth serum. Sarah Boone got life on second degree. Yep, that is possible. Albanian Mom is interesting to me, says Holy Ralph Male Empire, because their code of ethics goes back to medieval times. Yeah, I think a lot of these secret societies have codes of ethics that go back to places none of us can really understand. I mean, there is esoteric knowledge. You can look at OTO or Asiatic Brethren or any number of German movements from the 1700s, 1800s, and you can see that's not their knowledge. They're definitely just tapping into something that's been passed down for a very, very long time. And by the way, you really think stonemasons, Freemasons are fucking stonemasons? No, a long time ago, Freemasonry bifurcated between the people who actually like build things and then this like knowledge-based cult. And so I think a lot of these secret societies, mafia-based or or otherwise, are rooted in this passing down of sacred knowledge, which most people are not told. There's this whole understanding, there's this whole parallel world out there about all this knowledge that's passed down that I don't think any of us really get exposed to. I think it might have to do something with kind of like geometry and the way patterns appear in the universe based on numbers and sort of symbols and things like that. And then I also think it has something to do with sort of the origin story of sort of humans, and obviously we go back a very long time and how that happened. I just think there's a lot of knowledge, and I'm not saying that is the factual record of how it happened. I'm saying I think there's just these oral traditions that are closely guarded, that are passed down, and that's what a lot of these secret societies really reflect. It's a modern version of it, and mind you, anything you're hearing about in public is not doing a very good job of being a fucking secret society. So the real power, you do not know their names. Who owns the Empire State Building? It's one guy. Did you know that? One guy. I think his wife comes from Belco money. But one guy owns the Empire State Building. Tony Malkin. Malkin. You can look it up. One guy. But do you know his fucking name? You see him out there in fucking on TV, Hollywood Squares, whatever the fuck people watch these days? No, and you never will, because real power hides in plain sight. But it is interesting to see how some of these organizations adapt and transmute some of those sacred sort of initiation rites and hidden knowledge. Grant, you're like Cory Booker. You're like the Cory Booker of YouTube. That's a great reference. Cory Booker just did broke Strom Thurmond's record for the longest speech delivered on the Senate floor. I think it was 24 hours and 17 minutes was the previous record. Let's find out how long Cory Booker went. Cory Booker, new record time. What's the actual length that he went? 25 hours. Congratulations, Senator Booker. And the real reason he did that, it wasn't just a procedural filibuster. I hope you folks know you don't need to actually talk to filibuster anymore. You just submit a piece of paper. The reason Booker gave that speech was so that now when people reference the longest speech ever on the Senate floor, they don't have to talk about Strom Thurmond's futile attempt to filibuster the Civil Rights Act of 1964 for 24 hours and 17 minutes. Now they will talk about Cory Booker. And that's exactly what they should do, because Strom Thurmond's filibuster was bullshit. Just downloaded the book on Audible, but no high hopes to listen to 500 pages and be able to converse afterwards with law professors, though. Oh, no, if you listen to A People's History of the Supreme Court, which I have listened to 50 times, I love that book, you will become the most erudite towel in the entire world when it comes to discussing those decisions. We can have a book club where we just talk about, we can just listen to that book. I bet I could. If Professor Irons is still alive, I might be able to find one of his assistants. I will email him and I will say, Professor Irons, I would like to take your 500-page audiobook and I would like to play it for my YouTube audience so we can explicate it, every single word, every single sentence. I am sure he'd be like, I am thrilled that you want to do that, Grant. I think he'd probably be like, I saw your channel, though, and you seem to have a lot of people who refer to themselves as a towel, and I'm a little bit concerned that you might think you're an anthropomorphic towel. And I'd be like, yes, Professor, but that is a bit of an aside from the main point, which is I would like permission to use your text for academic purposes to teach my audience about Supreme Court decisions. And I'm pretty sure he or his assistant or whoever controls his publishing would be like, I'm thrilled you want to do that. All right. So we're over the 7-hour mark now, by the way. I did it. I accomplished my goal. I said I was going to stream for 7 hours. I'm not going to stop answering your questions, but by God, I did it. I'm thrilled you downloaded that book, by the way, Kat. That makes me the happiest person of all time. And Deb Martell, for comparing me to the Honorable Senator Booker, you are an official towel. And it's just a towel celebration today. The Tao of Towel, the Tao of Towel. I like that one, Sunken Grave, TAU of Towel. What an awesome live. B Rabbit, I'm so glad you've been here. It's been an awesome time. We've been having a great time talking. Chris says the Chewbacca defense. Have you seen these claws and teeth? Towel for DA. Blue Towel Brigade, Grant for DA. Welcome to Towel Sanctuary, where you can feel washed, dried, and folded. Don't mess with our towels. Francis Patel, I love it. Thanks for the live. Epic. Law Review, I'm so glad you've been here. We did it. We made it 7 hours. I think I have promoted all of the all of the towel friends, and there will be more towel friends to be promoted in time, I have no doubt. And friends at this 11:15 p.m. hour on the east coast of Massachusetts, as I like to say, if it's December 1941 in Casablanca, what time is it in New York? They're probably asleep in New York. They're probably asleep all over America. And this towel, too, shall soon be asleep, and I hope you, towel friends, also will soon be asleep. We had a wonderful time talking tonight. I was honored to join you as well. I do want to, hold on, one thing I will do is I'm going to do one thing before we sign out. People's history of the Supreme Court. I really want to, I can't post a link in the chat, but I can post the title of it, because I am so thrilled that someone someone went and found this book on Audible. I think that was Kat. I'm absolutely thrilled. So I actually went and pasted the title for you all. I hope you all have an absolutely amazing rest of your night. Very rarely do I cut off my wonderful outro there, but I thought Kat's ability to locate this book on Audible was prescient, and so I've now pasted the title for you all in the YouTube chat. Thank you so much to everyone who tuned in. Thank you to all the towel friends. You saw quite an experiment in towel history today with this 7-hour stream. We learned a lot. We read Kierney and Reed Supreme Court petition for certiorari. We talked about all the presidents going back to Franklin Pierce. We then talked a little bit about any number of topics. You all asked excellent questions, and we defended the towel folds and the fabric of the universe from interlopers. So, all right. With all that said, I also want to do one more thing, because I always forget to look down. And I think that some of you towel friends, although I said I'm doing my best to do okay, you were kind enough to send them some donations, and I just want to say God bless you and thank you for that. I'll try to click the heart or leave a comment on them on the Venmo or the Cashapp. But truly, God bless you all. It means so much to me that you've been here. Enjoy the rest of your night, everyone. Please be well. It is Thursday. We'll see you tomorrow. Enjoy the rest of your night. My name's GrantSmithEllis. Good night.